Hi, good morning, everyone. Let's see how today goes for little brave Darrell. I'm not sure it's going to get any better, but um, can't get worse. Can't get worse. I mean, actually, it can get a lot worse, and I have a feeling it's going to get a lot worse for Darrell, given his brilliant legal skills so far in calling witnesses that do not support his case. There's our boy. Well, me or Darrell, I'm not sure which one you're talking about, but here comes the boy. Let's see here. What are we looking for? I am looking for this to get set up. Everybody's coming on in. Yeah, good morning, everybody. Okay. Sorry, guys. I got to get some of this thing switched over and properly set up. Do. So I'm gonna put a poll up in chat just out of curiosity. How bad do you think Daryl's gonna do today? Because I think it's gonna be awful. Let's get this poll up here. And so there you guys got left you a option in poll. Take a why does this thing not work? There we go. Gosh, this poll sucks so bad today. Just wanted to make one, but now it won't work. Oh, hold on, I gotta fix something. There we go. Fix that. I'll turn it around. First. There we go. There you go, guys. Just let me know what you guys think is going to happen. Polls up now. How do you think he'll do today? He'll turn it around. It's going to get worse, or what the business? What the business? That's always important to know, guys. What the business? What the business? No, it's too early in the morning. I am not going to play his rap videos. It is too early in the day. Also, somebody copyright noticed me on those. So apparently, it's serious business out in the rap game to play someone's videos. Good morning, everyone. Though, holy cow, we've got people everywhere. uh, yes, and I know yesterday was interesting. I think it's only going to get worse for Darrell personally. I don't see how he fixes this. I mean, really, there's no way for him to fix this at all. How many maps does A-Dubs? Yes, how many pedophiles does he call to the stand today? I don't know. A couple, maybe. It's not going to go well for him. Just a map on the wall says, "My head hurts. Listening to this man should help." Oh yes, let him soothe you with his comforting sounds. Better than any sort of ocean CD. Dee-doo. No. What the business? Let me ask you. Is it substantiated?
For my client, I accept for value in return for
here we go.
my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and I would like to make a reservation of all my rights at this time.
That's nice.
I thank you. The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie, and he is wearing a mask.
And I do not consent to being called that man, for the record.
Noted. All right. So Mr. Brooks called a witness yesterday. There was an objection. I sustained it, but he also orally moved to dismiss, and I indicated I would take that up outside the presence of the jury. I didn't do that yesterday, so I just want to put on the record that I'm denying the motion without any further consideration or discussion by the parties.
That's really good news, Jim.
He listed
No,
two
I did not know.
reasons. One was it had to do when he called the state of Wisconsin as a witness for failing to appear, and then for failing to state a claim upon which relief can be granted. There's no legal basis for those motions in law or in fact, and so that's why I'm denying them on the record today. I'm not asking for any further commentary or statements on the issue.
I object to that.
And I intend to have you call the next witness. I just want to confirm with the state who is here this morning.
I object to that ruling, Your Honor.
Noted for the record.
Present this morning, Your Honor.
I would like legal finding of fact.
Tonight.
Your Honor, consistent with the court's instruction yesterday afternoon, we have present Douglas Kohler, Detective Steve Guth, and Erica Patterson are here now and available.
Ooh, she's going up this morning.
All right. I expect you to call those first three before we get to any other person. Not whatever order you want among the three, but those will be the three people called, and then we'll get to the next people according to the scheduling that I put in place yesterday.
I want to state for the record that I intend to appeal that judicial decision made about the motion to dismiss.
Noted for the record. All right, let's bring the jury out then.
Actually, we did address subject matter jurisdiction. It still has yet to be proven, for the record.
Good Lord.
I wanted to address the fact that with this, is it Kohler? Is that how you pronounce the name? Kohler?
We're going to continue with the witnesses. Witness.
I'm still having trouble finding the file for that particular witness.
Yeah, call the jury in.
So I don't know.
Yeah,
how
sorry
I'm
guys,
supposed
gotta
to
switch over.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those three, whatever order you want, but I'm not moving past those three
I didn't say anything about moving past the three.
I know that. I'm just setting the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find the
I understand,
paperwork.
But that's you not having your paperwork's on you, not anybody else.
So what am I supposed to ask him?
I can't answer that, sir. You know that.
That's a rush to judgment. You can't rush me to judgment when I'm notifying the court that I cannot find the record.
That is not a rush to
I
judgment.
can't find the file for that. I'm saying that particular witness.
I'll make a record. Yesterday you.
That's a you problem. That's a you problem.
Hold on a second.
That's not an us problem.
Just a second. Yesterday, you said you did not have a file for one of the witnesses, and you did a fine job from my perspective. So
I did what?
You did a fine job. I just want to say my assessment.
They also
you did
provided
a good
me
job.
with one sheet for that particular witness at that time. Okay. So I just went off of that 3 paragraphs.
How you're prepared or not is solely on you, sir. You've had all of this information. Now we're at the end of the 3rd week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How
We're not
can I
gonna
be
hold it
prepared
up.
for? I'm not. So the witness is just supposed to get up there and just. I'm just
No,
like,
I'm
yeah.
not gonna have this commentary, okay? I'm done.
Actually, yes.
The jury's
Yes,
coming out.
you-
Be
this is
prepared
how it
to
So
works,
watch
Darrell.
that's a
this.
rush to judgment.
That is
No, it's
not a
not.
rush to judgment.
It is a
Again,
rush to
I'm done.
judgment.
You got to call your
It's
pants
clearly a
down.
rush to judgment.
happens,
if I'm
bro.
telling you that I don't have the
No,
file,
in
How am
my
I
opinion,
supposed-
you're attempting to delay. So
no,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself?
Man, it happens.
You're always trying to pull some fast maneuvers.
Mr. Brooks,
And Miss Judge, Your Honor,
Mr.
Ooh.
Brooks, the jury's coming in.
yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
Here we
still
go.
had another one that didn't have nothing to do with nothing
Here
we
we
just
go.
talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important, that hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this
like
is
the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I can't
parties. The
even
jury
present
will
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these
Which
statements
is a
made
rush
by
to
Mr.
judgment.
Brooks
That's
at
Let's go,
this
Darrell.
time.
Go.
Right.
Get the high
That's
score,
unfair
man.
what
The
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get to before
And you
rush
may call your
everything
next
out.
witness, sir.
I'm not calling any witness until I get an answer, Your Honor. You're a public servant. You're
Mr. Brooks,
supposed to be able to answer simple questions.
Mr. Brooks,
If I'm saying I have to bring
call
it to
your
your
next witness,
attention,
please. That's the stage
I
that
have
we
to
are
bring
at.
it to your
This is
attention, Your Honor.
beautiful.
Mr. Brooks,
I'm merely seeking
please
to bring
stop.
an issue to your attention.
I'm telling you to please, I'm asking you to please
and I'm
stop
asking you,
because
can
we have the
address?
jury present
I'm asking
and
you.
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will
there
do
was
that
a
at the
legal
next
matter.
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
For the
yourself
third
are on
time,
notice.
I will address it at the next break. Call your next
Oh my
witness,
God.
please.
Are you asking me?
I'm
She's
directing you to call your
telling
next
you.
witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right
My
here.
oath? My
The
oath?
oath that you took, Your Honor.
Is it
Mr.
like
Brooks, I'd
oath
like
meal?
to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr.
So
Brooks,
you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath.
Mr. Brooks, call your next
As you
witness.
notify the jury every time when there's legal matters, we take them outside of their presence.
And we're going
I
to take
didn't-
testimony right now. Call your
I
next
merely
witness.
seek to put you on notice on the record for something that needs to be brought to your attention
And
and
I
to the
will-
court's attention.
And I will address it at
That's
the
what
next
I'm
break.
really seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next
God.
witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks.
judicial determination.
Call your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's no rush to judgment
There
here,
is a rush
sir.
to judgment. If you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor. You're a public
Mr.
servant.
Brooks,
Are you not a
it is
public servant?
9:37. Call
It is
your,
8:37.
sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next
That's
We
witness.
not a
had
rush to
legal
judgment.
matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
Telling you
at
I'm
the
denying
onset-
your request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call,
can you deny
please-
something that we're supposed to do before
Mr.
the jury
Brooks.
even comes out?
call your
I'm
witness.
not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every
is
day.
in the courtroom waiting for you. Please call your
Your
next
Honor, we do
witness.
this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified of
Put it
things
in
that need to
writing,
be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do
You can
both?
take a minute
This
to
is the
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to,
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to
Yes,
judgment.
guys, the jury is
Are
sitting
you
in the
not a
courtroom right
public
now
servant,
listening
Your
to
Honor?
this.
Mr. Brooks,
Do I not have your oath of office?
under
Three of them.
90611, this court has the authority, as you
Do I
know,
not have,
Call-
is this not a copy, or I asked for certified copies that you said on record that you would not provide for no good reason, that these are three
sir,
of your
you are
oaths.
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here.
You're
You're
doing-
doing this.
Listen, Your
We
Honor,
need to go
I'm not
forward.
attempting to delay the proceedings.
Yes,
I'm
you
not
are.
attempting to be disruptive. I'm merely trying to notify
Giving
Your
it a
Honor
business.
in the court for the record beforehand.
Oh, my God.
That way, everyone's at least on notice of the issues that need to be taken up, instead of waiting until a break or a lunch and things of that nature, which
In
kills
my
valuable
discretion,
time.
it's my authority. It's the courtroom that I'm
Your Honor.
presiding over. I'm not going to address
Is
that
this-
at this
is-
moment.
is this not
90611,
your
I'm
let's
oath?
not
go.
going to
Crush
Did
answer
you not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks.
Actually,
States
it's Illinois v. Allen
Call
Did you not do
territory.
that?
your
3
witness.
times? I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
We are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor. And I object
I'm
to
aware
that.
of 3 witnesses
I
who are
object-
here.
I object
Call
to
one
that.
of them, please.
Your Honor, I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take
That's-
exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these
Go
things
file
need
it.
to be stayed until this matter is before a adjudicated court of competent jurisdiction.
And adjudicated?
Because we have not proven jurisdiction in this court as of yet. Subject matter
Adjudicated?
jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of the
Mr.
charges
Brooks,
against me. I don't even understand that part
I
of it.
understand
haven't
your
been
request.
provided a
Oh,
complaint.
Jesus.
haven't- Your Honor, there's so many issues.
Mr.
and
Brooks,
I'm not
we will
attempting,
take,
I'm not attempting to
Mr.
be
Brooks,
disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the proceedings
Your
in any
requests
way.
are denied.
Your Honor, I
And I'm going to
respectfully
instruct the
object
jury
that.
at this point to
I
disregard
respectfully
and not
object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's
With that,
it's a rush to judgment
Mr. Brooks,
because, Your Honor, I just showed your oath that you swore to took. You swore you
Mr.
did
Brooks,
this, Your Honor.
please call your next witness.
You took these oath of offices. You did, Your Honor, 3 of them.
I understand my
Which
oath,
is
sir,
very,
very
very
well.
commendable that that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths. That
All right, I'm going to have
took,
to
Your Honor.
excuse the jury since Mr. Brooks
You
is
have
not
to-
calling his witness.
you
We'll
have to-
hopefully
you have
bring
to-
you back out shortly.
You have to
All right.
honor these oath of offices. You have to, as a public servant, Your Honor. I respect you being a public servant.
Oh, yeah, I'm sure you respect her a lot.
And this is not to take a shot at you in any way, but these
Mr.
issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. They need
I'm
to be.
excusing the jury. Can you please stop?
Your Honor, this is a rush to
Yes,
judgment.
swore to took.
This is a clear bias.
Mr. Brooks, you are to stop
It's a
talking.
biased.
Are you asking me?
I'm advising you, or you will forfeit your right to be present at this
So you're holding
courtroom
me
for
in
the
contempt?
questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm
can you do
advising you
that?
at this moment to
Rush
call
to
your
that
next
butt.
witness, or you will forfeit the right to call these witnesses.
You can't take my
Under
Sixth Amendment
906.11,
right.
you are
cannot-
refusing
cannot-
to
Mm,
call
I-
a
I
witness.
didn't
Again.
refuse anything, Your Honor. And you
He's
can't
blatantly
you
refusing
can't
it.
deny me my Sixth Amendment right, which is
Mr.
to
Brooks,
call
do you want to
witnesses,
be present in
which is to
this
subpoena
courtroom
witnesses.
while you question your first witness? Because it is now 8:44 and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you
This-
believe the
This
law
didn't have anything
is.
to do with the jury,
Subject
Your Honor.
matter that is what you referenced in front of the
I
jury, and
referenced
then you
that
referenced
after I
my
had
oath.
raised the issues that I was trying
Subject
to
matter
raise.
jurisdiction, as you know, is not
As I don't
something
know.
the state has to be, the
It
state
has
must
to be
prove.
proven. It has to be. And
You
if
are
it doesn't,
frankly
show me
confusing
lawful law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction in the state of
You don't
Wisconsin.
have criminal.
That
you
has
don't
been
even
made
have.
abundantly
You don't
clear.
have subject matter jurisdiction or personal jurisdiction.
Mr. Brooks,
Or personnel jurisdiction. You don't. You haven't proven.
you have not,
You
I
haven't proven
excuse
for the
the
record.
jury.
Give her the
I'll
business,
give you the
Darrell. Give it to
opportunity
her.
to raise whatever
Yeah.
issue it was, but you need to do it now or we're moving forward.
That's what I want to do. That's what I was
So-
attempting to do.
And if you interrupt me one more time, you're going to go do it from the other courtroom.
And
Because
so
you're
holding
being,
me in contempt.
all right. He can go to the other courtroom and we will address these issues because
holding
you
me in
are
contempt?
not being respectful. You are disruptive. You are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes because of your nonstop commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said
Okay.
you have a legal issue you want to raise before we get going. What is that issue?
Okay. The legal issue is this. Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that showed the backyard of my mother's home, which he stated that he had been to the home, had seen the backyard, all this stuff, when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
Because
fine.
she's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to be
away,
addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break. All right, so
Would I be?
you're
because
putting,
I had-
you're asking me to add Dawn Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena for whom?
for my mother. But I would also like to subpoena the phone records so it can be made part of the record of the conversation, since the prosecution listens to all the phone calls. They should be able to have heard that phone call as well. So they should be on notice of what was said.
I don't know what phone call you're referring to. If
I'm
you're
referring
referring
to
to
a
a
phone
jail
call
phone
from-
call,
I'm referring
Then-
to a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m., which I'm sure the prosecution has heard by now. And that also brings up the issue of perjury testimony.
sir, the way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her, and at the appropriate time, we'll have her brought. We'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able
terms
to-
of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
That's what I was trying to gain knowledge of. 'Cause
Well, I can't give you advice on that.
I'm
sir.
not trying to ask for advice. I was, is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things. And that's how you'll have to address
I
that.
accept for value in return for value this document.
Was that a subpoena form? Thank you.
Oh my God, we're
Is
back
there
to this
any other
again.
witnesses you're
Accepting for
asking to add to your, and you can also call Detective Casey if you want, just so you know.
So that make 3 times he's able to testify?
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
Well, in any event,
He know what he
Um,
didn't do.
we're gonna bring the jury back out,
You know what he did.
and then I expect you to call
Yes.
a witness.
He'll get you
And what-
convicted.
And just so I'm clear, because I was trying to get to that issue, what witnesses are here? Because I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler, Stephen Guth, and Erica Patterson. Of those 3, I expect you to call one of those witnesses.
it. I accept for value in return for value this document.
Do you think these cheeks will be receiving?
Just handed to the defendant for his benefit, the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct.
How do you know what you don't have? How
You
do
don't
you
have
really
it with
know?
you in the courtroom is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
All right.
Hmm.
Are you ready to proceed forward, Mr. Brooks?
Yes.
All right, let's bring the jury out.
Wow, we had that whole big temper tantrum for all that. Jeez. Okay, real quick. Could she remove his right to call witnesses? I mean, she can, but that's like the absolute last nuclear step. She's going to give him a lot of chances before that happens because that's a massive issue with his right to defend himself and the right to confront his accusers. So, the right to present a defense. So that could happen, but that's going to be a very that's a bridge the judge does not want to cross. I know she doesn't. I wouldn't want to deal with. Yes, Tom saying he gonna cry again. Okay. Jim saying, what does the accept for value, return for value mean? Once again, these guys think this is a civil contractual setting. And part of a contract, if you're like any sort of contract, there's what's called consideration, the value, the bargain for exchange. That I agree to the contract terms, you do something for me, I do something for you. That's the value. So he's trying to act like I'm accepting for value this document. He's trying to wrap it up in all this civil law nonsense. So it's some version of consideration. And then we can get a whole world of contract law.
Thank you, everyone. Please be seated.
No, Melanie, this is the weirdest I've ever seen.
Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that. Thank you. All right, go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kohler.
All right.
Detective Kohler? The detective again? All right, guys, here we go. Just 20 minutes of temper tantrums today so far. I mean, I know there's objection counters and grounds counters. We need a temper tantrum counter. Have you ever, Tom's asking, have you ever taken a
Good
trial
morning,
and
sir.
not
If you
No.
Make your way to the witness stand,
No.
which is up toward me, up one riser. And to my right. When you get there, please remain standing.
No,
Raise
usually
your
you have
right hand. My
questions.
clerk, Teresa, who's on my left.
Well, actually,
my
to be
clerk,
fair, yeah, we'll save this. That's actually a good question. I can say yes.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Douglas Kolar, DouglasKolar.
Thank you. Go ahead, your witness.
Good morning, Mr. Is it Kolar?
Kolar.
Kolar. Good morning, Mr. Kolar.
Kolar.
I want to direct your attention to November 21st of 2021. Do you recall that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time. Directing your attention back to the night of November, evening of November 21st, 2021. What did you do that day?
Well, that day, I was preparing my daughter to march in the parade with her dance troupe. Watched football earlier in the day and got her dressed, and we had to change our plans last minute because my son was not feeling well. So it was just my daughter and I that went to the parade.
And do you recall what time you arrived at the parade?
It was at least an hour before the start time of the parade.
And do you recall where you were positioned at in the parade?
I moved with the dance troupe. So I
kind of going with the flow.
correct.
And at some point you observed something happening. Would that be fair to say?
Yes.
Do you recall what that was?
Well, after my daughter had finished and I was walking back to our vehicle to go home, I noticed as we were approaching White Rock, which is what we were parked off of, I noticed a vehicle coming through where the parade participants were going. It was a red vehicle. It was honking its horn. It passed a few parade entries on the right-hand side, and then it passed between two of the groups. It veered to the left and went around the next group on the left-hand side, at which point a police officer attempted to approach the vehicle. That police officer had reached for the door handle, and at the time of that approach, the vehicle started to speed off.
I just want to back up just a little bit.
So he was swerving around groups.
You stated that you heard the vehicle honking its horn.
While it was on White Rock Avenue, it was honking its horn.
Why do rocks got to be white?
In your opinion, did the vehicle appear to try to avoid hitting people?
At that point, yes.
At that point, this cross is going to be bad. Then he plotted everybody.
And you made reference to it the vehicle coming in contact with an officer. Did you see where the vehicle went after that interaction with the officer?
There was no contact between the officer and the vehicle. The vehicle attempted to make contact. The officer attempted to make contact. But after that attempt, the vehicle sped southward. You know, I know those streets don't run straight north-south on Main Street.
Did you notice the vehicle strike anyone at that time?
I did not.
And what did you do after you saw the vehicle? Once it was out of your view.
Once it was out of my view, I grabbed my daughter and walked as fast as I could to my car.
Yeah, I saw this go down. I got the fuck out of there. Like, I don't.
And to the best of your recollection, how would you describe the vehicle as far as a make and model? To the best of your recollection.
To the best of my recollection today, I only remember a red SUV.
At some point, did you report to law enforcement officers what you had observed that evening?
On the Tuesday morning following the parade, I sent an initial statement to the police.
Would that have been the Waukesha Police Department?
Yes, it was to the Waukesha Police Department.
Interesting. I'm surprised he hasn't said that yet.
Did you said you sent a statement. Did you initially speak with anyone verbally?
Initially, no, I did not.
At some point, did you speak with someone verbally?
Yes.
And was that sometime after the Tuesday statement that you initially gave?
Yes, approximately 2 weeks after I made my statement, I was contacted by someone with the Waukesha Police.
Do you recall if the vehicle had any tinted windows?
I believe the rear windows were tinted like most SUVs are.
And after you had verbally speaking with law enforcement, did you do any follow-up on the reports after that?
Yes. The officer that I spoke to had advised me to add to my statement the items that we had talked about.
Now, what you mean by add? Did he tell you to make a new
Actually,
report?
the law enforcement officer asked you to add certain things to your report?
He had asked me some questions, and the questions that we talked about on the phone, he asked me to add to what I had initially submitted.
Harp in that this is all a conspiracy now.
And after that conversation, did you have any further conversations after that point?
I had no further conversation after that point.
Had you yourself been contacted by any further law enforcement after that point?
No.
So it'd be fair to say that you were subpoenaed to testify at some point. That'd be fair to say?
Yes.
Do you recall when you received that subpoena?
I received my subpoena last Tuesday.
The 18th?
Whatever day last Tuesday was.
Do you recall whom you received that subpoena from?
The Waukesha County Sheriff. Or
Do you
one
recall-
of the sheriffs.
I'm sorry.
Or one of the sheriffs.
Oh. And did you do any follow-up information once you received the subpoena? Like, for example, sorry, for example, calling the district attorney's office?
I did not call the district attorney's office. I did reach out to the clerk's office to see if there was any further information.
Were you or your daughter injured in any way during this incident?
No, we were not.
No further questions at this time.
Thank you. Any cross?
Yes, Your Honor, thank you. Good morning, Mr. Kohler.
Good morning.
Thank you for being here. To be clear, sir, the subpoena you received was issued on behalf of the defendant, Darrell Brooks, correct?
I don't know. That information was not filled
Yeah,
out.
he won't actually necessarily know that.
You did provide a typed statement to the Waukesha Police Department, correct?
Objection, leading.
The
And-
Waukesha Police
If
Department.
there's an objection, let me rule on it first before you answer. Overruled, go ahead. And his answer, I believe he answered it, but if not, did you answer it?
I'll ask again.
Thank you.
You did provide a written statement to the police department, correct, sir?
Objection, leading.
Overruled.
It's cross. It's there all kinds of
90611,
leading.
so 2.
Yes, I provided a written statement.
And in that statement, you described the SUV as driving erratically down White Rock Avenue, correct?
Objection. Didn't testify to that.
You brought up the statement
It was
though.
asked and answered.
No.
Overruled,
wasn't.
the witness may answer.
Yeah.
And it's
Not
sub
asked and
3, not
answered.
sub 2, by the way. Go ahead.
Yes, just the event of driving past some participants on the right and then veering to pass the next group on the left.
Okay. You said at that point, when the vehicle was on White Rock, it was honking its horn, correct?
Correct?
There was no objection. You can answer.
Yeah, they thought I was going to do it, but I didn't do it.
And you saw an officer run up and try and open the door to the vehicle, correct?
I don't know that he was trying to open the door, just trying to, I don't know what he was trying to do. He ran and his arm had gone towards the door handle.
Okay. And that was at the intersection of White Rock and Main Street, correct, sir?
Yes,
And you got
Uh-oh. Oh, no. Oh, no. Come back to us. Come back to the light.
a look at the driver of the car, correct, sir?
Objection, speculative.
Uh-oh.
Overruled, the witness may answer.
yes, I did.
Uh-oh.
And you described the driver in your written statement as a black male with dark dreadlocks and visible tattoos. Is that correct, sir?
Objection, leading.
Overruled, the witness may
Uh-oh.
answer.
Yes,
Is that
Uh-oh.
consistent with your memory, sir?
Objection, speculative.
Overruled,
that is consistent with my memory today.
Once the vehicle went past the officer, you indicated that you saw it accelerate or speed off. Is that correct, sir?
Objection, leading.
overruled, 90611 sub 3.
yes, at that point, it sped away.
Thank you, sir. I don't have any other questions.
Any redirect?
Briefly,
Go ahead.
Oh, I'm sure
Referring
this
to
is going to
the-
be stellar.
written statement that was just testified to the best of your recollection, do you recall stating that the SUV was a older model red Chevy Blazer?
I do recall putting that down at the time, but that was at that edition that
Ghost
I had
table.
2 weeks later.
So at that time, during the evening of the incident, to the best of your knowledge, that would have been your opinion of the vehicle that you saw?
At the time of that, the day of the parade, I just remembered the red SUV.
To the best of your recollection, what
That's the
assumption
state of
will lead
Wisconsin
you
sitting there.
to describe the vehicle as a Chevy Blazer?
I believe in my assumption, it was just to say it was a older boxy style SUV, and in my mind, that relates closely to a Chevy Blazer.
No further questions.
All right, thank you. You may step down.
Okay, so we thought it was a Chevy Blazer, but it was still a Ford
And you
Escape
also
that
are
killed
excused.
everyone.
Thank you for being
So,
here.
Gerald, this is not a win.
You may call your next
You,
witness.
you had a pop fly there, man. Out to the warning track.
One second.
Oh no, you guys, you can't call her looking like Keffels. That's not right. Don't do
If
that,
I may
lady
have
dirty.
just a quick second.
Okay.
Yes, that camera shot over to the blank table. That was the state of Wisconsin sitting in the next courtroom, believe it or not. Keffel's older sister. Oh no. No. Yes, Melanie, you're right. None of this changes the fact he plowed into a crowd of people and killed a bunch of them. So,
The defense would call Stephen Guth.
yeah, it would be.
I believe one of my assistants went to retrieve Detective Guth, Your Honor.
Thank you.
Oh. Perfect, Dwayne. I apologize to the chat. Not. Oh, Excel Right. How you doing, man? Haven't seen you in a while. I know we probably haven't been able to talk as much because Twitter's gone, but I can get back in touch with you, man. He was trying to pull a my cousin Vinny. That model Ford couldn't have left those tire tracks. Yes. He's trying a lot of different things here. Yes, Zaven saying calling that stenographer Canadian is very rude. Yes, it is. That's very considerate of you guys to label her a Canuck. What the hell is he writing? Who knows what he's writing? He's probably drawing penises for all we know. That'll be as effective as what he's doing. Von Richburg says, I am the ghost of the state of Wisconsin. Ooh. Okay.
Great. Good morning, Detective Guth. As you are, come to the witness stand, remain standing, raise your right hand, and my clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Please state your first and last
Presented
name
without
for the
comment.
record, or names, I should say.
Stephen Guth, STEVENGUTH.
Go ahead, sir. You're witness.
How long have you been in law enforcement?
Over 20 years.
And how long have you been a detective?
Just over 7 years.
Directing your attention to the evening of November 21st of 2021. Do you recall that evening?
I do.
And were you on duty that evening?
Not initially.
For more clarification, what do you mean by not initially?
It was a regular off day for me, but I received notification to respond to the police department for the mass casualty incident in the downtown area of Waukesha.
So at that point, I'm assuming you were dispatched to that location?
I was not dispatched. I received a Signal message. We use Signal. It's an app that's used that we can share information for investigations. I received a Signal message that this tragedy just happened.
And so what did you do from that point?
I immediately dropped
That's
my
actually, ooh, I don't like this.
wife and
Signal
kids
is
off
not,
and responded to the parade.
Signal's not inducive to FOIA. They
And-
should not be using Signal.
When you got to the parade, what did you do at that point?
I went
That's
to
a
the
big
downtown
problem.
area to assess and see what I could help with.
At some point during your investigation, did you make contact with a woman by the name of Erica Patterson?
Yes.
And what was the nature of that part of your investigation?
I wanted to speak with Erica Patterson because by that point, when I made contact with our command center, they had learned the name of Darrell Brooks and had learned that Erica Patterson was the estranged girlfriend of the suspect of this investigation.
You made reference to a estranged girlfriend. What do you mean?
I don't know if I should answer that.
I think the question was pertaining to the word estranged, but we'll move
Yeah,
on.
that Darrell, you
The jury
better
will
fucking
disregard that last question, that it's been withdrawn.
best watch yourself there,
And
brother.
the statement made by Detective Booth following that.
I'm assuming at some point you took a statement from Ms. Patterson.
I did.
Do you recall if it was recorded, written, you writing it? What was the nature of how the report was taken?
Well, her words were spoken and they were recorded, and then I prepared a report.
Did you prepare the report that same evening?
No.
When did you prepare the report?
Sometime after the 22nd of November,
Why not the same evening?
because after I spoke with her, I wanted to go back and speak with her again.
Did you obtain any statements from any other people that may have been involved with Ms. Patterson?
I did not.
Do you know, to your recollection, if any other officers have taken statements from parties that may have been involved with Ms. Patterson?
Well, the night of November 21st, 2021, I did have a partner with me, another detective.
Do you recall him talking to any other parties that may have been involved with Ms. Patterson?
Well, the detective that was with me was a female, Detective Barron.
The question was, do you know if your partner had any interactions with parties that may have been involved with Ms. Patterson?
I don't believe so.
Hold on,
but
are
I
you
can't-
specifically referring to a date certain or just in general?
I think it was clear.
I
The
need
date
it
would
clear
be-
for the record,
The
though.
date would be
On the
November
21st?
21st
Okay,
of 2021.
thank you with that clarification.
No, I don't believe so.
Did you learn at any point that there may have been other parties involved with Ms. Patterson?
In which incident?
I'm referring again to November 21st of 2021.
Yes.
Do you recall who those parties were?
Corey Runkle and Nicholas Kirby.
One related to Ian
Did you
Runkle.
yourself speak with either of those parties, Nicholas Kirby or Corey Runkle?
No, I did not.
Do you recall if your partner spoke with any of those parties?
Which partner?
I'm guessing the female partner that you made reference to.
No, she did not.
And in that recorded interview with Ms. Patterson, what did you learn about the evening of November 21st, 2021?
Which recording?
Are there multiple recordings?
Yes.
What did you learn about the evening of November 21st, 2021 from both recordings with Ms. Patterson?
Your Honor, I'm going to object at this point, as this testimony covers ground that was very clearly covered during the state's case in chief.
I'll give Mr. Brooks some leeway. You are asking for hearsay, though. You understand that.
I asked him, what did he learn?
Fair enough. Go ahead. You may answer.
I learned several things. Initially, I think is what you were getting at. Ms. Brooks wanted to report that she was injured by Darrell Brooks on November 20th, which would have been Saturday. She stated that she met with Mr. Brooks at Frame Park, and they were arguing over the fact that she did not give him money, and he injured her by slapping her in the mouth and punching her in the eye. The next day, I went back and talked to her again, and she clarified that that actually did not happen on the 20th. It happened on the 21st, and that she got in a motor vehicle with him over the same argument. He was mad that she did not provide him with money. He proceeded to try to take her phone because he thought she was talking to other guys. Slapped her in the mouth, punched her in the eye. She jumped out of the motor vehicle because she feared for her safety and made her way back towards Frame Park. While walking back towards Frame Park, she was calling her friends, Corey Runkle and Nicholas Kirby, to come help her. When she arrived back near Frame Park in front of White Rock School, there was a confrontation in front of White Rock School with Mr. Brooks, Erica Patterson, Corey Runkle, and Nicholas Kirby, where there was some kind of shoving match. And that's when Mr. Brooks got back into the motor vehicle and took off down White Rock towards Main Street. Erica Patterson then made her way back towards the Women's Center.
How's this helping you, brother?
You made
I
a
don't.
reference to being told about an incident from Saturday, November 20th. And then stating that in the second interview, Ms. Patterson stated that didn't happen. Is that correct?
She didn't state that it didn't happen. She just stated that she didn't drive around with him on Saturday, November 20th. But she also met with him and was slapped in the mouth that day too.
This does not help you at all.
If it pleases the court, I have a document here I would like to show the witness.
All right, if the bailiff could have it to the state first to look at it. We may use the document camera
This
if
is
that's hooked up. Otherwise, the bailiff can take it to the witness.
Before we go through that process, I'm gonna object. It's, well, maybe
Let
we
me
should-
see the
no.
document.
The mug is self-washing. Also, guys, Brooks Coffee Company out of Kenosha, Wisconsin, serving ground since 2022. You can find this on my merch. Link down below if you want one.
All right, and give that back to Mr. Brooks, given the content of that document. I'll sustain the objection, or what that document is, I should say.
Sustain on what grounds?
It's not relevant
It isn't relevant.
to this witness's testimony.
And we've already brought in the fact that
Oh,
he's
not
beating her, so that's great. Good job, Darrell. Now you're a woman beater.
It's not relevant.
Good
Made
job.
reference to November 20th. That's what this document is talking about.
Yes, and the
It's
date.
not relevant to the charges at issue.
It's not relevant to whether or not you
We can
killed
take it
6
up
people.
later. If need be, I'll let you recall the witness, but
It
I'm
changes no
directly
bearing on
move
that, Darrell, at all.
onto a new topic.
Your Honor, I'm gonna respectfully object to that and ask for a finding of fact.
It does not matter because
The
this
objection's
does.
noted, it's sustained. Well, their objection sustained, yours is overruled. Please continue.
Is that noted for the record? I would like a written finding of fact.
The request is denied. Keep going, please.
Denied on what grounds, on what lawful law?
Keep going, sir. It's not relevant.
Are you making a judicial determination that you don't have to answer that question as a public servant?
Sir, I've ruled on the objection. It's on the record. Please keep going.
Once again, information that needs to be known is being hidden.
It's not relevant, sir. Please
It's
continue.
very relevant. He just opened the door on that by saying November 20th.
Objection, move to strike all of the comments made by Mr. Brooks in the last 20 seconds or so, especially with regard to any implication that he hasn't had all of the discovery material.
Objection, I never made any mention of not having any discovery material.
Yes, you did.
That never
The
was.
jury
Yes,
will
you did.
just
He referenced
disregard,
it.
as I've told the jury repeatedly, comments made or statements made by the parties, whether they be lawyers or the parties themselves, are not evidence, and you're to disregard them and not consider them in any
He's like a
way
3-year-old.
the
He's learning new
statements
words.
suggested. Facts that are not in evidence, you should not consider that in any way either. All right, go ahead. Your next question, please.
Grounds versus frowns.
So is it fair to say that in your report, you referenced 2 incident reports?
Objection, this
Grounds.
witness wrote,
I'm going to overrule
Fine.
the objection and let the witness answer it. I think it might just be semantics at this point, but go ahead and ask your
You
question.
need semantics.
I think you were referring to that he had 2.
That's it. That's what his report says. He makes reference to two reports, 2 incidents.
2 incidents,
Yes.
not 2 incident reports. Reports would be separate documents. That's what I'm talking about. With that understanding that you're referring to, and I think you're referring to incidents with Ms. Patterson, correct?
Yes.
Go ahead. Ask your question. I think that clarifies so that the witness can answer.
In your, let me back up. You wrote your own report. Would that be fair to say?
Yes.
And in your report, you referred to 2 incidents. That'd be fair to say?
Just to clarify, which report are you speaking about?
That's a problem there, yes.
The one written November 22nd of 2021?
I do reference 2 reports and 1 CAD call.
What was the last part? Cat call?
A CAD call, yes.
Computer aided dispatch.
What do you mean cab call?
Not CAD, CAD.
Cat.
CAD.
Cat.
CAD call.
What do you mean cat call? What?
That's a call for service that does not generate a police report.
And what was that CAD call?
That was a call for service near Frame Park for a fight involving potentially a domestic related incident.
Do you recall any other details about that CAD call?
There wasn't much in it because the officer had to leave to go to the parade.
Do you recall mention of a knife during that CAD call?
Yes,
To the best of your recollection, do you recall anyone recovering a knife or you yourself recovering a knife?
there was no knife involved in that incident through my investigation of the report that you have.
But it is fair to say that that's how the CAD call went out, that there was potentially a knife fight.
That's how it was initially, I believe, reported
Knife fight.
or communicated through dispatch to the officers that responded.
My God, you guys. Get her something else. Yeah, this actually sounds about right. If She-Hulk was doing the trial.
And I'm referring to the second interview with Ms. Patterson. You made reference in your report that in the previous interview that Ms. Patterson was not completely forthright.
Hi, Yvette.
What exactly do you mean by not completely forthright?
Forthright?
She did not give me all the details of the incidents to me initially.
Do you recall why?
I don't know why she didn't.
She's not going to be there. She thinks he's crazy. And this is probably tearing her apart to watch this happen. So, no, she's not going to be anywhere near it.
So it'd be fair to say that Ms. Patterson had been untruthful with you in the first interview.
No, she told me she was extremely afraid of you.
Oh,
She
God.
didn't want to tell me everything.
You're helping
You just
yourself,
stated
Darrell.
that you didn't know why she was not forthright.
I can't read her mind, but that's what she told me.
Huh. Yeah, and then everybody talks about how much of a lunatic you are. This isn't, yes. Oh, I've got him where I want him. I'm not sure you do. This is just bad. Come on, Darrell. Darrell, come on, look at me now. You gotta pick this up. You gotta turn this around, man. You got the horn honking in, which is great. But you gotta turn the rest of this around because right now we think you're a lunatic that likes to beat women. Let's go, brother.
At any time during your investigation in regards to the incidents with Ms. Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them?
Had you seen any statements made by those two parties?
No.
Oh, shuffle them papers. This is what attorneys do.
Would it be fair to say, assuming
This is what
that those two
professional
parties
guys
were
do when they're
present
looking serious.
for the incident on the evening of November 21st
I are
of
attorney.
2021, would it be fair to say that at some point they were interviewed by law enforcement officers, to your recollection?
Yes,
And you've never seen any of those interviews?
they weren't video recorded.
Had you seen any written statements from them or report from law enforcement?
I received a summary of what they stated verbally from another detective. Yes,
So it'd be fair to say you did have knowledge of what they said transpired on November 21st of 2021.
I acknowledge what they said. I didn't see anything. Correct.
And to the best of your recollection, seeing what those two parties had said, what do you recall?
Objection.
Grounds?
Evidence, you didn't see what they said, and also calls for hearsay.
Sustained.
What did you read
Objection.
from those statements given by those two parties?
Objection, calls for hearsay.
Grounds?
Sustained.
Grounds for the sustain.
Calls for hearsay.
The grounds for the substains. And get those substains out with Tide. Get a Tide pen. It'll help. It's got to be clean. It's got to be Tide.
One second.
You need more than 1 second, dude. You need more than 1 second. You need more than 1 second here. So somebody was asking who this is. He is a detective with the Waukesha Police Department, and he dealt with initially some of the stuff involving Erica
Do
Patterson.
you recall what officer took those statements from
Yes, Detective Shane Gillis. Yes.
Nicholas Kirby and Corey Runkle in relation to the incident on November 21st of 2021?
Yes. Yes.
And what law enforcement officer was that?
Detective Van Els.
And after that report that you wrote on November 22nd of 2021, was that the end of your investigation into?
Guys, I don't know what happened here in my internet. What the hell just happened? No, something just happened in my internet. It's like, it's all getting wacky. Hold on.
Ms. Patterson again after filing your report?
Yes.
In reference to the incident from November 21st of 2021?
Guys, sorry about that. Sorry.
I don't understand your question.
Did you speak with Ms. Patterson after you filed your report in relation to the incident from November 21st of 2021?
No.
Yes, this is appeal proof so far. I don't see anything that sends it back. Yeah, I don't know what that was, guys. I apologize. I missed nothing. I was looking down the whole time. It's not a surprise.
The alleged incident on November 20th of 2021. Do you know if that alleged incident ever took place?
Objection.
Grounds.
Calls for hearsay, lack of personal knowledge.
Also, a legal conclusion if something occurred.
Well, you reported it.
It also goes to one of the ultimate issues that the jury will need to determine, so it's sustained.
Mhm. $500 people watching, guys. Thank you very much for tuning in this morning. I appreciate it. If you guys liked it so far, please give me a like. That way we can go after long crime and embarrass them by having more viewers, hopefully.
No questions, no further questions right now at this time.
All right, thank you. Any cross?
No, Your Honor.
All right, thank you, sir. You may step down.
Nothing here. Jim, you brought up a good point here.
May have something later for that particular witness.
You have a minor issue that all these witnesses
I'll
decided
still raise that on an appropriate break.
State
Call your
didn't
next
call.
witness, please.
said they show him honking when he swerved to miss people. I don't know if they didn't bring it. Like, it's who knows exactly why, but yeah, it doesn't look good in that regard. But he could be swerving and honking the horn fine, but he didn't swerve and honk the horn when he got to the main parade.
Yes. For that, yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
Oh yeah, it's only it's 9:40. It's 9:45 in the morning there. I don't get to make fun of Erica yet. I don't get to embarrass her. Oh no.
Who's supposed to come at 10:30, right?
Call your next witness, please. I don't have that list.
Did you hear the
right.
prosecutor just laugh? You can hear that just gasp.
You said what happened?
I don't have that list right at my fingertips.
I don't have the
but I know
business.
There's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
Oh Jesus, criminy on a cracker. Let's go, bro. Yeah, don't I get redirect?
Does the state have that? You can pass it over. I don't have
I
that.
know.
Sure, let me try to, I have it, but I'll write it up for Mr. Brooks to review, Your Honor.
Thank you.
This woman is a saint. Sue
While we're
Opera is
doing that, if the
making
jurors
her
want to stand
office.
for a minute, go ahead, or anyone else in the courtroom.
Sue Opera is making her office look phenomenal right now. And I don't usually say that about a lot of DAs, because a lot of DAs are dicks. But Sue Opera right now is doing a phenomenal job. She is going out of her way, even though this guy is an insufferable prick of the highest regard. She's out there wanting to, the Pike case says, I need to cross-examinate. Yes. She's doing very good. I'll give her top notch on this. The case they presented has been very good when it came to having to amend the information to reflect the evidence. They changed one word out of 77 counts. That's actually really, really good. they haven't pulled a lot of the bullshit you saw like in the Rittenhouse trial, the Potter trial, any of the other trials we've watched, or you've seen on my channel or Nick's channel or anywhere.
Return for value. This.
Oh, stop with that,
Paperwork.
Darrell. Jesus Christ, dude.
Thank you for everyone. Have a seat then.
You don't understand the concept of value, especially when it comes to human life.
Please call your next witness.
And who determined this order?
They did because you
Mr.
wouldn't
Brooks,
tell them
Take
anything,
up that issue
asshole.
outside the presence of the jury later. There's a witness available. Please call the witness.
You played this
That's
game
not the
yesterday.
witness that was intended to be called at this time.
I understand that.
But you
sir.
didn't
Under
tell-
90611, I have the authority and the discretion on that. So please call the witness who's available.
You spent all day fucking
So
around
I'm being
about
rushed
this.
to judgment.
No, you're not. You dicked around
No, sir,
yesterday
I'm
and
trying
refused to
have
cooperate.
An effective and efficient use of all of our time. So please call the witness.
Which is respected, but at the same time,
Respected.
being this is my
All
time
right,
to
I'm going to
present my
excuse the
defense.
jury for right now.
Oh, God almighty, man.
All rise for the jury, please.
Random Lombax 37 says, I'm sure it's really bad, but does the prosecution not doing cross mean that he did something that should be on OnlyFans? Yes. At times it does. That, like in this case with that detective, it brought out the domestic violence. They brought it up more and more and more, that he beats people. Erica's scared of him. All that fun stuff. But you also sometimes do it when it doesn't hurt you. And some of the stuff really doesn't hurt the case. So if it wasn't
All
effective,
right, thank you. Be seated.
Dale tried direct
Mr. Brooks,
examination.
under 90611, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process, and so I told you
Yeah,
that
he fucked around yesterday.
3 witnesses
I don't know
would
who
come
I'm
in
going
at
to call.
8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list,
You were advised on the record,
but
sir.
you didn't provide it to me.
Sir, you chose not to write down, so that's on you, not me.
Nah, that's
So
no. You
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson
A
is
rush to
here,
judgment.
so I'm advising you.
Oh,
She
oh,
will be the next witness that you call if you so choose. If you choose not to call her right now,
That'd be good.
then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her.
Yeah,
She's
the
on
re-
your list. She was on the listing, as I understand it, the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority
Lawful law,
to do
it's
that.
pretty
She's
damn lawful.
here, she's ready to go.
I'm just
She's
asking a
your
question.
witness.
I'm just asking the question. Is that lawful law?
any court
I
can
have
agree with
the
this
authority
100%.
under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation.
Your Honor,
Of
why is
witnesses.
it always so hard to just say yes or no? Is
Yes,
it lawful
I have
law?
the authority, sir.
I'm not disputing that.
Yes, you are.
You just
I'm not
disputed
disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if you
told me
don't want
what
to
you-
recognize it, that's
told
fine.
me
You
your
want to
authority.
object and note it, that's
Told
fine.
me your
Your
authority.
objection
I'm
is
not
noted
debating
on the record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly. And then I'm going to have the jury brought in and That will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue
It's a
did I say I
misdirect.
had with the
You
last?
said you wanted to raise an
said-
issue with about
What I
Detective
said
Guzman's
was I
testimony.
might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may have
nobody hears
missed
me.
it, but I heard, what I interpreted was when you said I may have an issue with this witness, I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted, and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I
You
respected
fucked around
that,
and missed the
Mr.
chance,
Brooks.
But I
dude.
said that.
And
from the
so
beginning.
then I asked you
Your
to
Honor,
put
with
him
all
in
respect,
flex.
with all respect, did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
numerous
I
times.
have authority to tell you otherwise. You
I
may
did.
not like it. You
I
may
did.
disagree with it.
It's not
You
about
have
that.
been-
It's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to
cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to
frankly,
do
any
that.
attorney in this
I never asked them to
situation
do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of the day,
but we expect
if
your
they didn't want to do
cooperation
it,
in that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
Yes.
but it
And
wasn't
here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
Because if
normal
you-
in a trial
You can't
to call
put the people.
witnesses.
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the
saying
state
that, sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did. in
Did they
that
have to
regard.
do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with. We're going to call this witness at this time.
But they're
and this witness
able
at this
to
time.
contact
They
their
didn't have to do that, so
witnesses
why should I have
and
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So
a.
here's the
with a shock
situation.
device
It is
on my, ankles.
9:52.
So how's I'm trying to control
Shock
anything?
device on Bob.
I just want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks,
Yes, it
it's
is.
fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how that's
the
fair.
process that has been set up.
Because you're
to
a
frankly
moron.
Help you. get
No,
the
it's not
witnesses
helping me by,
to
it's helping
court.
the state
And no,
by being able to say, if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes,
No,
you
you
did.
didn't.
You
You
did.
played
You
that-
asked me
You
to
played that
give
game.
them
You
my
played that
witness
game
list.
against who?
I gave them my witness list.
Yesterday,
It's not my fault.
I very
It's not my fault they
expressly-
weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm going to stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't
be
call
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
wanted to be
her
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For
Law,
your
where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have
Let
the
us
right
take the
to
letter.
You have to
witnesses,
cooperate with this process.
but I
sir.
also have the Sixth Amendment right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or
I'm not going to
or
play
order.
this game with you, sir.
It's not no game. That's what you don't
It
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
I
I don't take this as a
asked-
game. That's what
Let me explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You
you
think that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never.
That's
said
what
it
y'all
was
don't
a joke.
understand.
But there's
It is
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was
Why?
a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
I understand.
I think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about.
Oh, wow. 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 That was great, kids. Yes. You ain't going to stand on no grounds. You can't stand your ground, son. Whoo-wee. Lord child, that was tough. Damn, we got going. We got going there. Wow. Oh. That was good. Well, yes, 583 people. We've got some new viewers. Welcome. You guys came in for the fireworks. Real quick, if you guys are just tuning in, my name is Sean Martin. I run the channel Potentially Criminal. I'm a defense attorney in the Cleveland, Ohio area. So yeah, we're covering the trial today. I don't have to work. I don't have to go to the office. So we're just doing this. But let's get back to the questions. Real quick. Richard Gruber for $5. We're going to cover Super Chat real quick. Imagine unironically not proving subject matter jurisdiction. Sometimes that happens. Sometimes a prosecutor forgets to prove venue and things get dismissed. Let me see here. There were two really important questions here I wanted to ask or catch up on. Vince Clortho, this is a good question. Do all witnesses need to be served a subpoena? Or can he call his mom at any time? No. You do not need to subpoena a witness to have them show up and testify. Now, if I don't, so let's say, for example, Vince, you're going to show up and testify in a case I'm trying, and I don't subpoena you. If you don't show up, I can't do anything about that. The subpoena is a court order. Therefore, I can say, Your Honor, I served this man with subpoena. I personally served it to him. This is an order to this court. He needs to show up. This is a material witness for my client's case. Here's what this witness would show. You know, we would ask the court to put a material witness warrant out. We'd ask the court to send the police out, the deputies out to go retrieve him. Here's his, here's where he lives. Here's where he works. I served him at his place of work. And he's denying my client the right to an effective defense. So without that subpoena, if they don't show up, I can't do anything about it. I can't object and make a record about it. If you don't subpoena them, that's a problem. Also, on the other hand, if you do show up and you're not under subpoena, that can be used against you if you're a witness. Because if I'm a defense attorney and the prosecution witness isn't subpoenaed, I'll say, so you're not here under subpoena. You're not forced to be here, right? So you came here on your own. And I would use that to try to show bias, that you're like a goody two-shoes. You want to help out. You're a good idea fairy. So there's a lot of ways subpoenas are important. When in doubt, always subpoena people. It's better to subpoena extra people and then realize as court's coming up, you don't need them and you can cut them loose. And you don't have to do anything official to get rid of a subpoena. You just say, you call them up and say, hey, don't come in. And at that, subpoena's done. There's no official, like the court doesn't ask, hey, what about these subpoenas? Why aren't they here? The court's assuming you didn't have them come in or they didn't show up. If you're not complaining about it, the court doesn't complain about it. So I hope that helps. If that doesn't, Vince, let me know. Random Lombax says, I'm pretty sure it's really bad, but does the prosecution not cross-examine mean he did something that should be on OnlyFans? No, it's just if it doesn't hurt, there's no point in doing it. Like, if it's not dangerous to your case and not helpful to his, there's no point in going any further. Also, the prosecution in this case, they've got enough evidence. They're like, look, we just want to get done. Let's get through this. So, real quick, just going to try to catch up. Let's make sure to miss nothing here. Yes, we now have a Switchy and White Claw emoji, guys. Throw them down in there. Also, American Virtual, I know you mentioned the thing about Stardust. Yeah, if she wants to get a hold of me, I'd be happy to talk to her. But yes, guys, please smash the like button. It would always be appreciated. Yes, he went from OnlyFans to Live Leak. Yes. In this case, that detective did not hurt the state. It only hurt Darrell. Because now we've heard the domestic violence more and more and more. And we've just, yes, the jury now hears, once again, how big of a piece of shit you are. That doesn't help at all. Ron is saying, doesn't the prosecution have to disclose the order of who's coming in and when? No, but the prosecution has a set order of witnesses and they make sure they're there and ready to go. Darrell doesn't have that ability because he can't call out, or he's claiming he can't call out. But he plays this game of, well, I want these people ready today, and he jerks around the system. So yesterday they said, well, who are you going to call? Well, I've got a special witness I'm going to call. Who? It's going to take all day. I don't know. I'm not going to tell you. I'm not sure. They said, was it your girlfriend? He's like, no, it's not that. You don't know. You don't know. Okay, well, when do you plan on doing it? What's the rough order? Can you give us a basic idea? I'm not telling you. I'm giving you a list and letting you figure it out. That's why he's in trouble, because he didn't set up his own order. If he would have said, I want these people in this order, boom, 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 the state would have told these witnesses show up this order, and they would have they've helped to go retrieve these people. And they said, show up in this order. You here, you here, you here, and you here. But he didn't do that, so they just tell these people show up. So that's the issue. He set himself up for failure yesterday, and now he's crying about it. But yes, the prosecution doesn't have to give you a list, but generally speaking, you kind of have an idea of how the prosecution is going to call witnesses. Because remember, they have to tell a story, and the story has to be logical and coherent. So you start off with how it started. I'm the first detective. I was standing at the beginning of the parade, and what happened? This car came out of nowhere. Okay. And then they rewound a little bit, and they brought up the two women. What happened? Well, we were at the park, and Darrell took off. Okay, and then they went back to the parade itself. And then you had that one sergeant the first day of testimony, and he just sat there for like 45 seconds, just emotionally destroyed from remembering watching Darrell Brooks plow through that crowd of people. But you start with that, and then you start getting into the other police officers who were there. Then you cover the victims who were in the parade, and they could talk about who was all injured. Then they talked about what happened afterwards in the chase and the search, and the people that saw him running around like an idiot. Then he went to these people's houses, and that got covered. And then you talked to then the police were like, well, we arrested him. And then the police then said, well, then we found the vehicle. And then we did the searching, and we did the forensics, and we did this, and we did that. So they're telling a logical story. Generally, you have an idea. But yes, there is no obligation to show an exact order. Because remember, the prosecutor can eliminate witnesses if they want to. They can say, yeah, we don't need this guy. But they can also add witnesses if they want to. It's really hard to add during trial, but if a new issue arises, they can claim we need to bring in this witness to talk about this issue. You saw Darrell Brooks do that. I wanted to add somebody, and the judge said, cool. So that is, sorry, that was a little bit of a divergence there, but I hope that answers your question. If it doesn't, please throw something in below. Okay, here. Well, you guys are... Ross is saying the jury literally throw books at him when they deliver the verdict. That would be hilarious. That would be hilarious. Okay, so let's get through some of the other stuff we got going on here. The other super chats. Just Jen T. Thank you, Jen. I appreciate the super sticker very much. Track Golfer says, what can she do from here? Well, she can curtail his right to bring witnesses and present a defense. That's going to be like the absolute last nuclear option, though. I mean, she's very limited in what she can do. Just Jen says again for $2. Thank you. He has nothing to lose, completely pathological. Yes. And yesterday was a great example how he ended yesterday and now he's pitching a bitch today. Naked Lunch. Yes, he can lose that right, especially if there's a witness there who's ready to go and he's refusing to call. Well, he's going to release him. Now, notice at the end of it, he wants to cross-examine Eric. He wants to direct Erica, so he's not going to give that up. We have a new member, Hope Strickland. Thank you so much, Hope. I appreciate the support. Just a map nailed to the wall. Is Darrell running a train on this judge? No. He might think he is. He might go home at the end of the day thinking, yeah, I showed all these people what's up. No, she's doing whatever she can to protect the integrity of the trial, and I give her high marks for that. She's doing a very good job. Aunt Lalloween is saying he is constantly irritating me. Yeah. I'm assuming he does this in his normal daily life, annoys the shit out of everybody. So, nothing new. Axios super chat. Thank you very much. I appreciate it. Quick, someone get Brooks a copy of the worldwide Volkswagen v. Woodson decision. He could still win this. Yes. Yes, and somebody yesterday mentioned International Shoe. Yes, get him a copy of Paul's graph. It might help him. He might still turn this around. Tom Gillis says, have you ever taken it to trial and not cross-examined a witness? A couple of times I have. I had a guy once, I was public defending, I was in Toledo, and I don't think they met the elements of this guy hadn't committed a crime. So it was disorderly conduct, and he was shit-talking the police really bad and being drunk. But he wasn't like falling down drunk. He was just really, really tore up. And we went through it. There were 2 cops that testified, and then the bar owner. We got done, and I said, Your Honor, that's not, I didn't cross-examine any of them. We got done, and I just said, Your Honor, motion to dismiss. Him redressing grievances with government officials is not disorderly conduct. And you could be drunk, and you have the right to still tell government officials what's up. And the judge wasn't a fan of this whole situation, and he said, okay, yeah, motion granted, case dismissed. So that might happen every once in a while, but on a massive trial like this, you generally you just don't let everybody walk. But here, and yeah, I have a drug trafficking trial coming up on the 31st. One of the people that's going to come in is the sheriff's office person in charge of handling the evidence and showing I pick up the evidence is given to me by a detective, I log it, and then I took it to the state crime lab, and they processed it, and then they gave it back to me, and I brought it back. And she's going to show her documents to show that she did that for chain of custody. I'm not going to cross-examine her. There's nothing there because asking her questions does not make it any more likely or less likely that my guy was involved in drug trafficking. So I'm going to skip that. It doesn't help me. It doesn't hurt me. It's completely irrelevant to the case. Another one's going to be the lady who actually tested the drugs because at the crime lab. Okay, great. They're drugs. I'm not denying that they're drugs. I'm just denying my guy had any role in it. So for me to cross-examine her, there's no point. So there are times where I will not cross-examine a witness, and those are like examples of it. And I hope that helps. Jamie for $4.99. Thank you very much. He is calling people that heard a horn honk, it seems, because the woman yesterday said the same thing. I don't know what he can prove. He's trying to show that it wasn't intentional, like he was honking to warn people that, for whatever reason, to get out of the way. It's not really going to work at the end of the day because, okay, people didn't get out of the way, but by the end of the parade, he kept on running people over and didn't stop. And it'd be one thing if he, stopped and all the people are marching along and he, stopped right behind them and just waited. Okay. Then you might show, okay, he really didn't mean to hurt anybody, but he just kept going. So I think he's screwed. Boomer for $5. Thank you as well. Yes. He is speaking in dead languages. He is a real attorney now. Yes, watch out. He will have my job soon. Good for him, I guess. Kevin James, pause. says, do you think he goes back to his jail buddies each night and tells them how he kicked ass in court that day? Oh, I think so. I think in his mind he's
After
winning.
a short break, appearances are as they were before. I would just note Attorney Opper's not at the table, but I presume she'll be back shortly. I will be advising the clerk to have the jurors brought out. And then I'll ask you, sir, to call the defense next witness.
Can we address subject matter jurisdiction and still has to be proven for the record?
I decline to do so. Your objection is noted. For
Is
the
the
record.
audio on?
No, Darrell,
Your
we're
objection's
just,
noted
it's
for
all
the
a
record.
joke.
Is the
It's a trick.
audio on?
Yes, it's on, sir.
Yes, it's on, you fucking
It's on.
idiot.
So we're not going to address subject matter jurisdiction that has yet to be proven for the record.
For the record, I have
Oh,
addressed it.
Jesus Christ, on a
No,
cracker.
you haven't
And
proven it
here's
for
it
the
written.
record.
And your objection's noted for the
Have you
record.
proven subject matter jurisdiction for the record? Have you proven it? Has the prosecution proven it?
Oh,
Oh, no.
email that to her and print it out.
So that's your judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually
No,
did not.
we did not.
Come on, Your Honor. Come on now.
She busy talking, asshole.
We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
Your oath. Get a bowl of oath meal on this cold Friday, this chilly Friday morning. Big old bowl of oath meal. It'll sustain you through the day with nutrients.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
No, Vince,
Give 1
there's no
second.
way that
I'm
can
trying to make
happen.
sure I got the
The judge has to
paperwork
let the
since I'm
jury
being
do
rushed
it.
to judgment.
As much as that sounds great in this case, that would be absolutely terrifying if that were at all something a judge could do. But I understand the sentiment. Like, yeah, you're guilty, hop on the bus, we'll see you later. But no, he can't do that.
That's not right.
Both is good saying he knows he's toast, right? I don't know. I mean, he's a bit of an idiot, but we're not sure. Luminal Space Wanderer says, yes, her offal of office. Yes, 2D Oh My Hero says oaf meal with coffee grounds. You guys are on fire today.
All right.
Go ahead.
Defense calls Erica Patterson.
Thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Will this be a Lifetime movie? I don't know, Tom. Yes. The defense called that bitch Erica. And the Fed know, as far as where you go in a
Good morning, Ms.
prison,
Patterson, if you would please make your way.
that
the
is up
witness
to the
stand,
prison
which
to
is on the
classify.
right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my colleague Teresa, who's across from you and on my left, will swear you in.
No,
Do you solemnly swear that the testimony you're
Any
about to
sort of
give shall be the truth, the
classification
whole
where
truth,
you
and
go in a
nothing but the
prison,
truth, so help you God?
that's up to the prison.
Thank you. Please be seated.
So they'll decide what they'll do with him. They classify him and
First
then
thing
they
I
house him
will ask you to
accordingly.
do is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
Oh, the one spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ERIKA PATT E-R-S.
She's gonna fucking light him on fire. Get ready, guys. This is gonna be good.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here.
This is the woman he was beating on in the park, and this is the woman that we saw at the beginning where him and the other lady were fighting, and then he takes off in the car. This is the woman who the domestic violence call is all about. So it's Aiden Higgins says, "Hi, Sean, Dublin calling. It's been a long, great time to see you covering this fiasco. I'm a bit behind, so we'll catch up soon." Well, Aiden, thank you so much, and I appreciate everybody wherever you're watching. So thank you so very much. Yeah. But yes, this is the woman he beat. Guys, real quick. This is the woman he beat. It was alleged to have beaten that started the domestic violence call that caused him to take off. And then we had the parade attack. So this is where we find out, his idea is, I'm going to focus on this. And somehow that absolves me of the
I'm
murders.
sorry about that. 1 second. I'm trying to find this paperwork. Just had it on tape.
His paperwork to be like, would you agree if I called you a dumb bitch? Would that be
Ready?
would that be a fair opinion? Yes, Garrett Pace. Hold on, I gotta do it in Drex voice. Sean. Look at the shepherd, Sean. I don't get no Drex voice. It's too early in the day. Also, I just noticed that he's wearing the same shirt and tie from before. Whew. He probably smells a little ripe by this point, because I doubt he showers every day. I guess we'll read a super chat or two while we're doing stuff in the meantime. Mr. Squiggles for $5. He keeps shooting himself in the foot. His last witness will probably be testifying that the honking was coming from a clown stuck to his fender. Rob Dort says, okay, who taught him about rush to judgment last night?
I'm just going to start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason.
Alan Brown for $10. Thank you. Says, best law tube channel, period. That's the business. Thanks, Sean. Well, thank you. Thank you very much for your support. Terry Bradley for $19.99. Thank you. Says, happy Friday. Still glad you're covering this today. Thanks. Well, I'm happy you're here. Thank you. Thank you for the support. Oh, here we go.
Patterson.
About to get serious now. Tighten up that tie, Darrell. Tighten those cleats up, brother. Let's go.
So what do you do for a living?
I have my CNA certificate.
I'm going to direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
I was hanging out
I
with
think I
Miss
kind of
Corey.
got a little ahead of.
Oh. Mr. Brooks, just, I'll let you interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021, before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Yes.
Objection. In grounds for, I object to that in grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
The
with the-
objection is from the state is overruled.
Her being drunk has no bearing on your charges.
Do you remember the question?
You asked me what we were doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's hard beverage.
Ooh.
Do
Okay.
you
Oh,
recall
I understand.
around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interaction, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Thinking hard. Thinking really hard.
Is that usually the name you refer to the alleged defendant by?
Nope.
Refer to him as asshole. Probably.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park and she went her other way with her friend.
Do you recall who that friend was?
Nick.
Yes, she's regretting the fact he's a successful
assuming-
lawyer now, and she dumped him.
Or let me back
Oh
that up.
no, that's perfect.
Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
You threatened to beat her and then abducted her? Yes, Adriana. Yes, his defense is, I could have run them over. I was too busy beating the shit out of my
Do you
girlfriend.
recall if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this is a street, it's like a hill. Went up there, And then me and you got into an altercation. I get out of the car, walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering your question.
Um,
You asked her where you drove from. Go ahead.
What?
Finish.
yes, ma'am. And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was I walked back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's something going on.
And did you ever arrive back at Frame Park?
Yes.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me some more. I walked back across the street, and by that time, Miss Corey had walked towards us to meet up with me.
You made reference to you calling your friends.
Mhm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone. Her phone kept going to voicemail, and I called Nick's phone. He put Corey on the phone. I said, Darrell Brooks had just hit me.
Guys, I really don't. I could sit here and go, oh my God, this is horrible. You guys, this one, you guys know this is bad. This is absolutely atrocious. You are not, this is going as bad as it could go for Darrell, really. Except for, like, she hasn't included yet when you rape me as a little kid. But that'll probably come out.
I'm going to back up a little bit.
I'm sure you do.
To the day prior, November 20th.
Well, Regina, it makes him sound like a piece of shit who likes to hit
You
women.
recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. On the Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Yeah, guys, this is the problem. This doesn't.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
Funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection. Move to strike the answer and the question.
Grounds.
Lack of personal knowledge, hearsay.
Sustained. I'll strike the question and the answer.
Good objection.
The reason stated, serve rephrase, or
So can I show the witness the same paperwork that I attempted to show?
no.
No. Unless she wrote it, it's not a report like hers.
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No.
No.
Next question.
No, that's not. Oh, God almighty, dude.
Any reason why it would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Since that's not in evidence, sustained.
Grounds for the sustain.
The records.
Sustain those grounds, Darrell. Let's go.
So upon speaking to Detective Goof during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright. I just didn't tell him everything right away.
Well, I would object. That's super argumentative.
Why not?
I don't know, Mr. Brooks.
Ooh, she getting mad. She bobbed that head. Mm-mm.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. I told him the next day, Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, like a little.
Were you injured?
Ooh,
No, I didn't have any marks on me. Is that what you're asking?
but you hit her.
So where were you injured?
By my lip?
Objection. This states the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents
I
from
don't know.
November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
One second.
Yeah, you're gonna need more than 1 second here, man. Chris Corrett for $5. You know he wants to hit her. He's picturing it in his head right now. Oh, I know he does. Especially if she did that. He is getting pissed
So what time
off.
did you meet up with the alleged defendant on November 20th,
100%.
2021?
I don't remember.
Was it morning time? evening
Afternoon.
time? I didn't hear that.
Afternoon.
This isn't working out like the way you think it does. Yeah, 700 people watching, guys. Thank you for tuning in. Give me a like if you like what's going on, guys. We can try to take down law and crime today. They deserve it. Couple of questions real quick. Tons more Cowboy saying, is it possible he's trying to accidentally get the DV info to the trial and then claim mistrial? No, you cannot induce a mistrial like that. If you do it on your own, that's your fault. So
And what
if
were
he
you
brings
doing
it in,
prior
that's his fault.
to
The evidence stays
the
in.
alleged meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
Rounds.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Next question, please.
When was it answered?
Answered previously. It's answered in a previous testimony. Anyway, guys, yes, he can't force a mistrial to happen. He can't prejudice himself so bad and then claim mistrial. If you prejudice yourself, that's on you. So if he tries to do that, he brings in all the DV stuff that he, basically slits his own throat. Paul Fashilo says, "Can this dumb fuck object to an objection?" Not
So
you
to
don't
the
really.
best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Seems facts not in evidence. Mischaracterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
perhaps for a
question.
legal finding of fact
She
and a
just
legal
did. She told
reconsideration
you.
of that ruling, Your Honor.
Denied. Noted for the record. Next
She
question.
made a finding. It's
I'm trying to
relevant.
figure out how something got pulled out of thin air.
yes, you pull a lot of things out of thin air.
Interesting.
Not really. You're not very interesting, Darrell. You're very boring. Ashton Francis for $2 says, "Judge, the gremlins ate my paperwork." Judge. But Paul, yes, can you object to an objection? You don't really object to an objection. You object to the judge's ruling.
So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes.
Is that the only child in common?
Yes.
You have any other children?
Objection.
It has
Grounds.
nothing to do with the case. Sorry.
Hold
I'm
on.
sorry,
There's
Your
been
Honor.
an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant?
How does it matter that she has other children with someone else? I mean, it's literally not relevant. What does it matter that she has children with other men? That doesn't do anything to your case, Darrell. It does not make it any less likely you killed 6 people and then injured another 70.
The child that you have in common with the alleged defendant, how old is that child?
15,
Do you keep regular contact with that child?
off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
It's not relevant at all.
Sustained.
It's not
It's not
relevant.
sir.
How does this affect whether or not you killed people?
She answered it.
Next question, please.
This is just nuts. So
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds.
Relevance.
Sustained, not relevant. You don't have to answer that.
yeah, this is all bullshit. None of this matters. This does not affect what happened that day.
Do any of your children live with you?
Objection.
Grounds.
Relevance.
Sustained.
I mean, are you trying to point out she's like a crack hoe or got issues? She can't keep her kids. That does not affect
Grounds for
your
sustained.
case.
Not relevant.
How does her not having kids make it less likely you killed someone?
That goes to credibility, Your Honor. So
No, it
it's not
doesn't.
relevant.
No, it does not.
The objection has been sustained.
The fact that the county, the state may take her kids away doesn't mean shit.
I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record. I direct your attention. to
You're not
96.16.
appealing it now, interlocutory wise, because you're an
The
idiot.
basis for the objection being sustained as it does not fall within the categories listed. Next question.
Is that lawful law?
As opposed to an unlawful
Next
law.
question, please, sir.
I'm
Yes.
getting there. This is lawful law.
Yes, Dirk
Wisconsin
Diggler.
State Statute 906.16.
Yes, Dirk Diggler. Switchy
That
time.
doesn't answer my question, but okay.
Yes. All right, we're gonna answer another question. Yeah, Paul, I hope that answered your question. If it doesn't, please throw something back out there again. We'll try to catch it. Vince, yeah, you asked this earlier, but I just want to cover it again. There is no summary conclusion. The judge can't do that. Thank God they can't. That'd be terrifying. Well, that's a good question. Eliza Krogan for $5 super sticker. Thank you very much for the sticker. I appreciate it.
Where did you meet the alleged defendant?
Reno, Nevada.
How long have you known the alleged defendant?
Oh no, this is gonna be
16
bad.
years.
It's gonna be bad. We're gonna get into the kitty raping.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No.
Probably somewhere very creepy and disgusting.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming That would mean no contact at all via phone or anything like that.
No.
He's gonna fuck this up.
So my question would be,
He raped her. He raped her when she was 15.
I don't know if you can see him from here, but do you recognize these pictures?
Objection. Objection.
You need to show those to the state. The bailiff will take them.
Nobody. He raped Erica when she was 15 years old. He was 25. She was 15, and he raped her and got her pregnant. So yeah. Object. Prosecutor, object,
I'm
dude.
gonna object to those being shown as a witness. They have no relevance
Yes.
whatsoever to this trial.
Yes, they do.
No, they
That's
don't.
how I'm getting to how they have relevance.
They've also never been disclosed to the state
Yes.
before this moment.
Sustained.
Yeah, well,
Sustain
that's
why?
it's
Not
not relevant.
They are relevant. It creates foundation. And I can prove that.
Vince, we'll get to
I'll
this.
Take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well.
No, they don't. They're objecting.
You stated that there's been no contact. How would the alleged
Exactly.
how would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Some suspect, not inept.
Grounds.
Sustained. Since that's
Grounds.
not evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
It doesn't
Mr.
matter.
Brooks, assumes facts.
This is a
not
murder
evidence,
trial.
And
It's
at
facts.
this point,
I got the pictures right here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged,
Ooh.
the dates that are
Yeah.
charged for these allegations, you are absolutely
Ooh.
correct.
Thank you.
Ooh, that was a fuck up by the judge. Yes, it's an alleged violation. That's not a violation. That's not going to be fatal. But come on. But anyways, guys, yes, for the relevant grounds, for relevant things here, yes, the Brooks Coffee Company out of Waukesha, Wisconsin. You can get your mug at the merch link below.
Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Objection.
Grounds.
Once again, no relevance here.
Grounds.
I'm going to excuse the jury. I'll rise for the jury.
She's going to yell at him, but I think she might let him make a proffer about how this evidence is going to show any relevancy to his lack of guilt in this case. Oh, Rainbow Bright, no, I got your super chat starred. We're going to get to it in a second. We're going to get to that. Don't worry, I got it. I started it. Amanda Page says, I need a sticker, please, Sean.
Thank you. Be seated.
That's awful funny. Your Honor, I find
Oh,
it.
hold on.
Yes, under review. The jury's getting their 10,000
Sir, I'm going to
steps
let you make
today.
an offer of proof as to why you believe the
Yes.
photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
What does the proof have to do
It
with
assumes
this
the fact,
case?
not an evidence, but
You
what
want
is,
the letter
hold
too?
on, hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to
It's,
her
it's
testimony.
relevant because it was testified to her first time testifying, and then also by was the last guy, Guth?
Yeah.
That he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak
Did
and have
you want to
contact?
open up the door to the other act's evidence of?
That's
you
not
used-
open.
No.
Yes,
That's not
it
opening
does.
the door.
Oh,
Hear me out.
yes,
Oh, yes,
it
it
does,
does.
brother.
No, it doesn't.
These witnesses have been incredibly
There
careful
you
to
go.
abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts of evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact or not, you are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
Yeah.
But you can open the door to that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Over to the state.
Come on, man. Y'all know that's not right. Y'all know that's not right.
Whatever happened on the 20th doesn't matter because you murdered people on the 21st. It may become relevant,
but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. When did you receive the document?
Okay, but I just want to stay for the record.
Just listen to her and answer the question.
That's kind of biased because the
dumb motherfucker.
State did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have.
Answer her question.
That is
she will walk you through it.
She said it herself.
No, marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair.
55 IQ.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So do y'all want the letter?
I want to see the letter.
What?
I want to see the letter.
Okay, so I got.
And I want to know when you received it.
I got to bring that in.
You didn't bring it.
This is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not
because
sir,
the state
there
has
are
their
proper
shit together.
Procedures, and I want you to
that
make
the
a record.
procedure.
If you don't make a record,
so
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is.
Smooth brained guys, still right now.
Mr. Brooks,
Smooth brained.
when you aren't
Stop
even
it.
letting
You're a
me
public
ask
servant, Your Honor. I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee.
Please don't do
that.
Or
is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson, please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen.
Darrell ain't paid too many taxes, I bet, Patrick.
No, it didn't happen.
So I'm going to make a record about what he's referring to in count 77. Okay.
What happened to that paper? Because it was on the table. Then when
Mr.
I come
Brooks,
back in,
I need to make a record of a variety of things.
So who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
okay,
sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's I can't answer. It was dismissed because the
they don't have to
request was
articulate
made,
it,
sir. They don't need a reason.
They can
There's
dismiss
a
whatever they want.
abundance of case law about prosecutorial discretion, and they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know.
Yes.
You know what? I'll indulge you.
Yes, he says,
Attorney
I want
Harper,
more
would
charges.
you like to
Give me the
provide a
charges.
basis for why the state
What a stupid
sought
idiot.
dismissal of that charge
I
prior
object
to
to
the
that
start
dismissal.
of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in, and now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No, I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
paper.
Did I point the finger at anyone? Did I say anyone?
Then where'd the paper
Not
go, Darrell? Why are
directly,
you
but
so mad?
indirectly you did,
So
sir.
how can you make
You
the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you
yes,
interrupting
you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents. I don't know what happened. Things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms.
But
Patterson.
papers.
And if
Oh
I
my
need to,
God.
I'll have a bailiff
Darrell,
put on
brother,
the record that no one touched
you need some
your
Jesus,
table.
man.
Your Honor, did I say anyone touched my table?
Yes,
I
you
didn't-
did.
You
You inferred.
implied it, sir.
But
You
did
said
I
who
say
took
that?
it. Yes, you
I
did.
never
You stated it implicitly.
100%.
I never
you
asked
did.
the bailiffs, hey, did anyone of you touch
You
my
said
table?
someone
I never
who
said
touched
that
it.
to them. I just said I can't find my paper, which is the truth.
And
No,
the way
looking
that
down.
you said it,
more than that.
like,
I didn't point anyone
With
out
with-
though.
and like,
I
well,
don't
that's
think that
kind of
that's fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
words
what
to
I
that
said,
effect.
but I did not point the finger at anyone.
So
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that,
Yeah.
then that would be more of a
Yeah,
validity
he said who
to what
took my
you're saying.
paper. Where'd it
I
go?
need to continue with the record, sir.
Oh, God.
It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
Oh, God.
So-
you're fucking killing this, dude.
I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right. Then there's the statute on bias, 90616. All right. And none of the questions, as I heard them, went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters actually over a period of time. It wasn't, I referred to this one because this one had the picture.
So you had him for a while. You
But-
should have
And
disclosed
why
them.
do you believe
one-
it was from
to
Ms.
answer your question, to
Patterson?
answer your question with clarity,
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter. I brought the pictures because I thought, from my interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness
We need the
knows that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing in jail. Oh, this and this and that.
I
Oh,
don't think
you know, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that, but I don't believe she
But-
ever said that. She specifically said today when you asked her, why did you, it was either why did you go back or why did you have, I'll look at my notes. And she
It was
said,
why
I don't know.
why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from
Weapons
her,
grade
these
stupid.
pictures are from her, how does it
Your
relate to
Honor.
her credibility before the
Who
jury?
else could these pictures be from?
Okay, great.
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got. What do you mean sign? No
How do
one
you
signs
know?
letters.
What's your belief?
Yes,
Why do you
people
have a
sign
belief
letters.
that they are from her?
I have multiple letters from her.
You're not answering my
Why
question.
didn't you bring them with you, you dumb
Why
fuck?
do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean sign?
Did she write her name?
Love
on the letter?
Erica.
Was
Are
it the
you-
content
are you
of the
kidding me?
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which
Don't
I
use
know
that
is
phrase,
true,
Darrell. That's
you've
not
never been
good.
in my
That's not a
position.
good
You've
look,
never been in
brother.
jail. So you've never received a letter
Don't say on a limb.
from someone writing someone in jail.
Kurt will love that joke.
No
Love you,
one's
Kurt.
gonna sign.
And you're
When you
Caucasian.
You're
say
not
to me-
answering my
when you say
question,
to me,
sir. What's
did-
the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom,
Why-
could be, I'm just saying,
Why
could
was
be anybody
somebody?
else.
This is,
You got to answer my question. It's
Your
called an
Honor,
offer of
this-
proof.
It's the
but you
offer of
still
proof.
got to understand why this is mind-boggling to me. Like how
That's because you don't
I got a
understand
child
how to
with this
do
woman.
this.
Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these
That's
letters,
how you
sir.
show
That
you
might
know
be
it, sir.
through your own
Ridiculous.
testimony. So that I'm trying to
That's how
figure
you
out
show it,
why
Darrell.
you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. And you
Because
can
they're
answer.
from her.
And that's what you
But
say. I
you're
recognize
Like
the
assuming-
handwriting.
how else am I supposed to answer that?
The manner of speech, how she
I've
answers
given you a
things.
few reasons why
I
it
can
would lend
recognize
to
it.
that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're going to question her on that, the state absolutely has a right to see the letter.
Yes, they do.
So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that or question this witness
They do.
and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm
He's
not
just being a
allowing
bitch
this
now.
line of questioning.
Well, I ain't listening. I ain't listening. Don't his
Do you
best
have
Nick
the letter
Rekieta
with you
impression.
in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And
yes,
everybody
we can
assumes,
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic.
because it's not a tactic. It's
What we're
facts.
talking
It's
about
facts.
to some other reason.
It's facts. Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make
stop.
a record
No, but
of
if
why
we
they
hear
find
you,
this
we just-
objectionable because I
we
haven't
hear
let them
you.
do that.
We
I've
100%
given
hear you.
Multiple opportunities to tell me why you
So
believe
I
it's.
didn't get
It's
these
facts.
pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right, I'll ask the state their position on all of this.
Christ almighty.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him.
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that
I'm not
because that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish,
don't open the door
Mr.
on that, no,
Brooks.
since he want to make a record and not be accurate, so let's be accurate on the record since you think you know so much.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on
being
we can open the door on how old she told me she was when we met.
interrupting.
We can ask
He's-
that
he
question
is
to me.
over the
That's
top.
never
Ask
a
that.
defense,
Did you
no.
know that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter,
Damn, early lunch
it
for
is
everybody.
shown- it is inadmissible. She will not be questioned. And under 90611, I will declare the cross-examination. closed. Thank you. We're in recess, 1 hour.
Yeah, you fucked a little
Get your
kid,
facts
Darrell.
straight.
Get your facts.
So let's open the
Facts
door on
straight.
all of it then, so we can get all of it on the record. Since you think you know so much,
Uh-oh, he's getting all mad.
did you know she said she was 18 when I met her? Did you know that?
Woo! Ooh, God, that was good. Hey, can't beat live TV, folks. Can't beat live TV. Can't beat it. Yes, both as good's right. Yeah, let's tell the jury about you raping a 15-year-old and then saying she told me she was 18. Let's tell them that. Let's see how that goes. Good idea, Darrell. Bold strategy. Let's see if it pays off. Okay, guys, if you guys were commenting in the meantime, I didn't see it. My bad. Also, 789 people here. Guys, thanks for tuning in. Please give me a like if you like what's going on here. If you guys are just tuning in, my name's Sean Martin. I run a channel, Potentially Criminal. I am a defense attorney in Cleveland, Ohio, and I cover criminal defense topics. So here we go. I'm going to try to answer some questions. We're trying to catch up on some of this stuff here. Night 1007 saying, real question here. I understand it's sovereign citizen BS, but what does he think he's accomplishing by saying grounds? What do I think? He knows attorneys say this, so he's using attorney words. He doesn't know what they mean. But that's it, really. He says, when there's objection, you can ask for them to state their grounds. And that's true. If I'm asking a question and the opposing party objects, I could say grounds for the objection. So yes, it's a word, but he doesn't understand how to use it. Daniela, new member. Thank you so much, Daniela. I appreciate your support. Chris Kelly for £2 sterling of the King's sterling. Please accept for value or return for value the super chat. Yes, thank you, sir. Daniela says, is it possible that another prisoner has been feeding him the soft sit arguments, setting up to humiliate himself and fail? Another prisoner probably has been giving him all this nonsense. It has been floating around the jail. The worst thing in the world is a jailhouse lawyer because they're in jail, so obviously whatever they're claiming didn't work. But is this to set him up and fail? No, because these guys actually believe all this nonsense. They think it'll help them. Diamonds and Henna says for $1.99, great coverage, Sean. Well, thank you. I appreciate that. Rainbow Bright 13. He is thank you for the super chat, by the way. For $4.99 says he is absolutely ridiculous. He just wants to harass her. Is he trying to blame her for what he did? Yes. He's also, for whatever reason, he seems to think if he can show that the whole domestic violence case was BS, he's focused on that, but it doesn't change the fact you still ran over and killed a bunch of people. But once again, he's an idiot. Nobody's alt but mine says, are you a Buckeyes fan? No way in goddamn hell am I a Buckeyes fan. I'm a Michigan fan. Kevin James Pa says, can you make an is that lawful law mug? Yeah, I'll work on that. That's funny. We can work on that too. Vince Clortho says, what if the jury, this is an interesting question. What if the jury comes back with not guilty? Can't judges call BS, set aside the verdict? I mean, no way Wisconsin lets him walk if the impossible happens. Okay. The judge cannot overturn a not guilty verdict. Okay. A not guilty is not guilty. End all, period, full stop, done, bam, boom. It's over. If the jury convicts someone and the judge does not believe that a reasonable jury could have done that, and there are evidentiary issues that the state failed to meet, the judge can set aside a guilty verdict. So the judge can set aside a guilty verdict, but they cannot do it the other way. Okay? So it's a one-way street. You can only overturn a guilty verdict at trial. And then pretty much, I mean, even on an appeal, you can't really appeal a not guilty verdict. In America, not guilty is not guilty, not guilty, not guilty, not guilty. Full stop, done. Naked Lunch for $4.99 says, I'm sorry, what does this all have to do with his ex, the Christmas parade killing? This sounds more like a custody hearing. True. What of this? Okay, those are my kids. Okay, great, Darrell. How does this make it less likely you killed these people and drove through the parade like a lunatic? How does this support you at all? It doesn't. But he's an idiot. And also he wants to, do his thing. This is a man airing his grievances before the world. AC for $5 says, I've lost all patience for this judge. With every engagement, Brooks' tantrum, she continues to say exceedingly dumb things. Yeah, she's getting exasperated, but she's doing the best she can. This is not easy. This is not easy. Chaucerian Fraud says, he just said this is not a joke and nothing is funny, yet now he's saying this is a funny situation. Yes, and and more ironically, everything he does is a funny and hilarious situation. Even though it's frustrating, it is funny in a tragic way. Fuck says, I just said on the wall. Yes, on the wall. Yes, Darrell. Yeah, another place, another time. Darrell goes on the wall. D Soul for $4.99. Thank you for the super chat. Says, thank you for the commentary, Sean. My new favorite channel. I appreciate that very, very much. Nobody's all but mine said, so did he open the door? Are they going to hear he's a kitty diddler? No, he has not opened the door yet, but the prosecution has, and I think made a very valid argument. If we go down the road of why she's a bad mom, why she doesn't have the kids, your kids don't live with you, okay, because she's a bad mom. Why is she a bad mom? Well, she got knocked up when she was 15 and sexually assaulted by you. So he's on the verge of opening the door, but the state is warning, and I think it's fair to make that on the record, that he is pushing his luck and the court's trying to avoid it, because that stuff would be horribly impermissible and unfairly prejudicial, because none of that has any bearing on whether or not he killed 6 people and wounded 60 others. That is the focus of this case. Then also bail jumping, then domestic violence. None of that has any bearing on those allegations. So it's everything's, all evidence is prejudicial in some form, but is it unfairly prejudicial? And him being a kitty diddler would be very unfairly prejudicial unless we're talking about him diddling some kids. President-elect 4 Doors More Horrors for $1.99. Thank you. Says, jury, I unalive children, but I create more with them. Okay. Sam Walter says, so just confirming here, if not guilty, the state, if he's found not guilty, the state cannot bring charges again because that would be double jeopardy. Not like Brooks has a shot at that. Yes, if he went on trial, if the jury came back and said not guilty in all counts for murder, all 6 of them, that's it. He can never be retried for those murders ever again. Now, let's say he got convicted of the other 70 counts of felony assault he committed. He's still going away forever. But yes, any not guilty, you can never be retried on it. Now, let's say there's a split verdict. Let's say a couple of the counts he's found not guilty, but a couple they're hung on. Okay, the not guilties are acquittals. Acquittal is final. You can get retried on the things that were not. If there's a hung jury on, let's say of the 6 murders, 3 are acquitted, 3 are hung. Okay, well, if it's a hung jury, they can retry the 3 murders, but the other 3 go away. So I hope that makes sense, guys. If you don't get that, don't be afraid to keep asking. Cole Springs for $2. Thank you. What more should she be doing to reel him in? It's difficult because he has the right to conduct his own defense. I mean, I don't know what more she can do. She's trying. It's hard to do in this situation. Diane Brown says, or Dion Brown says, or actually it's Diane. Was Erica on witness stand for all that? Initially, she was sitting there, but then the prosecutor said, wait, can we excuse her? And she doesn't have to sit there and listen to all that. And they don't want the witness to listen to all of that because that can poison the witness's testimony. So they kicked her out. So for most of that, she was gone. America Virtual says, isn't the cross-examination closed? No, not yet. We're still on direct. We're still on direct presentation of evidence in this case. We're still in the direct testimony. So that has not even finished yet. Vince Clortho for $2. Thank you. Says, accept this for value and return for value. I do accept this for value and return for value in the same manner. Thank you. I need to kind of kill off the stars as I'm going. K-Brag for $5. Thank you very much. I say give Brooks the W and admit the evidence. Bust that door wide open. Yeah, but remember, this is about not getting it overturned on appeal. Because if it gets overturned on an appeal, they could say he was unfairly prejudiced. Now, the worst case scenario is they could say we're dismissing charges. He's acquitted. But more likely what would happen is they'd say a new trial. Now, think about how long it took the prosecutor's office to get this trial prepared. All the witnesses they had to talk to, all the things they had to corral, all the preparation that went into it. They would have to redo it. Now, yes, they can recycle certain things, yes. But the people hours and the actual money in retrying this case would be a disaster. Making those victims, that band director, get back up there and talk about her kids in the band as she watched them get run over. And she knew each one by their names. It was Aiden was the first one that got hit. He got hit first. And you could hear her talking about all that. Making each one of those people come back up here and relive all that. No, you don't want to do that. You want to make it stick, and you want to do it as cleanly as possible. They've got more than enough out there to convict him. He's going away. He's never coming back. It's not worth the risk. That is a very dangerous gamble. And it's unnecessary. You've already won. You don't need to push your luck. I agree, though. From us watching it, it sounds awesome, and we should hope they do that. And it would be hilarious to watch, and it would just be so ooey gooey good. But for the sake of the legal part of this, you don't want that to happen. Plexity says Michigan fan. Christ. I mean, is Jesus a Michigan fan? Maybe. Russell McHenry says, Sean, would an appeal court hear all this BS that is said when the jury's out of the room? Yes. There's a court reporter. She's sitting there with her little computer pad, and she's typing away. And that gets transcribed into a transcript, and the transcript comes out as a big set of papers full of everything that's said on the record. So every time he's been in there bitching and crying about subject matter jurisdiction, that's on the record. A couple days ago when he had that 50-minute tirade of all the problems he had, that's all on the record. That all gets typed out, and an appeals court would have to read all of that nonsense. Brittany says, do a lawful 90611 mugger sticker. I'm trying to come up with something for that. I'll come up with something there. Justin Smith says, is it only 6 jurors? No, this is a 12-person jury. That's a lot of in most states in the North, you get a full 12-person jury. In the South, it's weird. You can get different variations of it. But yeah, most of the Northwest Territories. So like the first couple of states that got admitted to the Union after the Revolution. So like Ohio, Indiana, Illinois, Pennsylvania, or Ohio, Indiana, Wisconsin, Michigan, they're all 12-person juries generally. You don't get to deviate from that. Some other states let you get down like 6, 8, 10. We don't do that in the North. It's a 12-person jury. Let's see here. Just a map nailed to the wall for $10. Do you think his mother is a cartographer, or did the streets just lure him to the playgrounds of Reno? Why the heck would he want this public? Okay, first one. Is his mom a cartographer? No. Darrell seems like a shitty human being. That's pretty straightforward. Why the heck would he want this public? Because he's an idiot and he's so focused on terrorizing this woman and his moronic view of a defense. He's not understanding that he's literally on a pogo stick hopping in a minefield and he doesn't realize it. And people are trying to stop him and he wants to do it anyway. Making it known to his future lifetime friends. Yeah, that's the other issue. Now he's put it on blast to the whole world. He's a chomo. That's not good luck. Do you think the way he's being aggressive toward the judge today, that the shock collar around his ankle should have been used? No. A taser, that's no different than a taser. So you have to have a serious grounds to use force on someone. He is not being violent. He is not threatening violence, and he doesn't appear to be getting ready to be violent. He's just being loud and obnoxious and combative. So you can't just zap somebody. The use of force still exists. So those sheriff's deputies have use of force policies. Those policies are also grounded in constitutional law. So they still have to do it right, or they could be liable for abuse of power. They could be charged with, crimes if they do it. Because if they shocked him right now, that would be assault. You have to still follow the same rules. Jarvis Das says, I will go back to this, Wayne. This is a really good question. I think it's actually very good. So thank you for asking. Jarvis says, when Darrell's found guilty, is it life in prison or death penalty? Wisconsin has no death penalty. This is life in prison without parole. So when he gets convicted of these 6 murders, which he will, he's going away forever and never coming back. And they're going to be consecutively imposed, most likely, on top of the other felonies, which is going to be a couple hundred years. What is it in him? What is in it for him to keep delaying the trial? Prolonging the inevitable. He probably also enjoys the fact he's causing problems and dragging stuff out. This is his last hurrah. Chaucerian Fraud says, can you touch on the topic of a minor lying about their age and whether or not a fully grown man is still responsible for impregnating her? Okay. So if you have sex with somebody and they're underage, that is considered a strict liability offense. It doesn't matter that they lied. It's your fault in almost every state. They could be sitting at the bar. They could have a passport. But let's say you're on the airplane with them and they're ordering drinks. They're using their passport to show. You follow them through customs and the passport scans 100% perfect. So the most critical document you can ever own is a passport. Okay. If that says you're valid, you should be valid. Sorry, not enough. Now, under federal law, mistake of fact about the age is a defense if you were lied about it. If the person represents their age as something else, that is a defense at the federal level. In most states, you're toast. So that's pretty much it right there. I thought she was whatever. Doesn't matter. Even if she lied to you and you have like 1,000 pages of it in emails, 1,000 people heard her say it. She's got fake IDs. Doesn't matter. Most states are screwed. So you got to be careful. Why don't they let him open the door, Diamonds? I'm going to address this with K-Bragg. Yeah, I understand that. I hear you, but you want to see the prosecutor rip Brooks to shreds for being a child violator and running this poor girl over with a car. Yeah, I mean, we all do. We all do. And like you said, it'd be popcorn city. It'd be great, but we can't. We can't risk it. Almost 1,000 viewers. Yeah. Guys, please, if you're liking what you see here, please, smash that like button. I hate, God, you know what? Don't smash the like button. Click the like button. It's so cringe when people say, smash that like button. Just click it. Husker fan says, sorry about this question. There's no such thing as a question to be sorry about. The person who was sick, did they replace on the jury? One of the people who was sick was an alternate. So one of the jurors who's not actually on the 12-person panel. So they dismissed that person. It wasn't an issue at all. Donovan says, when his mom testifies, are all their prison calls fair game or just the ones about her testimony? Probably just the ones about her testimony. And unless there is a phone call where he talks to her saying, hey, I need you to get me these baby pictures, then yeah, anything relating to her testimony could be brought up or things she said to Darrell. Tom Forsyth has says, whatever happened to gavels? I've been in probably front of, in my time, all over Ohio, like 40 or so felony judges and maybe 60 or so municipal court, like misdemeanor judges. And then there's, probate judges and juvenile court judges all along the way. I think only I've seen a handful ever use a gavel. Most judges don't use a gavel. It just sits there on their bench. And usually it's like a really nice one that like their family got them when they took the bench or somebody else got them. They're very ceremonial. Most judges don't use them. Most don't anymore. That's a dying thing. If I was a judge, I mean, I don't know if I'd do it. I don't know. It seems kind of cringe to me. If the pictures get admitted, can the state call his mother? Well, for now, they're not getting admitted because he doesn't have the proof. How did you get these? And this goes back to the letter. Well, he's saying, I know it's from her. And the judge was trying to explain to him. And then you're going to have to explain how you know it's from her. And this is where him testifying and him having the witnesses structured out right could have been helpful. And he could say, like, I recognize your handwriting. And this idea of, like, people don't sign letters. I love you, Darrell, love Erica. That's signing it. Does he recognize her handwriting? Is it in the same manner of speech that she always writes in? I've got a bunch of them. They're the same thing. Now, it sounds like Darrell has admitted to he's had these letters for a long time. Well, if you have a duty to disclose evidence to the state, and the state has a duty to disclose evidence to you, if you're going to use it at trial, they have the right to look at it to make sure it's a good ahead of time. Now, there are exceptions to that, such as for impeachment purposes, or if something brand new comes out of nowhere. But he's had these, he hasn't provided them. They're not going to come in. Alpha Fox says, everybody, Darrell Brooks, that like button. Yes, hit that like button harder than he hit those people in the parade. Oof. Oof, oof, oof. Oh my gosh. You guys are something else. Before we get too far, I did want to mention to everybody, if you do like having relevant grounds and if you do like Darrell Brooks and all the grounds he's been serving up here, I do just want to offer this as an option for you. Because what's good about being on the internet if you don't chill? You can get yourself a version of the Brooks Coffee Company out of Waukesha, Wisconsin, serving relevant grounds since 2022. And I can tell you, it's a good mug. You can find it at the merch link there. And I know some of you guys might complain it's on Teespring, but I don't really have another option set up. I am working on fixing that, but for right now, that's kind of where we're going with it. But if you guys want one, there you go. Also, in the meantime, I am on Locals. I'm at potentiallycriminal.locals.com. I'm on Rumble at Potentially Criminal. Also, by the way, hey, everybody on Rumble. Hope everybody's doing well. And actually, we'll check in and see how many people are there. Oh, 21 people watching. Oh, Wrestler Town for $2. Thank you. You got a Rumble rant. I faked the technical difficulty to get out of a meeting early for this. It was the right decision. Oh, no, that's so funny. Well, I'm hoping it's worthwhile for you, man. I'm hoping it's worthwhile. I hope it's worthwhile. So funny. Oh. Sam Walter says, I get why you and Ricada state this is important, but Jesus, can we end him already? In due time, he gets to do this. Don Marie says their kid is 15, so old baby pics. I think so. I mean, those look like they were on like old camera, like, digital camera paper, like film. So those look like they're older or like they're reprinted, certainly. Yes. Oh, you know what? I need to send a link to somebody real quick. Get on Twitter here real quick. And sorry, I'm gonna get this out there. Might have some guests coming in the afternoon. It all depends whether or not they can make it. Although, to be fair, this has been an agonizing thing to sit through, so I'm not sure they're going to want to. So, all right, we're back to what everybody's talking about. Just a map says, if we cross 1,000 viewers, will you shotgun a White Claw, or is that not a lawful law? No, we won't. But I'll have one because we're almost to noon. We're in the noon hour now. Yes, oof, big oofs. Yes, Sam Walters, beep beep. Yes. Okay. Are those photos certified? Yeah. Oh, I'd love for the prosecutor to make that argument. Okay, this is a good one, Crispy Snickers. Is the prosecutor allowed to talk to the witness during the break? No, not really. Now, it's not their witness either. It's Darrell's witness. So, I mean, they could go up to talk to her, but generally speaking, you're going to stay away from that person if they're not your witness, number one, because if you start screwing with somebody's witness, that is an issue the court will not like. But if let's say it was their witness, let's say it was during their case in chief, you might you're going to sit there with them and you're like, okay, look, you're doing fine, just keep going, everything's okay. But you can't talk to them about how to say things or like prepare them like you would pre-trial. You're not going to do that stuff because technically they're under oath and they're still in the middle of their examination. John Bubba says since he's claimed and repped Bloods, would locked up Blood members want to take him out or protect him? I don't know. It depends on which Blood. Every set of Bloods has different rules on what you do and can't do. Ron Bacardi says, you want to see a judge lose it? Check out the state of Georgia versus Denver Allen. Yes, I've seen that. That is a very hilarious thing, especially the Rick and Morty version of it. Potentially criminal says camera out of focus. Seems okay to me. Also check Discord. Uh-oh, what happened? Did somebody poop the bed? Oh, okay. Yeah, I open original. Well, I guess we'll show it because I did not see this and it's not showing up in StreamYard, but I want to make sure there's credit for it. Carlos Ramirez, been a member for 2 months. Thank you so much for your support. I appreciate it. Love it when you get fired up. Love when you get fired up when it gets good, Sean. Well, thank you very much, Carlos. I appreciate that. And yeah, sorry we didn't see that, but StreamYard doesn't always show these things, and I forgot to have a pop-out window for YouTube chat going. So thank you very, very much. DFlesh60 says, Darrell's mama sent the picture to him. Yes, and it 100% sounds like that if they have the phone calls. Remember, guys, they listen to your phone calls if you're in jail. All right? And you might not think they do, but they do. And it's not necessarily the prosecutors all the time. It's going to be detectives. Or if you're in the prosecutor's office, there's going to be an intern there. And that intern's going to be some guy in law school who wants to make an impression because he probably wants a job. I was that guy. Listen, jailhouse calls anyway. When you're in law school, you're like, oh my God, this sounds so cool. And it's really boring after a while, especially when you're an attorney for real. But yeah, somebody listened to all of that, and they probably, every time he touches that phone, they're monitoring it. Because those phone calls are recorded, they can download them onto a CD right away and listen to them. Why was he complaining this morning before the jury was present about the phone call with his mom? He complains about a lot of things with his mom. He complains about everything. Jay Walker says, if Darrell is sovereign, how can he claim constitutional protections? You're asking you are asking for me to criticize and pick apart and point out the flaws with sovereign citizenry. That is a critical one, and I think that's a fair one, but they always claim that they are only bound by the Constitution. But that's how these guys are. They're nutbags. They're nutbags, and they're very disingenuous about what they do. So that is the problem. Guys, give me 1 second. I need to take this. Somebody leave me a voicemail. I need to listen to it. All back, no big deals here. 900 people watching, guys. Thank you very much for tuning in or clicking on me. So let's see here. Where are we at? This is Brooks Playgrounds. Yes. He's having fun here and playing around. Yep, everything is recorded. Everything is recorded. Bendover says he only has 63 IQ. He's acting like I don't know, but he's certainly not the smartest bear in the woods. Justice Smith says 100% of all jail calls are listened to. Yeah, they will be listened to. Now, do they ever get used? Very rarely. But in a case like this, I guarantee you there are meticulous notes on every call he's listened to, every call he's made. Me Queen says, if the baby in the photo is 15 years old, why do you think he would show the baby pic and not a current pic? Because he's an idiot. I don't know why. I don't know why they're doing this. It's stupidity. That's the only thing. I mean, don't attribute to malice what you can attribute to stupidity, and Darrell's pretty stupid. K-Brag for $5. Thank you again. I appreciate the support. It's saying here, I believe kitty violation and playing vehicular bowling with band nerds and dancing grannies is against a Blood's code of conduct. The first one, yes, but it all depends. I mean, some of those guys might say, well, yeah, if she lied and she like looked 18, okay, and who knows? But yeah, running through the band, yeah, he's not gonna have a fun time with most of the gang members. They're gonna think he's a tool. And watching him cry like this in court, yeah, none of this is gonna make him look hardcore to people. JB saying, yeah, he claimed that his mom told him that the detective never went to her house or spoke with her. Oh, yeah, I'm sorry. Yes, that part, yes. Because they talked about the detective yesterday who had all the video up of him running around and getting in the car. Yeah, he's claiming that never happened, which I think is impossible if they got the video from her. Somebody had to have talked to her. Common sense is dead. This is very clever. Does Brooks legally have to state and spell his name if he testifies? I actually don't know. He could probably say, I'm not going to spell it. The court will say, fuck it. We'll just move on. But yeah, that would be kind of hilarious. Please tell us how you wish to be addressed. Oh no, it's Montegraph. Somebody said, oh, it's Darrell Brooks asking to hire me. No. Nothing I can do now, man. This cake's already baked. T3 is saying his mama snitched and she's telling her son she didn't. That happens a lot. Somebody will say, hey, that person says they didn't tell on me. But I know for a fact they told on them. Because you don't want to lie. I mean, people like to lie and try to be nice. Like, no, buddy, I didn't tell the cops all about you. No, I didn't do this. I didn't do that. When you did. Why? Because you lie to your friends. You lie to be nice. Sarah Beth says monograph is sketchy. Nothing but sketchy. Adriana says, Sean, Darrell's like, please, sir, I need you. You're the only one who can help me. I'll be like, all right, Darrell, tell him to put it on pause. I'll show up. Bring on Monty. I'm not bringing Monty back. No, we're not doing that. Vince Clortho says, what about the personal visits with his mama? It all depends on how those are recorded. If they do the ones where you have to talk to the phones through the glass, those will be recorded. But if they had ones where he could sit down face to face with her, that might not be recorded unless it's probably in a small room. If it's in a bigger, like, visitation room, it's going to be really hard to listen to people. We about to get back to the business? Yeah. Yep. I need to go grab that back up again. Hold on, guys. Here, we're going to back out. Actually, nothing yet from Fox Milwaukee because I'm using them instead of Long Cuck because, well, they're cucks. So let's see what we got going on here. Oh, we got to check the poll in a minute, too. The very important poll. Yeah, Long Crime is still out, so we've got time. But yes, we've got the poll. It's always about the poll. That's how usually it goes. How about chat? All right, so with chat, we've got a couple of polls to address. We got things here to talk about. So, what's the poll say? We're going right now. How will Darrell do today? Out of 1,400 votes, 5%. He'll turn it around. 5% of you. Guy's got to have a little more faith in him. He's trying hard. 59% say it'll get worse. I think you're right. 37% say what the business. Yes, what the business indeed. What the business indeed. Now, you guys were wondering, yes, they are out at lunch currently. They will be starting back up at 1 o'clock. 1 o'clock Eastern time, noon Central time. They took a very early lunch. It just worked out that way. And then, yeah, the judge is going to have him, expect him ready to go. Wheels up. Alpha Fox says, do most jails and prisons have a separate secure phone for protecting attorney-client privilege? There are times where they will let you call out on a direct line if they know you're calling an attorney. But generally speaking, they'll, clients will call me and from the jail and they'll say, this call is being recorded. Now, if they that call, it cannot be listened to. So when I was, for example, when I was in law school and I was an intern, when I heard the defense attorney like pick up the phone and it's like, hey man, what's up? I got stuff about your case. All right. I would make a note, attorney-client conversation, and then I was told skip ahead in it, make sure they're still talking. Okay, skip ahead, make sure they're still talking. Okay, they are. You'd write out the whole conversation as attorney-client privileged. We can't listen to it anyway. More importantly, any attorney worth a shit is not going to talk about something critically important over the phone. If it's super important, I'm coming to see you to talk to you about it. Letters, jail mail, legal mail is protected. It's not supposed to be examined. Now, jails and prisons can open it up to make sure there's no contraband in there, but they're not allowed to read the contents. So basically, they're allowed to cut it open, like look inside, shake it to make sure there's nothing in there, and then send it on to the prisoner. All right, guys, hold on one second. I got another call coming in. Sorry, guys, that was a very important call I had to take. I really had to take that. And no, it was not Darrell. I promise it wasn't Darrell. I really had to get it done. So I am so sorry for that. Dirt in My Eyes says the jail read mail. If you send a letter into somebody in jail, yes, they will open it. They will read it. They aren't gonna like read it, say like ooh la la, what's going on? But they read it and like they open it up and they scan it because you don't normally get the paper itself. That's just a security issue. That way, if in case there's like hidden messages, things like that. There are some people though where your mail is explicitly read to make sure you're not communicating in code, especially like gang leaders or people like Darrell Brooks. They probably would read every single word he writes, and they would get a permission to do that, and they, go through the proper things. So yeah. Crispy Snickers says, my first time here. Thank you for answering questions. Do you think he'll testify? I think he has to. Number one, he's a big narcissist. He loves himself. Number two, he likes to talk and he wants to screw with everybody and make this take forever. So why not? That would help. And then number three, if you're going to tell people like, hey, I didn't actually do this, it wasn't intentional, there's two sides of the story. Well, that implies you're going to tell another side to it. So you have to kind of talk. But once again, Darrell Brooks is an idiot. So who knows what he's going to do? And I apologize. I know everybody kind of left while I had to take care of that. I am so sorry. But you guys are not allowed to listen to that stuff. And oh my God, this is like a serious thing right now. This is over on the lawn. Because I have long crab because I know they're always on. Oh, somebody just popped in. Hello, Nate.
You turned on the thing.
You taught me well, master.
What's going on, bro?
Not much. Hi, Nate. Everybody, this is Nate the lawyer. He is a former police officer. He's also a former prosecutor, law professor, astronaut, millionaire cowboy, and also defense attorney out of New York City. Hi, Nate. Thanks for stopping in.
Thanks for having me. I'm glad you wrote off the resume because Boozy's been saying he's not a lawyer. He's not a lawyer.
Oh, I know. I'm sure he's just been great about it.
So what's going on with the case? Is this guy putting on a good case?
Oh yeah, it's the best. It's the best. I'm waiting for the not guilties. So, and I was just going to recover this. I know we have a bunch of people in here now, and you showed up, and look, the numbers are bouncing back up. I just actually got off the phone. My office called me, so everybody's thinking like, "Oh, Darrell was calling." So no, he this morning he had a witness go on and is done, and now he's got his ex-girlfriend, the one he was beating on, the one he was terrorizing that day. He's got her up on the stand.
Oh my God!
And this is solely to be embarrassing. He's like going back, well, when did we meet? And he's really stepping all over the issue of, well, yeah, you met her when she was 15 and you raped her. So he tried to bring in like baby pictures, like, do you recognize these? And he's going on and on about nonsense right now. And he just had a big fight with the judge over it. And they took an early lunch. And they're about to come back any minute.
Man.
Yeah, it's getting interesting. He got really fired up. And I thought they were gonna take him into another courtroom, but the judge is really holding off on that.
Well, because the thing is that it's very, very, very. The judge has to be very careful because
yes, she does.
If she shows anything about where she's like mad at him or in front of the jury, that could be we have to do the whole shit again. So I know she's like,
I agree.
Yeah,
I agree. Well, I thought she was gonna put him back there just to let him bitch and cry while they were having their private sessions.
Mm-hmm.
I don't think she's going to punish him she can't really punish him like that for direct because that would just be too prejudicial. That would be bad.
Yeah.
But yeah, and it was funny because he said, well, I got these letters, and she said, well, you needed to do a proffer, and she said, you need to show proof how you know they're from the victim.
Yeah, of course.
This girl, and he's like, well, what proof do I need? I know. And it was so funny because she's trying to tell him, you need to explain to me how you know.
Yeah,
and he says, well, I know. And not, but she said, well, are they signed? And he looked at her like, nobody signs letters anymore. And I'm like, Yeah, it's like, and it's fun. And then the prosecutor says, "Well, we know they're not from her because we have a phone call between him and his mom last night talking about this."
Oh my God.
Oh, it was good. It was good.
Listen, I feel bad because I feel like this is like the Today firing squad, right? This guy is going down hard, and he's just just digging the hole more and more and more and more. So my God,
yeah.
Oh, so they should be back at like 1 o'clock, huh?
Yeah, should be back in a minute here. Yeah, so they're pointing out that Darrell's now in law too because he's now doing trials.
There is no law tube. There's no
more law tube anymore. Yes, but yeah, we'll be streaming with him from prison soon.
Yeah. What do you think about this, Darrell? Now we were arguing about this. We were saying is it Darrell or is it Darrell or is it Darrell? Yeah.
I think he kind of has gone by both at this point, and he mentioned it on his video when he's been arrested when they're talking to him and they're kind of smoking and joking in the interview room. He says Darrell. But he says Darrell when he gets arrested. It's yeah.
So is it looking at this guy?
Yeah.
It's funny because at a point I thought he was mentally ill, but I don't think this guy's mentally ill.
Nate, just so you know, apparently there is one of the guys in the courtroom. Everybody thought it was you yesterday. They're like, how'd you get back? Did you see what they're talking about?
No, I did. I didn't see it.
Well, he might be back. The camera might pan again, but yeah, people are like, oh, Nate's there.
Oh, that'd be good. Matter of fact, that's what we've been waiting for. We were all waiting for like a good New York trial to go to. The Kevin Spacey trial was here in New York, but it's just like
it's also federal court. Yeah. Sally Morton says, "Can prisoners get email?" There are some of the companies that do the phone calls, JPay, Securus. They do inmate emails, but yeah, those are all heavily restricted. You have to approve them sending them to you. They have to approve it back. So all that stuff. All communications are subject to interception and observation. Yeah. So be careful what you say to somebody if you know somebody who's behind the wall.
Oh yeah. But you guys got to understand everything that they send out of that place is recorded, and it's funny because we used to have Rikers calls here. The jail here in New York is called Rikers Island. So when I was ADA, when I interned at the DA's office,
I brought this up.
They
said, "Hey Nate, you want to listen to some phone calls?" You're like, "Oh golly, hell yeah, I want to do this." I was that guy too. I was an intern too, and I'm like, "Oh my god, let me listen to them." Then you start listening, and all they do is talk about sex and just really degenerate stuff. You're like, "Well, this isn't really that good." And then every once in a while, they might say a sentence or two, and you're like, "Oh boy."
I would say this every day. I listen to Rikers calls because I did it for like maybe 2 weeks. I always got somebody admitting to some crime on the call. It was no matter what it was. I'm talking about there was one we had a assault in an interesting way, and the person was the whole defense was I didn't do it. I wasn't even there. Guess what? He calls his best friend. They're talking about it. And the best friend says, so he's like, yeah. So between me and you, what really happened? And guess what? He gave it all up on the phone, and right then after he take the tape and give it to his lawyer, hey, this is what your client said on the phone. The client is like, no, I didn't say that. No, I didn't say that. Right? Oh, this is like, but so the lawyer was trying to make the argument that, we can't use it because he didn't know he was being recorded. So then they show like literally over the phone,
preamble part,
the big sign that says, all calls are recorded. Calls are recorded.
Well, there's that too, but I bet you're like, well, I don't know about Rikers, but I assume it also says, every time it breaks, it starts off saying this call may be recorded. And then halfway through, it'll say this call may be recorded. And it breaks in every couple of minutes. Yeah.
Yep.
But I've done that before. Yeah. And I had one when I was an intern and it was a manslaughter case. The guy had, it wasn't clear he had murdered these women, but we were like pretty sure. And he said so much like, I need to own up to this. He's like, I got to get straight with everybody. And just a lot of those where you keep saying it over and over and over again, like this is all weighing on me. And you can give a prosecutor like a whole stack of here's what he said, here's the time he said it, the date he said it, who he called. Yeah, like I said, guys, they are listening. That's the thing. If you're talking about something and these guys in jail like to talk about sex and all the creepy stuff they do, we're listening to that too. Or if you write a letter and you're talking about all the nasty, degenerate stuff you want to do with somebody in there, they're reading that too. So be very careful about what you say.
Yeah, there's always a third person on the jailhouse call. There's always a third person on the jailhouse call, and it's but again, I just don't understand why they give it all away. And it's funny because no matter I've had clients that is told, listen, when you go inside there, don't use the prison phone because they're gonna and they go in there and they spill the beans on the prison phone. I'm like, did you guys listen to anything I just said?
Uncle Buzz says his next record's gonna be over a prison phone. Yeah. And guys, it's not like somebody's actively listening every second, but what happens is that detective or the prosecutor will contact the jail and say, hey, you guys got calls for this dude? And they load them up off the internet, off their little computer program, and they can email them to you sometimes, or they burn it on a CD and you get them that day.
Well, the one thing and how they know, like in Rikers, is that every person has like a unique number to access the phone. Now, what they do is sometimes they'll try to give other people that number, right?
Yes.
But they don't realize that there's also cameras. So you look in and say, okay, when did this person who's making the phone call at that time? And they'll say, okay, so it's this guy. So it's easy to find out who, but that's generally the way we do it. Yeah, I like how now they have break on it. That's great.
Yeah. Well, the other thing though too is, and this is something from my experience, you might try to dial okay, I'm using somebody else's ID number. You're still calling your girlfriend though,
and we always
we can always
number.
Yeah, you can always collate things on what numbers they call, and then you try to do like 3-way calls. I love that when they do those, and the 3-way call is like I would call Nate from jail, and then Nate would get Joe on the line, and because the phone calls sometimes the computers can tell when you're doing a 3-way call, but even then, it's just very obvious when it happens.
Yeah,
especially when you're listening to them.
Yeah. The 3-way call is the thing, but they have their tricks. And I still don't know how they sneak in cell phones because sometimes people sneak straight cell phones in.
I don't know about you, but I've gotten I get them every once in a while. I get cell phone calls from prison. And I'm like, I don't know how you got this. And I'm like, I don't want to know. And I think a lot of times it's obviously the guards letting somebody borrow a phone or phones got smuggled in. But yeah, they, I can understand hooping a flip phone, but yeah, I don't understand how you get that in there.
Yeah, they be get like the new iPhones inside there. They be hiding them around. I'm like, what are you? You can't put this up your butt. It's kind of big.
Hey, I guess it's bad enough you want it.
That's true. Well, I think somebody's getting paid. It's like what Barnes always says. Epstein didn't kill himself, right?
Oh, definitely. Yeah. So, did you watch his opening arguments yesterday?
I did. I watched a little bit of it, and it was insane. But it was just like what I thought. He stood up. He gave like this emotional plea. He didn't really lay out his case, and the judges just allowed him to dig himself a hole. She's just do whatever. So
yeah. Oh, just a map for $5 says, I humbly request we poll the masses as to whether shotgunning White Claws will improve the quality of the stream. No, but it's 1:00, so we'll start one. I'm not going to shotgun. I did that last night, and I don't mind shotgunning beer, but there's so much carbonation in this. Oh, it was bad.
It was bad. Well, listen, right now it's 1:05 here in the Northeast. I wanted to just step in and say hello, and probably it's trying to see if I can catch some of the trial, but now they're on break, and I got to go actually pick up children and stop by the store and pick up some stuff. But are you back on Monday? You're gonna be covering the Monday about this time?
No, Monday I got lawyer stuff to do, so no, I'm gonna be watching with everybody else. So
well, listen, if you're back on my time, when I bring back the kids, I'll definitely be back.
Oh, we are going. The prosecutor and the courts, everybody agreed. We are gonna blow through all of his witnesses today because they don't expect it to take forever. They're gonna try to get everything done today and leave him on Monday if he wants to testify, I think. So it's going to go for a while.
That's going to be crazy if he testifies in his own defense, because he's going to ask himself the questions, right? How do you feel today? I feel very fine.
Yeah. Well, I explained to people he's going to have to do it like as a narrative. The judge will say, just go ahead and tell us what happened. But yeah, we'll be around, Nate, if you come back.
All right. Listen, thanks, chat. And thanks for sending me the link. I'll be back.
All right. See you, Nate. All right, guys, that's Nate the lawyer. He's another attorney here on YouTube. He's a great guy, and if he's around, it'll be very, very funny. When she said did she say 1 p.m.? I thought she said they're only taking an hour. Oh my God, I really hope that they're not taking a 2-hour lunch. That would suck so bad. They're entering the courtroom. Oh, I hear them now. Yes, they are. Let's see what. Fox Milwaukee's back up because I like their feed better than everybody else's. I mean, we'll use TMJ if we have to. Still on break, but I can hear people. Oh, 1:15. Okay. So we shall see. We'll get through the rest of these real quick. Sean, when Brooks gets acquitted, are you going to ask him to join your law firm? Yes. I don't have a law firm yet, but yes, I will partner with Brooks and we'll do Brooks and Martin. Rachel Mills asked a question. Are they allowed to listen on jail calls between you and a therapist or spiritual counsel? That depends on your state. Some states have a penitent and priest privilege. Some of them have privileges between therapists. Sometimes that falls under a medical privilege. It all depends. So sometimes maybe it depends, but you should assume everything you say is not protected. StreamYard, Parallax, there was a Rumble rant. Well, I know there's... Oh, do I have to refresh? Well, yeah, I know about the one Rumble rant. So I already got on top of that one. President-elect Four Doors More Horse says, what the business call? Yes. And I guess while we're waiting for a minute, we'll just check in. There's some good memes that are out here, guys. I think you'll get a check call out of them from some people. I think it's a good meme. Is it fair to say that I've sufficiently proven my guilt? Oh. And then this one here, I think, is funny because it does come from the closed captioning. I think I forget who was watching this when they showed it. Oh, crap. It crapped out on me. Oh, shoot. Where did it go? Where did it go? Where is it? Oh, here we go. Yes. All right, here we go. This is the one I wanted to show you guys. I thought it was funny. I thought is interesting. Given that it's Wisconsin, yes. Darrell Brooks plot twist. Did someone call the state of Wisconsin to the stand? Oh no. This is from the Mystery Maven. I thought it was kind of funny. Because, they do have those Wisconsin cheeseheads for the Packers games, so that would be kind of humorous if they showed up. Oh, well, here we go. Here we go. It's game time.
12:10. I do have Mr. Brooks in the other courtroom so that I could make an adequate record.
Oh, wow. She put
without
him in there.
interruption. We are on day 15 of trial, and today has been a rough morning, to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence that set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly, my obligation under 906.11.
They have the recording going in the other courtroom too.
That there is an effective presentation.
That's from the courtroom. That's not us.
Of evidence.
Yeah, read that Bible. That's going to help you, Darrell.
And exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted.
Oh no, damn it. I hate this. Apparently we're having problems with
Cross-examination.
the feed.
And the next part talks about civil cases.
Yep, we're hearing it from Darrell's
That
mic,
would
and
not
this
be
is
applicable
absolutely
in a
annoying.
criminal case.
I think she took a lot of
So
Xanny
that
bars.
is a statute that guides
Guys, the echo's coming from the other court, and I'm not sure
what
what's
I do,
going on
not
with the
just in
courtroom
this
right
case,
now.
but in every case
So this is getting ridiculous.
that comes before me for trial.
Map says I'm
Or
basic.
even a motion hearing. And in my almost 11 years on the
Oh, come on.
bench, I've
Damn it,
presided
I didn't do
over
anything. This is not
dozens
me.
and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where
What the hell is going
it
on?
is true, I did not do my usual
Yeah, it might be. Yeah, it's guys, this is the court feed. This is not me.
practice
They, like,
of asking if there were any preliminary
see, we're running
issues
fine.
that the
We're
parties
running
wanted
fine.
to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively
Yes.
for all of the reasons that are stated in 90611. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in,
Oh, the buffering is
Mr.
mine?
Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the
Guys, it's
tone,
echoing everywhere. It doesn't
the
matter.
demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom
It's cleared
and
up
leaves
now.
this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here.
Yes.
I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience,
Echoing
not
everywhere,
only
guys.
as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him, I should state it this way. He is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being, we all would expect have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder. He got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. it is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question? Basically, is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other acts evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906-16 and 906-08. Those are generally two of the statutes dealing with character evidence. That would be 906-08, 906-16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding
Yes, the jury's not
whether
in the
he sees
courtroom.
the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper.
He's just reading the Bible right
The
now.
only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906-16, I didn't see where it also related to her credibility.
Biased, Judge, biased.
It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erica Patterson, and then the photos.
She heard me. Yeah.
The issue as it relates to this witness is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time
Exactly.
is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and
Yes.
other questions
It would
along
open the door.
those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him,
Yes.
related to the other acts evidence, related to whether he has a relationship with the children or not. And frankly, a
Mhm.
topic I am not
It would be
going to
bad.
open the door
It'd be
to.
bad.
I'm not going to allow. It's a side issue. It is not relevant. It is not probative.
Also, this is a judicial determination, Darrell.
But certainly one could argue, based upon the questions, topics that the door could be opened to. It is my duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now,
When Harry met
whether there's been
Sally.
any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong. That needs to include an offer of proof as to why he believes this letter is from Erica Patterson and why it's relevant to the issues in this case. Because he came in to the courtroom this afternoon and is not in here, but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional
The most
equivalent
premium
of being
audio.
present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the
Bench to the
criminal
shadow
justice
roll.
system of this trial. There was nothing dignified about it. There was nothing orderly about it. I would remind him once again of SCR Chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them do unto you. Be respectful. Be kind. Give these proceedings the due respect that they deserve for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the record for that momentarily. An offer of proof if he wishes to do that related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? 7th. October 7th, I believe she was the third witness. We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
Wow, that was stunning. Now, okay, we gotta get some comments here, guys, real quick. Just a map saying basic Brooks. Pseudo Snark for $10. Thank you for the super chat. Says, do you think there's any odds the jury comes back today? I mean, at this rate, yes. They're gonna have to come back and do the proffer, and Brooks gonna have a chance to do a proffer. So yes, maybe. I would assume they do. Why did she have to read through, Graham's saying, why did she have to read through Illinois v. Allen each time? She's trying to protect the record, okay? And here's the deal. It's better to overdo it than to underdo it. And if she says it 55,000 times and the court said just saying it once is enough, fine. But if she only says it twice and the court says, no, every time you need to re-justify why you're doing it, and she doesn't, that's a problem. So it's called belt and suspenders. If you're wearing your belt and suspenders, your pants never fall down. So she is doing everything in her power to make sure this never comes back. T3 says, Judge, the record is very clear. Yes, but she's making it more clear. I mean, she's doing everything right. Alana for $10. Thank you. Says, Sean, you were like sitting next to an average guy in a bar giving his take. Love it. Well done. Well, thank you. So that is it for right now. They're going to try to bring the little crybaby back in, and we'll see how he does it. He isn't listening. Of course he's not. Just a map is saying, do you sit around and do paperwork on a Friday night or just come back and do it on a Monday? I mean, I always wait till Monday. I mean, like today I am actually, like I've answered like 2 emails, like nothing's really come in except for those phone calls. So no, I'm really not, like today I decided like I'm not doing crap. So I'll take, there's nothing I have to take care of today, and anything I can take care of, I can just, it can wait till Monday. So there's nothing to worry about there. So he will be, like I said, Darrell will be back. Coach Platitude says Magic the Gathering declared to do a card for 2023. Darrell Brooks. With keywords return, target defendant, back to courtroom, which banished from. Yes, he can come back from the Shadow Realms now. Dark Diggler says, a man who wears his belt and suspenders can't be trusted because he doesn't even trust his pants. That's some like Velociraptor level stuff. Some Velociraptor level stuff. I'm guessing defense testimony is going to go to Wednesday. Yes, at this rate, but I have a feeling if he doesn't offer a proffer, they are going to cancel Erica Patterson's testimony right now because it's only been duplicative and completely irrelevant. So very quickly, Darrell's going to run into 90611, the axe. And then the state's probably not going to cross-examine, and then they'll just move on. And that because he said this is going to take a lot of time. And if this doesn't, then we might end up with him testifying today, which would be pretty cool. Billiam says that I miss the ex-girlfriend. Part of it, but we're still on her testimony. My mic is crackling. Oh, no. Hopefully it's better now. What is plot? Piasco says, what is a proper? No, proffer. 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 You are proffering. A proffer is a statement on the record to establish what you intended to show. Like, I want to show this evidence. Here's the evidence I have. Here's how I intend to bring it in. Here's the witnesses I intend to bring it in. Here's the questions I would ask to lay foundation. And then, had I been able to present this evidence, here's what this evidence would have shown. A proffer is where you lay it on the record before the court, before you do it, what should happen or what this will do. And that's, number one, a way of showing the court what's going on. Number two, if you get denied, that's a way of showing on the record to the
Right, so we
appeals
have-
court what you were going to do, and they can actually rule on
record,
that.
I've been advised that Mr. Brooks does not want to come over to the main courtroom. Mr. Brooks, I'm advising you, you are invited back to this courtroom.
Yes.
It is my sincere hope that you want to come back here. I see you're reading something, but we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. And I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you
Yes, Tyler, it's a portmanteau kind of. You're
are asking to
proffering.
stay
You're offering the proof.
in that courtroom.
And like I said, the appeals court could then rule on it once you state it on the record, and they can make a ruling saying that was an impermissible denial. So there are effects to
I've been
it.
advised
and
to
they do have
hear
help.
and see.
Uh-oh. Crybaby. Crybaby
Mr. Brooks,
Darrell.
we are on the record.
Keep reading that Bible. It ain't going to help you, brother. Maybe Job will help you out.
I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would
Eliza,
you like to
that's
come
not
back
mine.
here?
That
Yes
that
or
is
no?
that's the people doing the stream. Sean. Okay.
The audio is on. Would you like to come back to this courtroom, sir?
You're unmuted. So I'm finally unmuted.
You've been unmuted for a while. Since I came back on.
Oh.
My understanding, sir, is you'd like to be in that other courtroom.
No, they
Is
wouldn't
that
come back
true?
until Monday unless the jury got the verdict right now. They're not coming back. Like, they wouldn't come back till Monday, but it's going to be a couple hours, probably like 2 hours before they come back with a verdict. And we're not near there yet.
Record
And they would
reflections,
probably
putting on the
let the
headphones.
jury start deliberating on Monday, even if they close today.
What's going on?
Mr. Brooks, I'm inviting you
Yes.
back to the courtroom. My understanding from
Laws
a
and
relay of information from the bailiffs is that you don't want to come back here.
I ain't saying nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I didn't hold you in contempt
Then why am I even over here?
so that I could make a ruling and make a record without an interruption pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever going to get a chance to make the record without being interrupted?
Mr. Brooks, I'm
you
asking
make it
you, the
intelligently,
first
yes.
question is, do you want to come back into this courtroom?
Not if you're going to hold me in contempt.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if you
keep being
don't
held in
answer yes
contempt.
or no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you going to hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him. He has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not going to hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
Oh my God, just stop it. Just give it up.
Yeah,
All right.
I'm always muted.
All right, guys. Apparently, we got a little bit behind. I'm not sure how.
I can hear everything she's saying perfectly clear without the headphones. Oh, that's a trick to hold everything up too, right?
Listen to him talk shit. All right, we're going to skip ahead to the... Okay, we got caught up. Sorry about that, guys. We were a little behind. So we had to skip ahead, but listen to him care. Listen to him cry and pee his pants. Yeah, we're all set, Eliza. We refreshed. Yep, it's a hot mic. So we'll see what happens here going forward. So yes, when he does the proffer, he's going to tell the judge, here's what I have, here's what it's going to do, and here's why the evidence will help. And then he can also lay that out for the appeals court, and the appeals court can read it. Because if you make a motion to offer proof and the judge says, well, I would like to bring it in, the other party objects, and she says sustained, and you just move on, the appeals court doesn't ever know what you're going to show. So instead, what you can do, and I've done this before many times, as a prosecutor and as a defense attorney, I said, Judge, I would like to make a proffer. And if you can get away with it, the judge will pull you up on a sidebar and say, I plan to introduce this piece of evidence. This witness is going to bring it up. I will lay the foundation like this. And here's what this evidence will show. And why is that important? Because it will establish X, Y, and Z. And then you put that on the record. T3 says, yeah, he's pretty much confessed, yes. But that is what a proffer is. I know we got through all that, but I wanted to finish that up. He'll do something to go back, very likely. Very, very likely. You guys want to put together a care package? I'm going to send him 80 pounds of coffee. So Mephisto says, are we still doing witnesses? Yes. Erica Patterson is still on the stand, but we've taken a pause on that to address issues of evidentiary value. So Darrell comes out. He's going to make his proffer. And if the judge is not satisfied of what road he's going down, she's pretty much ending his direct examination right now. The state has not decided if they're going to cross-examine her, but very likely this is going to be it because I don't think he's going to understand what he has to do. Wonder if he would act this way with a male judge. He doesn't like authority, so he doesn't like being told what to do. It wouldn't be as direct like this, but he'd still be an arrogant little asshole. I have a feeling. Rob Dorr says, yep. And it's true. And it's one of the most common reasons for a successful appeal is an effective proffer. Otherwise, the appeals court has to say, yeah, the objection was wrong, but you didn't tell us the evidence, so we can't comment on it. Just a Map says for $5, Sean is nursing that claw like it's baby Brooks. You need to think like an SUV and crush it. It's only 2:00. We've got to get through the whole day. So we've got to get through the whole day, man. And I've not had anything to eat yet. The B says, by the way, thank you very much for the super chat. I appreciate it. The B says, any chance of a mistrial? No, not at this point. Why is that important? Because he can't induce the mistrial. The judge will do everything as possible to prevent that from happening. But you cannot induce the mistrial on your own. If he brings up all the damaging information, well, that's going to be on him after a while because he's been thoroughly warned and they've tried to protect him. So that's going to be an issue for him. K-Bragg says, can we send him a grounds mug? I don't know. You might be able to. That's going to depend on the Wisconsin Department of Corrections.
It's 12:48.
Oh, we're back.
All right, let's take up the issue of the letter and the photographs and your offer of proof, sir, if you have one.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof
We
to
can go
provide,
past all
sir?
that. We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Oh,
Mr.
just
Brooks,
a
I'm going to
minute.
ask you for a third time. Do you have an offer of proof
Daryl,
I
related
just
to
said
the
no.
route?
I just said no. I just said that.
Widow baby doesn't
All right,
know
thank
how
you.
to
Then
do it,
based
so
upon
he
there being no
passed.
offer of proof, then
Poor widow
my decision
crybaby.
stands.
Poor little crybaby Daryl, one away like
As
a
to
baby.
the continuation of the examination of Ms.
He's given up
Patterson, I
hope.
would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were you going to question her about?
He punked out. She asked him to do it, and he's backing down because he doesn't know how to do it. He's throwing his temper tantrum. Bitching out, Daryl. Daryl, the bitch
I guess
Brooks.
I'll have to look in here
Bitching
because so
out.
much that happened since over the past hour and a half or so.
Over the past hour, I can't do it. Oh, pussy.
I can tell you one thing.
Pussy.
I don't intend to have too many more questions. I tell you
Here,
that.
Daryl.
I was almost
You're a
finished.
pussy, man.
I
You
need
have
an
the
offer of
chance.
proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination,
I
or
don't-
already covered by your direct?
I don't remember her. What do
Patty,
you mean
look
by
what kinda-
related to her direct? Is that from the last time she testified?
No,
From
this
the-
direct.
From
This
the
direct.
first date that she testified and from today?
Yes.
I don't
What
remember-
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
You dumb fuck.
Mr. Brooks, this is your opportunity to prevent relevant and probative evidence. But under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already
You need to
covered.
tell her the questions
What,
you're going to ask.
Pursuant to
Daryl.
the police report or something? Is that what you asking?
Answer
I
that
don't
question.
I'm
understand.
asking you,
What are you going to ask her?
I'll
What
ask
are
you
you going
once
to
again,
ask
sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you said related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only,
Is it a statement that she wrote?
No. It's not a statement she wrote. It's not a statement she signed. If
I
the
don't
police
know if it's a statement that she wrote in here.
Do you see
Possibly is.
do you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report. Both interviews.
Oh, don't do this again. We're gonna have to jump stations.
Previously provided with discovery?
Absolutely.
What about the police report? Sir, do you want to question?
Oh, come on, you son of a bitch. All right, guys, we're gonna switch
Her
over.
about, so I know with specificity.
We're going to TMJ.
Oh, I'm looking at it now.
Oh, actually, it seems like it works. Kathleen Jeter, I wonder if my neighbors can hear me screaming. Yes, those police reports, unless she signed a written statement, an officer.
How many officers did report?
We're going to TMJ right now. Sorry, guys. We're not messing with this.
Available to show me what Mr. Brooks is referring to. I can maybe help him try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there.
We are trying to avoid long crimes feed for specific reasons.
Statute.
Yeah, we got a new stream, guys.
So I've got pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department incident number 21-047533. This is one of the two reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what questions
Yeah,
about that
You had all
report
night
do you
to
want to
prepare.
question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read.
you
a
should have
little
had
bit of
this ready.
to form the question.
Under my authority, under 90611, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that
Oh,
time.
no.
And they had ample time this morning
Nuclear
to
option.
question her. I will declare that his questioning of her to be closed.
Uh-oh.
I will bring the witness out on
Uh-oh.
the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any
Oh,
questions,
no.
and then we'll move on from there.
Oh,
Just so I
no.
understand what he mean
Oh,
by close.
no.
I'm not allowing you to ask her any additional questions.
says you're
given
done.
your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
Yep. What
How
happened?
do I, first of all,
90611 the
report is in order.
axe.
So I would have
Waukesha's
to
hardest
essentially
rock
read
music.
At least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So
You could have
I'm bringing
prepared
the
last
witness
night.
out.
You had
The
all night
jury
to
will come
prepare.
out and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I
then
have
if
to do
can't-
that in front
The
of the jury.
state, it has to be done that way, and the state has the right to cross-examine.
I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record.
Because
If
you're
you
a
start
crybaby, Darrell.
interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your
So I
right
might
to
as
be
well just, I might as
present.
well have just
No
stayed over
such
there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
gonna get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're going to
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're
a mis-
attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt?
I'm going to keep you in here because
that's the whole reason
you're
I
going to need
didn't
to
wanna
call the
come-
next witness, and I'm going to need to bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I
Obviously
want you
you
in this
do.
courtroom.
Obviously you do. You brought it up before we can even get to.
All right. Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even though it will be
did I
short,
actually forfeit that right?
you have forfeited your
Yes,
right
you
to
have.
be present.
And
That
how
is the-
did I forfeit that right, Your Honor?
All right, we're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding
You're
you
not
in
held in
contempt.
Then what did I do?
All right, I'm going to step off.
What I do?
Interrupted
What I do?
repeatedly.
What I do?
I'm going to step off.
Okay, guys, that was great. So Darrell shit the bed there. What happened? Well, once again, she asked the proffer, what is your offer of proof? What do you intend to show? Well, I'm going to ask her questions. Well, I haven't read the report yet. He knows that he was going to ask her questions. He's known this for like the entire time. He was going to call her as a witness. He knows that. And even then last night, he knew she was going to be called as a witness today. He didn't read through the police report last night. He could have prepared. And because he's not prepared, the judge said, well, you're done. Well, what were you going to ask her? Well, I don't know yet. Well, then you're not prepared. That's not advisable. So, yeah, good job, Darrell. You played. Congratulations. You played yourself. Another one. You guys are saying that the judge being weak. No, she's doing what she can. Keeping him in the courtroom is more conducive to preventing a mistrial. Let's see here. We got a couple things. Darcy says, my head hurts. Holy shit. Yeah. Just a map nailed to the wall as a new member. Thank you so much. I appreciate the support. The squid for $5. Thank you. Says, just woke up. So has the judge put him in timeout again? Yes. And since then, again. And probably again. And again. And again. Today. So we're only partway through that. Jay Walker says, can the jury hear when he is loud or is the room soundproofed? That's a brand new building, so I'm assuming it's got very good soundproofing. The jury's going to be isolated. That is a problem in older courthouses with thinner walls that juries can hear you. I had a case in May where the prosecutor said some things he shouldn't have said, and we were in the judge's chambers, and the walls were thin enough the jury could hear me yelling and making my arguments on the record in the judge's chambers. And the bailiff had to come in and say, like, we can hear every word you just said. And then they also had to say, we heard every word the prosecutor just said. So, no, this should be soundproof and they should be isolated far enough away. This judge should not let him back in. She's fucking up. Yeah, Liz, she's doing the best she can here. I think she's doing it fine. Kevin James Paz is saying, does he keep saying held in contempt on the record just to muss it up with bullshit? Yes. That's entirely what he's doing here. And he's not being held in contempt because contempt is a special finding. And it doesn't help that he's in jail, so you can't really hold him in contempt because what's the worst you're going to do? Put him in jail? Okay. He's also, it's not like you can fine him because it's not like he can pay that anywhere or would pay it anyway. And she makes it clear, I'm not holding you in contempt because contempt means that they're not going to continue the proceedings. She just says, we're going to put you in the other room pursuant to Illinois v. Allen. So that's what she's doing. And that kind of diffuses it every time. 864 people here watching. Thank you so much, guys. I appreciate it. If you guys like this, please click that like button. I would be great. Sean dripped out in the red shirt. It's maroon, but yes, thank you. To the victims, this is not a fake trial. I feel bad for them. Yeah, but at the end of the day, they will get through this. Mr. Papa says, is 90611 a radio station? Axed FM. Yes, it is. Well, I like doing that. You're listening to 90611 The Axe, the one place for Waukesha's hardest rock. While other stations may be wussies, we're out here rocking all day and all night. 90611 FM, The Axe. Right now. Amanda Page says, this is what fucking around and finding out looks like. 100%. 100% so. Yes, it's not the court's problem. He's not prepared. Very, very good. True. We had a pastime. 100% true. Rich G says $100. She'll give him another chance when we come back. She has to. She has to keep offering them an opportunity because otherwise that could become prejudicial. Remember, she's going out of her way to make sure I've done everything possible to give him a fair and impartial jury and a fair and impartial trial, free of prejudice. So she's going to have to keep doing that because this way she has made it bulletproof on appeal. So I think she's done everything fine. T-Pro says, I can hear Janis Joplin. Cry, baby. 6 Hours says, this has been the least productive day ever. Yeah, I kind of get that feeling too. Rose RNC says, it's like listening to an abusive relationship with a narcissist gaslighting. Oh, yeah, I'm sure this is how he is all the time. John Bubba says 90611, keep throwing out those jams. Yes, 90611, keep yourself locked up for our top 10 countdown, featuring the new hot single from Darrell Brooks, They Movin' Me, followed by his yesterday's hot single, They Fixin' to Do Some Slick Stuff. Are there any family members of the victims in the courtroom? Sure. They certainly have every right to be there. There probably are some people there. American Virtual, thank you. 906.11 megahertz would be the police radio, etc. Yes, thank you. Well, actually, thank you, though. It's all right. Arash, how are you doing, man? Can I get a soundboard? I've thought about that, but I don't necessarily know if I like them. Dwayne Mansell says rackets at 5 grifting cucks live on Rumble. Yeah, well, I understand for Nick being there. He kind of has to be there. Yes. Yes, Triaris Metzer. 90611 FM. We have the grounds to be the hardest rock in Waukesha County. Does this speed things up? Hazitaka says, "Oh, I hope I got that right." Hazitaka. Does this speed things up? I can't tell. I can't even tell anymore. I don't know either. I'm sure for the people in this courtroom, this is very much like a Sartre-esque version of hell. Just no exit to the room. Patty Leather says, if she 90611's him, does the defense attorney finish the defense for him? No. It's just he can't ask any more questions. He's done. So as you saw right there, his direct examination of Erica is done. That's going to get ended on the record in front of the jury because the jury has to be presented. And then the state gets to decide they want to cross-examine, but that's it. It's done. Dunsky. Yeah, screw Google says,
Clerk, could you please have the
you're listening to Dopey and the Pedophile. One and the same.
You are unmuted, sir. The jury is on its way in. Well, will be shortly.
Why didn't we address subject matter jurisdiction when I was over here?
I'm going to mute you if you do that,
Subject
sir.
matter jurisdiction again. We're going back to the
I'm not gonna do
old
it when the jury-
reliable.
That's why I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record? Why
Rob Dorr, thank you for the membership.
held in contempt when I
I'm sure
didn't do
everybody's
that?
appreciative of that.
Civil or criminal?
That's a misstatement of what I did.
Guys,
sir.
if you get a membership, tell them thank you.
So
I'm
why
sure
am
you
I
do.
I will
Okay.
advise when the jury's coming in, and if you can't be quiet, you're going to be muted.
Okay, why is TMJ
Sorry.
freezing up?
You gonna mute me anyway.
Not if you're quiet.
So I gotta be quiet like a little kid?
It's not what I said, sir. You have to be
That's what
respectful.
you said.
You have to be respectful of the proceedings.
But nobody has to be respectful to me though.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen them through the TV screen and made me feel uncomfortable?
Jury's coming in. Please rise for the jury.
So that's not gonna be
Yes,
addressed.
Mr.
okay?
my
Brooks, I'm
case.
muting you.
Yes, he needs new legal jargon. Yes, he needs to come up with a new
Oh,
legal
okay.
word for today. Expand your vocabulary, Darrell. It's the fourth quarter.
Okay.
You got to pick it up. Oh, I'm playing 2K23 and sucking on my weed pen. Hey, nothing wrong with that. Hope you're having a good time
Should just keep
and listening to me. It's great.
They're nearby. Thank you, everyone. Please be seated.
Address her opening. Who's opening? I don't really know what you're.
Just for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the
Nicest
state
mommy
have
ever.
any questions for this witness?
I don't have any questions for Ms. Patterson.
All right. Thank you, ma'am. You may step down. Thank you for being here.
Nah, she's done. You got nothing, Darrell. You got fucked on that one, brother. Ha! Cope and seethe, baby. Cope and seethe.
All right. The defense may call its next witness, please.
Cry, baby. Yes. Is that a fiscal responsibility, Your Honor?
Go ahead, sir. You can call your next witness.
I thought I was muted.
You're not muted.
Oh, the judge's the thing. The judge, when she laid that all out, was
So
phenomenal.
how
in how
long
she
am I
laid that
supposed to
out.
stay here now?
Oh, you don't answer that
I'm
crap
gonna
on the
excuse
record.
the jury. We'll hopefully have you back shortly. All rise for the jury,
Dirt in
please.
my eyes says Godspeed, Erica. Yep. Oh, I'm sure this afternoon is going to be a lot of us stonewalling and laughing at him. Yes, he's in a room alone with a mask on, yes. Also, I want to make sure. Do I have the sound boost on? Yes, I do. All right, I want to make sure you
All right,
guys.
the jury is no longer in the courtroom.
Oh, well,
Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to
forgive me for
perhaps
taking
either
you seriously,
ask
bro.
to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not muted. You're unmuted.
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous, disrespectful, and disruptive. So pursuant to the authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct.
New poll
I'd
is
also
up,
direct
guys.
the
New
parties
poll is
to
up.
some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
All right, we're going to try to bounce around to another spot here, guys. Hold on.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back
She's
into
using
this
Illinois
courtroom,
versus
sir.
Allen, but justifying it with
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
Mr. Brooks is not answering my question directly. So based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer.
Mr. Brooks?
You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will. He's interrupting me once again.
Okay, you talking. You the one talking right now. So don't do
Oh, God damn it.
that.
I'm going to mute him because he's not being respectful and he's just spouting off. So he did
All right, we're switching over. We're going to a new
not
one.
answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now because you haven't.
Okay, he is again not answering the question directly.
Spitting a fire, Darrell.
I'm going to mute him again, as I've noted before. This is a clear
she cut you off.
method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I've confirmed that he can see and hear as well. based upon the court personnel that are in the other courtroom.
Yes.
So I'll make
Are
another
you winning,
finding
son?
that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses.
Ooh.
So I'm going to unmute you. Actually, I need to bring the jury back out. But before I do that, I will unmute you first and ask you which
100%.
witness
She's doing a great
you
job,
intend
guys.
to call, so we can at least have that person ready to
She
go
might nuke
and
him.
outside the courtroom.
Ooh, this is gonna be good.
Who will be your next witness?
I'm not calling no witness if I gotta be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made
gotta
a
answer
record of that,
everything.
sir.
I have to answer everything though. Everything you ask me, you expect me to answer. But then when I ask you questions, you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable.
Yeah,
I
they're
just
going
brought
like
that
this.
up on the record. You didn't even address that.
Are they going like this?
Mr. Brooks,
Loser.
I didn't address it because frankly, you keep interrupting me and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that. And if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back
Mute
over
boy
to
fly.
this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or
Rob Door
probative
again. Thank you,
at
man.
this
That's
time,
awesome.
and they're a delay and disruptive tactic.
They're
Mr.
not a delay
Brooks,
and disruptive tactic. Is that a judicial determination that you're making?
I'm going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial
Yes.
determination.
I've said that for
It
days
is on
now.
the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now, you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there.
And by the Price is Right rules, Rob, you therefore lose.
And it looks like he took his headphones
But that's a
off,
pretty
so
good
I
play.
would-
Well played, sir.
Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses.
Okay, now this is very
And
serious.
I'm doing this outside the presence of the jury
she's gotta
right
do
now
this on
for
the
a
record.
reason. I need to know from you right now, you are unmuted. Who is your next witness?
She trying to say something to me? Yeah. What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones? You
Yeah,
choose
because
to
I'm
read?
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have
No,
to hear
yeah,
the
yeah, is a
instructions.
lady.
Okay, well then why should I need to hear what
So
you
let
say?
me be clear, sir. And
you
you
don't
are
gotta
not,
be clear or nothing. I don't gotta listen to you.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again?
No, she's talking to the
This-
other fucking defendant in the courtroom, you dumb fuck.
Childish stuff, dude.
Childish stuff is you the
I
one.
gotta sit up here and I'm supposed to abide by every single rule, but nobody else gotta do that.
The record should
Judicial
I don't know about
reflect
that, Daryl.
that Mr.
Repeatedly.
Brooks is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks,
Go for the high score,
You
That's
Daryl.
are-
not
Don't
my
stop
name.
now,
I
brother.
told you I don't consent to being called that name.
Keep going.
sir,
Go,
you
Freedom
are
Train.
hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to
You
present
can't do
any
that. Show me
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
My God.
Show me that it's law.
He's
That's
going to
all
do
I'm
it.
asking.
He's
Show
going
me
to go for the
that
high
it's law.
score, guys.
Mr. Brooks,
How can I forfeit not being able to have a defense?
He's going to do it.
Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay.
gladly bring you back into this courtroom so you can
Ooh,
present
she's giving
your
another
additional
chance, guys.
witnesses.
You're
But
right.
you need to ask me to come back into this courtroom.
With all due respect,
Yes. Combo
I'm
breaker.
tired of having this back and
tired
forth
of having this
combo
back and
breaker.
forth with
every day.
It's not my intention to
It's
come in
not
here
my intention to
and,
come
and
in
have
here
this
and have
these interactions with you every
these
day. It's
interactions
not.
with you every day. It's
Regardless to what you may
not.
think,
Regardless to what you may think,
regardless to how you may feel,
regardless to how
that
you
is
may
not my
feel,
intention.
that is not
Okay?
my intention. Okay?
I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question.
I'm going to ask a question.
I
No shit, you
apologize
don't
if it
understand.
makes you feel
Apologize
that
if it makes you feel
I'm
that
intentionally trying to
I'm
delay the
intentionally trying to
proceedings.
delay the
If I'm
proceedings.
intentionally trying to
If
be
I'm
disruptive.
intentionally trying to be disruptive.
It's
Because
so
that's
beautiful,
not the
guys.
case.
Because that's not the
And,
case.
and I feel very,
And I feel
very, very, very
very,
disrespected
very
every time the record is
disrespected every
made,
time the record is made,
making it seem like that's
making
what
it seem
I'm
like that's
attempting
what
to do.
I'm attempting to do.
So of course it's gonna
So,
make
of course,
it's gonna frustrate.
it's gonna
Of course
frustrate.
it's gonna
Of
make me a
course,
little bit
it's gonna
upset.
make me a little bit upset.
And I just want you to understand
And I just
that.
want you to understand that.
It seems to me the
It
way I'm
seems to me
interpreting
the way I'm interpreting
what you're doing, which
what
is
you're
it
doing,
is your courtroom.
it is your
That's
courtroom.
not it. That's not a dispute.
It's not a
That's not up
dispute.
for debate.
That's not up for debate.
You control what's going on
You
in there.
control
That's
what's
not a
going on in
dispute.
there. That's not a dispute.
But the way I'm
But the
interpreting
way I'm
what you're
interpreting
doing is that
what
I'm
you're
being
doing
held in
is that I'm
contempt.
being held
That's
in
how
contempt.
I'm interpreting.
That's how I'm interpreting.
Because one of the three
Because
things
one of the
that's
three
cited
things that's
in
cited
Illinois versus
in
Allen,
Illinois
one of
versus
them is
Allen,
one of them
one
is
of them
being
is
gagged.
one of them is
I
being
haven't been
gagged.
gagged.
I haven't been gagged.
One of them is held in
One of
contempt.
them is held in contempt.
If
What's
I'm-
the
if
third,
I'm not
Mr.
under-
Brooks?
If I'm
What's
not
the third?
The third is removed from the courtroom while the
removed
trial
from the
continues,
courtroom while the
right?
trial
That's the
continues,
third, right?
And
That's
that's
the third,
what's
right?
been done.
Okay. So now,
Okay. So now,
where does it say after
where
that
does it say after that
that having me on a headset
a
or
headset?
Guys, this
being
is
able to
an
see
this is
and
an
hear
issue
all
with
of
the
this,
stream,
how is
not
that
me.
not
I can't fix this.
prejudicing my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal.
I can't even.
You
I
can
This is
raise
why I
that
say that.
issue on
This
appeal
is why I
if
say
you
that.
are
This is why I say
convicted.
that.
This is why I
This is why I
say
say that though.
This is
Because
why
I
I say
can't
that
even
though.
see.
Because
The
I
only
can't
thing I
even
can
see
see right now
The
when
only
I'm
thing
looking
I
at
can
the
see right now when I'm
is
looking at the
you
TV is you
in the prosecution table. I
and the
can't see
prosecution
anything
table.
else.
I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm
Beautiful,
not,
wonderful.
I'm not
This
fully
is
So
their
aware-
audio,
I'm
not
fully
mine.
aware of what's going on
This
in
is
the
the feed.
courtroom.
Don't I deserve that right?
Don't
to
I
be able to
deserve
see
that
and
right
hear
to be
everything
able to
that's
see
going
and
on?
hear everything that's going on?
Yourself consistently with the decorum and
Yeah,
respect
shut the
adherent
audio
to the
off real quick
concepts of
just to
courts
show
and
you.
judicial proceedings. The answer then is yes.
what
So
did I do?
I'm not going to
So
have a
what did
debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Uh-oh. All right, we'll switch over. This is hilarious, guys. I've never seen this before. Okay, guys, it's freezing up everywhere.
You have an echo too. I thought maybe you weren't live again.
Guys, nobody cares, Darrell. Yeah, this is God messing with the Brooks audio, maybe.
At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand
It's not
English. That's not an
It's
issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely.
You were
That
warned.
takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own. And you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself.
Your Honor,
And
that's not
that
fair.
comes at a risk to you of, yes, at times not fully understanding the law,
We'll try
the
a
rules
long
of
crime.
evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because
So I'm going to do the following, since I'm not really getting
You guys want long crime, we'll do a long crime there.
procedure, but you
That's
do
not
so
fair.
at your peril.
that's not fair to state, Your Honor, because
Do you guys see?
So
This
I'm
is
gonna
an
do
audio
the
feed
following,
issue.
since
This
I'm
is not
really
me.
getting anywhere. I'm going to mute you for the moment. I'm not
Okay.
getting anywhere with him.
It's not me. It's
I would
it's
like
the
him to be
court
brought
feed.
over. And he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury.
So
I will ask him 3 times if he fails to give me a direct answer. And after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he will come back over here. Thank you. We are in recess until that happens.
All right, guys, look. We bounced around a bunch of different feeds. I hope you understand. It's not me.
We're gonna stop everything. Take a
It's not me. It's the court feed. The audio has nothing to do with it. Okay? It sucks everywhere. The only thing I can get is that long crime, I think, might still be running. But the feed sucks everywhere. The audio is not on my end. It's an issue because they're in 2 separate courtrooms and we're having problems with the audio. So that's what's going on there. I just did all that just to show you, and we listened to him cry and piss his pants like a little baby. All right?
want being kicked out, then obviously I don't want to be kicked out. But then I'm kicked out anyway, and then I get over here, and it's just like, okay, I don't want to be over here, but
Yes, Rob, you are 100%. This is uncharted territory. This is so weird. I didn't think this was ever going to happen. Completely weird territory. Yeah, guys, I am sorry, but it's bombing everywhere. Yes, Justice Smith, this is all your choice. So refresh your. Okay, fine. I'll refresh my browser. Here, you know what? Here. We'll do it even simpler. Simple as. And I'm going to refresh StreamYard just to get it done. Just because we have the time, guys. There. Everything's been refreshed. There's problems all over. We'll get back into it. There. Now we're back. Present, share screen. There we go. We're back. We'll try long cuck again. I doubt they're any better right now. Long cuck is on a waiting screen, so that's why it's down. Yes, poor White Claw on it. Yeah, the echo's on Ricada as well. It's everywhere, guys. So, just wanted to get that clear. Okay, so we'll go through some stuff right now. The Squid for $5, thank you, saying, I feel like a first-month law student could do a better job representing this child than he's doing. Yeah, I think it would be a little bit better at least. Cool Spring saying, did you ever work in radio? No, I have not. I don't know if that's a good comment, a good question or bad question. Kim Berger is a new member. Thank you so much, Kim. I appreciate the support. Sparks for 199 says, Sean, thanks for the entertainment and commentary. You're welcome. We got to get through this together somehow. Alana is a new member. Thank you so much, Alana, for the support. And Roxanne Wynn says 90611 end it all. She just did that. She just nuked him. She might nuke the rest of his defense. Just a map nailed to the wall says this is important research we are doing here. Yes, it is. This is Uncharted. Rob said it. This is weird. I've never seen this before. This is very, 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 very different. Yes, Zane says, or Zaven says, I hope this turns into a speed running of dismissing witnesses because Brooks is petulant. You might get your wish. I would rather not see that happen just for the sake of making sure things are done properly. But yeah, we might be there. And Just a Map says, 90611 FM, where the hits keep coming. One parade goer after the next. Only on the Axe. Kim says for $4.99, what if he just goes mute? How do they continue on? She kept on unmuting him, and if he refused to answer, she would say that he's acquiescing. But we just saw how she was going to handle that. Then Rob for $5. Remember when I predicted he would melt down after two witnesses and I unfold? Yeah, you were only off by one witness. Yeah, I thought he would have the wherewithal to get through this, but yes, you are right. He had a temper tantrum, and this is, man, I could ask your professors in law school. This is different. This is very different. So very different. Just a Map says, Jesus, you know he's listening to your stream. Don't teach him the word acquiesce. Yes, he's going to come in. If he says that afterwards, then we'll know. Then we'll know. And I truly have the power. Becky Bailey, thank you for becoming a member. I appreciate your support very, very much. Now you have the White Claw Glock and emojis. B. Cluet says, have you tried lower video quality for the buffering? Yeah, but I don't want to do lower quality video. I mean, it's the best ever. Yeah, GM. It's all the court picking up the mics. That is an audio problem there. Mike Ladd says WSN 12 News is clean and clear. I'll take a look at it if we have a failure going forward. I'm going to bring up a couple of streams ready to go. But for right now, I think we're good. Jay Walker says, do you believe the jury's already made their decision? Pretty much. I mean, like, let's be real. I think that they're going to sit down and it's not going to take them long at all. Buffering all over the internet. Yep. Yeah, I kind of thought that was the case. So we do have a poll. We're going to end it there. It looks like not a lot of people wanted to vote, but it looks like the winner of the Who Would You Smash is the bailiff with the taser remote, and then Judge Doro in the lead, and then DA Opera at the back end. You guys left poor old Sue in the back. That's not nice. Not nice at all. Darrell's using the prison Wi-Fi to watch Sean doing his defense. Yeah, that'd be great. All right. TMJ4 is streaming fine, no buffering. Yeah, we are having problems with TMJ. Like, we're bouncing around. Guys, give me 1 second. I'm just going to restart my internet here real quick and reconnect it. It takes like 2 seconds just to protect everything here in case it's on my end. All right, I should be back. We should be good to go here. Yeah, it's not Sean, it's everywhere. I just wanted to make sure. Take care of it. Peter Jordan said that was at least 5 seconds. Okay. I'm sorry. Yes, actually, that was 5 seconds, Sean. Is this live? Okay, that's live. Sounds boosted. Perfect. All right. It's on Rumble and Odyssey because of the Trialstream, yeah. Just a map says Sean is self-deleting. Only SAS says it is the courthouse problem. I know, but you know what? Now nobody could complain anymore. Just wanted to make sure we're all set. Are they going to move him for all eternity? Yeah, I think we will. I think we will. New poll, new poll, new poll. What do you want for a poll? Jay Walker says Darrell is begging for a plea now. No, I don't think he is. Actually, fine. I'll put up a poll. All right, guys. New question. How do you feel about Judge Doro handling the trial so far? New poll. Take a look at it. Tell me what you think. Brooks probably found the courthouse router. Don Mossy knows baseball. Is drinking White Claws kind of gay? No, it's not. We're never gonna have to ask that question because we already know the answer. No, it's not. New poll. Who took Darrell's paper earlier? Yeah, the one he was looking for. Screw Google says she gave him a spoon and he's already dug his grave. Yeah. American Virtual says, crying in my cup cage like, what's the business? Crispy Snickers says, what do you think the jury's thinking with all these interruptions? I don't know, and they can't say too much during these because they would get in trouble for commenting on the case before the trial's done. So I don't know what they're thinking, but certainly they know something's up. This is not normal. They certainly know something like this is not normal. Also, I can't believe it's taken them this long to do the transfers of the courtroom. Also, people are on law and crime donating money. Imagine donating money to a corporate media interest. Like, how does that work? I don't get that. That is so weird. Guess that is whiskey's what men drink. Yeah. Yes. Distilled dildo filtered whiskey. Yes, Mr. Brooks. Yes, Dirk Diggler says it. Yes, Mr. Brooks, I'm giving you one last chance. And by last chance, I mean 500 out of 1 million. Yes, Axios says the state of Wisconsin stole that paper from this morning. If she eats his witnesses, she'll have to eat his testimony. Then it's closing. No. She'll just
The record to reflect that Mr. Brooks is present in the courtroom in person
by himself
and in custody wearing a suit and tie. Actually, his suit coat is off.
So he
but
doesn't
he's
lose.
still
He
wearing
doesn't
it.
lose all of that.
And the jury will be brought out, and you'll be asked to call your next witness.
Can't call it that name.
So noted.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
It's already been proven,
The record stands.
and that's a judicial determination, Darrell.
So is that a tacit agreement that you don't have to answer?
Tacit, you illiterate fuck. Tacit.
I make no such agreements with you, sir.
Tacit.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven?
Yes, people are super chatting law and crime. Weirdest thing ever.
Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
No, it's not. Well, Tim Pool makes a lot of money, but law and crime is part of a media conglomerate. That's a bit of difference.
The defense may call its next witness.
Who's here?
Up the volume a little.
Bertram,
Okay.
Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
Oh, for the love of Jesus Christ on a cracker. I don't understand how there's issues because I'm coming through nice and fine, but we're going to go to TMJ. Oh, it's back to normal. Okay.
Let's go with Deanna Aldridge.
Deanna Aldridge? All right, very well.
He probably has been freebasing coffee grounds. Only SAS. Thank you very much. I appreciate it. Only SAS, or maybe you like the SAS. I don't know. Special Air Service. Either way is cool. Thank you for becoming a member. I appreciate the support. And look at that bitch boy. Darrell is sitting there ready to do witnesses again. He didn't give up. He didn't quit. He came back and cowered and did what he was told. Good job, Darrell. Good job. Good job, Darrell. Oh, Rob, that's interesting. Dan Abrams invited Joan after Amir Locke, who was murdered by the Minneapolis Police Department for no justifiable reason, by the way. And they canned your interview
I'm
after
sorry,
you
I
weren't
think she was
bootlicky
saying yes,
enough.
Bill, thank
Yeah.
you. It's all right. Thank you for letting
Yep.
us know.
Somebody's saying court TV is not delayed because they buffer because they're delayed by 2 minutes. Ah. It's like a security blanket for him. Maybe he feels he can be invisible. At least that's what I'm thinking. Yes. 2L law student. Darrell Unmasked. Sounds like a Dateline title. Or 2020. Oh, really, Rob? You defended the officers? I said no. That was not. Guy's got a gun. That doesn't mean anything. Like, people are going to have guns if you don't like them. I think we may disagree there a bit, but I agree no knock warrants are bad, but I still think that was a bad raid. Javi T, what's a map? An MAP is the colloquial term nowadays made by the mainstream for minor attracted persons, meaning a choma or a pedo. That's the nice way of calling them that now. Yes, Jeremy, a thing that goes on the wall.
Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please
I'm gonna try to catch this up, guys. Hold on.
Think about the truth, so help you God? Yes.
What do you currently do for a living?
Yeah.
I'm retired.
That's always pretty good.
It's always good. Thanks, Darrell.
Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes,
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
Guys, I got the sound boost up all the way.
The engine dropping kind of noise.
Okay.
I don't know.
And you stated you looked out your patio and saw a red SUV.
I did.
We'll try the other ones real quick.
SUV looked at that time.
It was smashed to smithereens.
Do you recall if
We're gonna go to TMJ. Their audio's dropped off.
recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes,
And at some point, did it cut off?
yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
Description
what?
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay.
Why were you looking down on a black person? That's probably the next question.
And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were going to walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah.
Do you recall how many people there were?
Maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
If you recall, did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
I'm right here.
But that general direction would have been, what street did you say?
Arlington.
Arlington. I apologize.
You don't apologize for anything. Yes, his evil twin, the soap opera twin.
Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
After you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Yeah, because she's probably really confused why this guy's calling her to testify. I understand. This is got to be very nervous. It's got to be nerve-wracking for normal people. And the defendant's calling you in a case like this, and everybody in the world's watching. Yeah, everybody will be nervous.
Do you recall the
Here's
name of the
subpoena.
officer that interviewed you?
No.
Particular, don't take Xanax before you testify. I can't recommend that. Yes. What do you know about Skinwalker Ranch? Do you agree wizards could take the appearance of another? Darrell's just in a BBW. Oh no. No.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor. Thank you.
Thank you, ma'am.
Ha! Done. Uh-oh, Darrell, you got to move on to the next one, bro. There's no time to get ready for the next case. Next witness.
Defense may call next witness.
Zaven, who rolled the nat 20 for the disguise?
1 second, Your Honor.
Nikos. He already tried that one. He already tried that play earlier. It didn't work out too well. I don't think he'll be able to circle back to it.
The defense calls Christopher Bertram.
All right, thank you.
Jay Walker says, he's done a great job arguing the state's case. When will he get to his own defense? Yeah, this has not been very helpful.
I presume the state heard that and was assisting. Thank you.
Your Honor, my assistant.
I didn't want to assume. So thank you for
Yes.
verifying that. Looks like this one's a lot closer than before, so that's good. All right, good afternoon, Mr. Bertram. If you would please make your way to the witness stand, which is off to my right. It is up one riser. When you get there, please remain standing, raise your right hand. And my clerk, Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Have a seat, please. First thing I will ask you to do is to state your first and last names for the record.
My first name is Christopher, and my last name is Bertram.
Could you spell those, please?
CHRISTOPHERBERTRAM.
Thank you. As long as you sit close to the table, you will not have to lean in. Go ahead, sir, your witness.
Oh, I'm sorry.
Go ahead, your witness.
First of all, good afternoon. What do you currently do for a living?
I do electrical work.
Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our mechanic friend.
I was smoking pot in the car.
Were you aware of a parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
And at the time you observed this smashed up car, as you say, did Did you see anyone driving it?
Yes,
And were you able to make a description? Sorry, description of who was driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
You made reference to giving a statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
Yes, Jesus.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
Did you observe the vehicle stop at any point in time?
No.
So it was pretty much you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tints?
Any what?
Tints, like tinted windows?
No.
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was your interview with law enforcement the same evening that you saw this vehicle or sometime after?
The same evening.
Do you recall stating during the interview that evening that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
No.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
Yes, bend over. Do you like
Do
my
you
rap
recall
battle
in
video?
your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
And where did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
He had his hoodie on.
Do you recall during your interview with law enforcement that evening stating that you thought the operator was wearing a black sweater or jacket as it drove past you?
If that is what is written.
Do you recall saying that?
No.
And do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
Where's this going, Darrell?
And was anyone present with you during your interview with law enforcement that evening?
Yes.
And who was that?
My mother.
And do you recall what agency your interview was conducted by?
Yes.
And would you stay for the jury and the record?
The FBI.
Ooh, the federales.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do you
There are a lot of
recall
gunshots.
I think that's a little bit unfair to say.
I think it's unfair to say.
If you had to estimate where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
How many of these dead show gunshot wounds, Darrell? Does not matter. Does not change anything for you. You're getting convicted and you're going away forever because you haven't done anything to spell. You intentionally killed these people, then injured everyone else. Like you've really screwed it up. I don't know why you think it's going to change, but it won't. You're done.
Do you recall seeing the
This is nonsense.
vehicle that you observed crash into anything?
No.
Stupid. Waste of time. Dead air, Darrell. 90611. Let's get this going, Judge. Axe him
Do you
now.
recall
Axe
stating in
him.
your interview with law enforcement that evening that the vehicle appeared to slow down while traveling down Prospect Court?
Yes.
How could this witness help him? Maybe if he had some really nasty Ebola and he gave it to Darrell and Darrell died. It ends the trial.
Sometime after observing this vehicle, did you call 911?
Yes.
And if you die before the trial's over, they have to dismiss the charges. So then, therefore, he's innocent.
Do you recall around what time you called 911?
No.
Do you recall shortly after seeing this vehicle texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
Possibly.
And hear gunshots from downtown. And if you're not ready, 3 sounds like a million probably. So this doesn't help Darrell because we can explain the gunshots away. The gunshots are explained away by the officer shooting. And yes, I'm sure the people in the parade made it sound like he had it, thought he had an Uzi when he's like, pop, 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 trying to shoot up that car. Oh, Jesus, this is not going to help you, buddy.
Did you see anyone else in the vehicle?
No.
This kid's playing it cool, but he's like, this is cutting into my Call of Duty time, bro. Hurry up.
But you do recall seeing the operator wearing a black sweater.
I don't remember.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Forgive me, Rachel. I'm not up with the kids. Randomizer, he's trying to show each one of these witnesses has problems with their recollections. Therefore, their credibility's bad. And because their credibility's bad, nothing should be trusted
Do
from
you
them.
recall why you would have gave?
That's what he's trying to do.
A description that evening.
It's
when
not going to work
initially
here.
Interviewed by law enforcement.
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds.
His answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross? No. Thank you, sir. You may step down and you are excused.
Ha! We're going to blow right through him, Darrell. Hurry up, brother.
Go ahead, call your next witness.
Shuffle them
When we get to
papers.
the next break, I have something to discuss outside of the presence of the jury that pleases the court.
Do you want to do that now or after your next
We
witness?
can.
Oh, God.
Address a legal
Why?
issue, and we'll bring the jury back in when we're ready.
Why? Just let it go for a while. This jury's going to have so many pee breaks, they're going to wear out the toilet. Yes. Yes. No more witnesses. Case closed. Charges dismissed, Your Honor. Outside the presidents of the court. Yes. Yes, Axio, stall. Oh, God, stall. But he did it the right way. He didn't act like a fucking lunatic. I mean, Darrell, you did it without losing your mind. Good job this
Everyone can
time.
have a seat, and then we'll just wait for the door to close.
Yep.
Go
Subject
ahead, Mr.
matter
Brooks.
jurisdiction.
I'm curious.
He's like, I'm just going to plead guilty now. I'm sure you're curious about a lot
Some
of
of
things.
these, judging by the reports, how's
Lay it on me,
some of
Darrell.
these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
Yeah, you're not.
I'm
making it clear
asking.
here.
What I'm asking is,
Use an example. Use an example, Darrell. Come on.
reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just
Yes, you can impeach people.
to be blunt, which I've been since the beginning.
I'm
of this
sure
trial,
you
obviously.
you like your blunts, Darrell.
I
You're
see
in-
the whole strategy here by the prosecution.
Your intellect is as blunt as a
I see
fucking
right through it.
basketball. You see right through it.
Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
No, the jury,
Sure.
they have pictures of you running
You could
fucking
ask
people
questions that
over.
establish
That's all they
that. You
need.
can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other
Fucking
witnesses
galaxy
that's
brain
if
not-
you're
Darrell
asking me
here.
to strike their testimony based
I
on your
didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out. You're going to call your next witness.
If you're not asking a straight
I'm not
testimony,
hearing
then
a
what do you
request
care?
from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well,
Are we
disagree
sure
with
about
sir.
that?
Again, you
Are
could
we
ask
fucking
questions.
sure
You
you're
lay
not
a
stupid?
foundation
All of a sudden, the
with
state
these
don't got.
witnesses.
All of a sudden,
Just pump
for
that
the
brake,
first time
son.
in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well,
Yes,
this
it's
is argument-
strategy.
Come on, man.
This
It's
is argument on
strategy.
your part,
I
sir.
see
It
through
is
it.
pure
I just
commentary
want
at this
that on the
point.
record. I
It's
see through it.
entirely valid strategy.
And your
Nice try.
see-through
But I see through it.
has absolutely
Nice
no
try,
basis
you're still
in the
fucked.
Yeah,
fact.
I know that's what's being done.
You could
on, man.
ask
I'm
these
being
questions.
done.
You could
Come on,
ask
man.
these
You got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
far from an idiot.
They're your witnesses,
Ah!
sir. If you believe,
So I'm gonna start asking every witness up here
Sorry,
that they
Kirsten.
seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find
Yes.
it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't
proceedings.
recall what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury
Come on,
brought
man.
out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss
New poll is
that.
up.
I would like to provide the defendant and the court
I assume
a copy
So that had
of
to be
the-
said. So it was the defendant.
That's not how it was said. I
That was how I
completely
said. You want to run the
disagree.
record back?
Mr. Brooks,
Rob Dory, you're
I'm the only
100%
one. I got
right.
one.
Mr.
I got one
Brooks.
ear that work, and I heard that.
this
Come on, man.
is to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit me.
witness
So let's
as
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Like I don't know who y'all.
Oh, come on, man. Come on, man.
I'll set the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell?
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003, criminal trespass to dwelling from
yes.
2006.
All right, I need to take a
Reveal
break.
the verdict.
This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Hmm.
And we're
Oh,
taking a
don't
break.
say you're scared, Judge. Fucking have him tasered. Oh, we might get him to fight. We might get him to. Oh, they turned away the camera. Yes, was that a table bang? Somebody asked. Yes. He got big mad, big sad, and Darrell doesn't like being told what to do, so he just pound his hands on the table and go, I'm gonna stare you down, Judge. I'm gonna stare you down. I don't know what the fuck this is gonna do, but I'm gonna stare you down. Cry baby bitch. I mean, this just shows you, like, out on the street, you could fucking tell this guy off and he'd run away like a little fucking bitch. Little bitch boy Darrell. Yes. So what was that whole thing about? So where are we with this right now? So I think he was trying to argue he should be able to show that there's issues with, you said this guy had a black jacket on. Well, and the kid said, I don't remember. That's a valid answer. If you don't remember what you said previously, that is a 100% acceptable answer. Then he could refresh the recollection. He could attempt to. And he could say, would it refresh? Would you, if I told you that you told the cops, you know, if it was in a report that you told the cops the guy had a black jacket on, would you believe that you said that? Okay. But what does that go to? Now, Darrell's going to say, I wasn't wearing a black jacket. I was only wearing a gray sweater. But then he has to deal with the other witnesses where he tried to say, well, I wasn't wearing a gray sweater. I was wearing a red shirt. There's a lot of problems with this. It's layers upon layers upon layers upon layers of stupidity and incompetence. I think that's what Darrell's trying to get at, but who knows? Yes, and the judge said, yes, can you question witnesses over what they say? Yes, she can't tell him how. And then, the prosecutors, they're not asking to they're not asking for cross because they rigged this already. I see for what it is. No, Darrell, we just watched you kill everybody, so we already know what this is. I mean, my God, this is just absolutely fucking pathetic. I don't, he is truly stupid outside of being a street hustler. That's the sad part. American Virtual says he was staring down the judge way longer yesterday and she didn't say anything. Well, he smashed the table today and was like all angry about it. Bitch made, to quote the great Drex, bitch made pussy ass bitch. That's all he is right there, Darrell. If any of his family's watching, Darrell's a bitch. Exo Wright says, I think his plan isn't working. I think he's getting frustrated because he doesn't understand what's going on. And it's making it even worse for him. Yes, Dr. Mimo, this is a true quote. If the facts and law are against you, argue the law. If the law is against you, argue the facts. If the law and the facts are against you, pound the table and yell. And I've been in that third position before. But yes, he's very much pounding the table and yelling. Is there a hot mic right now? I don't know. Right now, we're not buffering. Everything's fine. To all law students says, he still hasn't found the ACM module. Very true. He said that they are rushing the case, so it's how about they are rushing the case? They're allowed to. They don't have to interview. These people are not helpful at all to him, and they aren't doing anything. There's no reason to be there. Legally Leah says, oh, I love a profanity permitted stream. Let me subscribe. Well, yes. This is not a Christian Minecraft server, to say the least. Gigi, thank you very much. Kyle Bogue says, sick the bailiff on him for $5. Yes. I was wondering if that was going to happen. Darrell is realizing he's an idiot. Yeah, I think he realizes that he's running out of options here and it's not working. We can hear your pee bottle. No, I'm not. It's not a pee bottle. I was pouring into the cup. Also, we're going to get through some of these things that were started earlier. Cole Murdoch says, Sean, do you ever work in Stark County? I will for the right, send me, if you have a legal issue in Stark County down in Canton, send me an email. It's down below in the open up the show more in the description. You'll see an email address. Get a hold of me or get a hold of me through my website. Either way, whichever you prefer. I might. It depends. I mean, it might cost you a little bit more because I am traveling, and to Canton is almost 2 hours. But get in touch with me. I might. We might be able to work something out. So yeah, it's possible. Ryan Nolan for $5. Thanks for the support, Ryan. What are the odds Judge's giant coffee cup is 20% bourbon by now? Oh, I think 20% bourbon and a little Xanax sprinkled in there. Just a map for $5 says, you messing with the wrong one, Judge. Now I need another White Claw advertisement for this torture. Yes, White Claw, the exclusive drink of potentially criminal. When you don't want to obey the laws, have a White Claw. Kyle Bogue is a new member. Kyle, thank you very much for the support. I truly appreciate it. Very, very much. Let's see here. Night Hunter 28 says they should show all the victims he killed as a slideshow there in closing. They probably will. They'll probably have their pictures up there. That's something that's going to happen. Very likely. I mean, but that said, though, they've been doing pretty good. Mendover says he was driving, not traveling. Yeah, not driving, traveling. Yeah. That's how he's going to get out of this. Eric Rollins for $2. It was a pee bottle. No, it was not. And Wild. Hey, from New Zealand. Well, hello. Thanks for tuning in. You guys are, geez, it's like 7 a.m. Saturday morning, I think, for you guys. Watching this fool go down is entertaining. What if he did wasn't so, what if he did, if what he did wasn't so terrible, he's just a joke. Yeah, if this was just some like kind of like run-of-the-mill misdemeanors, this would be hilarious. But it's partially like really disturbing because this is a multiple murders and what I still think is a terrorist attack. Racially motivated terrorist attack. And I hear the hot mic still running, which is interesting. Then I meet the courtroom. Beauty in her brain says, make sure you enjoy this beautiful Cleveland weather while it's here. Yeah, it's getting nice out. I mean, it's almost 70 and it's going to be like that for the weekend. Richard Gruber says, Claw's Law, taxation is theft. Yes, it is true. And also, guys, if you are interested, they have, if you're interested in some for here, and this is available to everybody. We'll get back to the thing in a second here. If you guys were wondering the mug I have, it is the Brooks Coffee Company out of Waukesha, Wisconsin, serving relevant grounds since 2022. You can find it down at the link below in my merch store. Well, let's get back to the show. Let's see if we can hear him cry and throw another tantrum. Musical chairs for the jury. The jury has not been in the room. They're not there while this is all going on. Matthew Brown says, I'm late to the party. Why is the guy defending himself? Because he's an asshole who thinks he's smarter than everybody. He intentionally rejected the public defender's office because he thinks he's smart and because he learned a bunch of sovereign citizen nonsense while sitting in the jail. So I mentioned this before. This is like watching a guy pack his own parachute. So I hope you enjoy it, Matthew. Thank you for being here. It'll be a fun time. Did she remove him again? I'm not sure if she removed him, but she did want to take a break because he was being angry. Use the word narcissist without a nada gets you blocked. That sucks. Mr. Deadhead69 says, I got to say, I've been jumping around the law rooms, and you were the easiest listen to talk to. Well, thank you. I appreciate that. Garrett Pace says, Darrell's going into rectum panic mode. He might be. Oh, Legally Leah says, I had my first White Claw at my law school alumni social last Friday. I liked it. It's good stuff. Can't have it all the time, but it's nice to enjoy. Objection to pee bottle. It's not the pee bottle. It's not the Tuma either. Random Lombax 37 says, I'll settle for Electric Avenue. Yeah. Too bad that doesn't happen in Wisconsin, though. Yes, Mema X, I think this is correct. He thought the reason the state had something to hide by dropping the witnesses, he's now realizing the real reason, and he's in panic mode. Yeah, these just might not have been the best witnesses. And this kid doesn't offer anything else that has already been introduced by other people. And when you think about the case they presented so far, it's actually really good. And getting rid of this guy was actually a good idea. Getting rid of these other people so far were good ideas. And yes, I think he's starting to, it's multiple things that are going on. He's getting frustrated that he can't do what he wants to do. But I also think, he's starting to panic that he can't find anything here. Okay. Betsy, that's an awesome mug. Thank you. Yeah. Yeah, took about 25 minutes on Photoshop to work on. Also, by the way, designed completely by me. M. Wild says he will appeal citing ineffective assistance of counsel. The neat thing is he can't actually do that. If you represent yourself, you waive that right. Okay, so we got a new poll results after 34 minutes. Or I'm sorry, 13 minutes, 365 votes. Darrell is stupid. Yes, 67%. No, 8%. LOL, 24%. Claw, claw, claw. Yep. Claw, claw, claw. Yep. I love the claws. Maisie, thank you. I appreciate it. He said it's not his life too bad. The dead can't say the same. Yep. For sure. For sure. Do you think this judge will get her payback during sentencing? I don't know. Judge Doro, I assume she's been very professional, very dedicated to her job. I assume she's not going to be. No, it's just a matter of law. If you commit first-degree intentional homicide, life without parole. So, boom, done. I don't expect anything bad to happen. I think she's going to do a very good job. I expect nothing but professionalism from her, given how she's done this case. Nothing but professional. Mr. Young, this is 100% a very good question. Thank you for asking it. Do you see a professional defense team making an argument about the lack of intent and motive? Maybe along the lines of he panicked or had flight instinct. Can't believe he's acting this way instead. Yes, I think there's multiple ways this could have been argued. That he was fight or flight. He panicked. He got stuck and then ended up on the parade route, didn't know where to go. Yeah, those are things that you could have argued very easily. But he didn't, and he hasn't. And when you're making those arguments, though, you're changing it from first-degree intentional homicide to maybe second-degree homicide or maybe manslaughter, which still means he's going away for a long time, but at least he'd have a chance of getting out. And that would be the victory. But yes, I could see his public defenders trying to make that argument. And it sounds like for some of the questions he was asking out of the information they had prepared already, they were going to try to do that. But he has completely and inarticulately screwed that up. But yes, I definitely think that could have happened, and that would have been the goal. I can't believe he's acting this way instead. I can. He's an idiot. He's lived his life being an asshole, causing problems, doing whatever he wants. Tom Gillis says he's LawTube's cell annex attorney now. Yes. DC says, whose record was the prosecution talking about? There's one of the witnesses that he intends to call next has a criminal record, and it sounds like there are issues that have to get brought up about his criminal record. There are things that if you have, for example, a felony within the past 10 years, typically, that have to be disclosed. You have the right to disclose that to the jury because it goes towards credibility. And the other big one is if you ever had a conviction for a crime of moral turpitude or deception, generally meaning theft, but also other types of things. Theft, stealing welfare, misusing things, misusing vehicles, providing false information to law enforcement. Because those, even if they're misdemeanors, because those go towards your credibility because you've outright lied. So it sounds like this next witness may have some credibility issues because of his convictions. So we'll find out what that's going to be about. Okay, let's see here. Oh, I got my mug in the mail. Thought I was getting a Cardinal hat. Yeah, I need to find a good one. But also, some of those Berettas are like hideously expensive. I don't need like a super expensive one. I just need like a normal priced one. Will this be a Lifetime movie? No, it's already taking all of our lifetimes so far. John Bubba says, but before that happens, he's going to see more sausage than Jimmy Dean. Oof. Yeah. Ryan Nolan saying, oh, hold on. Actually, sorry. This is what I meant. Jamiro Face. Jamiro Face says, I get the feeling the not guilty by reason of insanity was the sole reason why he wanted to represent himself, because insanity offended him. And that does. I've had that happen before with clients where you tell them, look, we're filing a not guilty by reason of insanity, and they lose their crap because they're offended at the notion they might be insane or suffer some mental health issues. Oh, Steve Yeager. Brooks is what you get when you order B. Ivory Lamar from Wish. And if you guys don't remember B. Ivory Lamar, he is the attorney in the Theodore Edgecombe trial I covered way back at the beginning of the year. Shunka Bacon says, I bet he tries to object to the victim impact statements. I definitely could see that. I wonder if his former public... Ray is saying, I wonder if his former public defenders are watching and cringing. Yeah, well... Excuse me. I think they're cringing and watching, but I think they're also happy they dodged a bullet. Like, they didn't have to do the trial. And they can focus on people who do want help. Is there an end sometime? Eliza Krogan's asking. Yeah, probably about 5:30 or so Eastern Standard Time. We to Pastime 7 says, will he testify? That's still up in the air, but at this point, I actually don't know. I could see him being a little bitch baby about it, and he might give it up accidentally. Garrett Pace says, we should crowdsource a Sibian for Judge Mommy. Yeah, that'd be interesting. Mema X is a new member. Thank you. I appreciate it, sir. Thank you for the support. Potentially criminal. Do you mind clones at all? What do you mean, like real clones, or I'm confused. Aiden Higgins says, sent the funniest meme on the web messenger to look at. Still laughing here in Ireland. Great work. Oh, Daniela says, check out the meme Kurt posted on YouTube. Oh, is that on his community page? Let's see here. Oh my God. This is good. All right, we're gonna get this one. Holy Jesus, this is hilarious. Ha ha! Yes, how it's going. Judge Mommy versus Darrell. Objection, grounds. Would it be fair to say, or eye roll? Darrell tries, grounds, but it wasn't very effective. Judge Mommy does, Allen versus Illinois, and it was super critical damage. That is awesome. That is beautiful. The internet is a beautiful place at times. Oh, I love it so. Well, people are stirring. We might be back in time. Ellen is saying, Do you think he thought or expected the prosecution to challenge the kid for not remembering? I think he thought they would. Yeah, I think he thought the prosecution would be more involved in attacking people. It just didn't work out the way he thought. And it's not going the way he plans or meeting his idea of what would happen. Oh my gosh, this is perfect. It's already a movie meme already tied in. You guys remember Shawshank? Oof, 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 oof. Yes, Brooks is here. He's effectively hanging himself in front of her. He's committing suicide. So I think that is very appropriate. Yep, we still got the sound booster going. Good. What that business? What that business? Casey in NorCal says, with all the interruptions by dumbass, I'm finally live. See, it does help out after all. Yes, Dan Mossy says, could you see Borowski saying, I'm scared? Yeah, I never would see that. Rob Dorr says, the public defenders I work for are laughing their asses off watching this. I bet they are. But I bet in the Wisconsin State Public Defender's Office, a bunch of them are just breathing a nice sigh of relief and are getting ready to have a nice long happy hour tonight. Liz Bott says, this judge is also the sentencing judge. Correct. In America, the judge who handles your trial handles your case, handles your whole case. Pre-trial, trial, and post-conviction, which generally includes sentencing. Edward Karpinski says Judge Wapner. Oh, random Lumbax. You're talking about firearm clones. You were talking about Beretta. No, a Biretta, a Beretta. The hat Cardinals wear. But yes, the Taurus knockoffs of the Beretta are fine. If that's your game. But yeah, a lot of firearm clones are fine. Ginger, I don't know if the judge is pregnant, but yes, he was staring her down and trying to intimidate her because that's all he's got. He intimidates and treats women like shit because that's all he can do. Certainly, he tries to treat the average guy like this. They wouldn't listen to him or they knock his teeth out. Beat his ass up and throw him back into mommy's car. Mr. Squiggle says, Darrell used glare. Judge is paralyzed in fear. Two law student says, what was the Bundy pro se defense like? Actually, very good. Bundy went through the trial. There were no problems, no outburst. Bundy conducted himself very, very well. He still gets convicted and sentenced to death, but he did a very good, quiet, and effective job. He did it like an attorney would do. So Bundy was very well known and impressed a lot of people. He did a decent job. But Bundy was also really, really fucking smart compared to this guy. Yes. Anytime the prison sentence is mandatory. It's life without parole. I don't know why mandatory came up for, but yes.
They were before.
All right, crybaby, let's go.
I'd like to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness.
Let's go, crybaby.
I trust that you're ready to do that, sir. right, then.
And we need to complete the task of.
Oh,
the
we do.
priors for
I
Mr.
knew I would left something in.
I got to
my
pay the
office,
water
but
bill,
I
guys. 1
reviewed it,
second.
So go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor. And that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that. And obviously that would not have been a crime, but everything from OWI second on down, we believe would be appropriate. There's also one that's noted 06 CM 2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr.
We'll get to this, Michael.
That was going to be kind of my next topic once. Thank you. I look at this again. All right, Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
Come on, Darrell. Don't bitch out now, dude. You got to hang tight. I bet he's got Romans 13. Yeah. Come on, baby. It's the heat of battle. Let's go. You got to do it.
I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior
I don't know what you're asking. Oh, he sounds so broken.
convictions.
He's sad, everybody.
I think maybe we
Poor
only discussed that
Darrell.
if you were to testify, we would have to have that conversation. So in fairness, I don't,
No, there was one state's witness that had one.
He's in
prior
E-war
that
mode.
we
I
discussed.
just don't
That's
know
right.
no
We
more.
I recall now.
I'm
So-
sad.
At that point, I directed your attention to 90609. And then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
Cricket, cricket, cricket.
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000,
Emo
well, it's
cry boy.
recorded as 06 CM 2039. 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in. 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So
Not
no
playing anymore.
convictions from that file.
So why is it on the sheet?
Because it's his fucking criminal record and they give you everything to be
This
in
would be an accurate
transparency.
listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
Jesus. At least be aggressive and do this. Don't be a little girl. Come on, man.
And
Stand
nothing
up.
since
Grab your nuts, Darrell. Feel those notes.
2007.
That's
Let's
correct.
go.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
He's gonna be big mad, big sad. Everybody, Darrell's gonna be so sad. Whoa.
What is dismissed and read in? Does that mean there is no charge?
No, it means it was when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why my understanding why it was listed.
That's an interesting way of how they phrase it, because that's how we phrase it here. Guys,
so where it says
she's-
dismissed and read in, that would be the restraining order and the MBJ.
She has to do
Right,
this to help
misdemeanor bail
out.
jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in. And then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8 should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI.
Oh, no.
An OWI first would not be a crime, it would be a forfeiture.
Oh my God. Oh my God, it's horrible. Yes, wake up. This is awful.
I still would say 8 just based on the fact that there's continued OWIs. All the way up to a 5th.
Remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case, convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Less than what, 8?
Well, it'd be less than 7. He has 7 convictions as I count them.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7. Should be 7.
What?
All right. Do you want to make any argument about whether any should be excluded under the statute based upon the factors I just read to you?
Well, you already made reference to one of them not being a crime. So that brings it to
What?
8.
Oh
I
my
don't
God.
understand the whole.
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
I don't want to speculate on the next man's life, but if it's 7 on here, well, I guess it brings it to 7. And whether OWI first is not a crime, it still counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first.
What?
Looks like 7 to me.
All right, then. Anything further from the state on this?
Oh.
Given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993. And
That's
without
ridiculous.
That, you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span.
Yes.
It's now 2022.
This is his own witness.
Essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Lozano before he testifies, Your Honor, I believe.
I agree. State willing to relay that information?
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr. Lozano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
You know, Rob, I'm confused about what the hell he's trying to do here.
Who's present right now?
For sure, Mr. Hayes and Mr. Lozano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
All right, so Hayes and Lozano are still here.
Yes.
All right.
Yes,
Those are the 2 who are here, sir. I'll tell you what, either way, let's just bring Mr. Lozano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in. And
Oh, no, that's not good.
Victim witness could bring him in.
This is absolutely confusing. We just went through all that fucking nonsense.
Can I have a first name?
Also,
for this
real
witness,
quick,
please?
Michael. Oh, we'll have to get to this.
It's
Abel?
Abel,
Does-
but I
does-
believe it's pronounced a different way.
The Jaquetto, Michael, is that little thing they wear on top of their head that looks like a big yarmulke. The Beretta is that red thing that's got the fins
Abel,
on it.
Thank you.
Looks like a lunch box, like a box lunch.
Subject matter jurisdiction, Your Honor.
Oh, for fuck's sake!
Still has yet to be
Oh,
verified
reliable.
for the record.
Your objection's noted for the record.
His eyeballs are buffering, yeah. He looks very tired himself. He's like on the verge
Do
of
you want
giving
Mr.
up.
Lozano on the stand, or are you going to call Mr. Hayes first? Just so I know what to do when he comes in.
Uh-oh, he's crashing.
I can't find paperwork from Mr. Hayes. Can a police report or something be provided in case I want to call Mr. Hayes first?
I'm surprised prosecutors tell him to fuck off.
Yes, we will accommodate that request. It'll just take me a minute, Your Honor, to find it.
Wow, they're
I'll have
being
to have
very
it
nice
printed and
still
brought over.
after all that bullshit.
Or Mr. Wichow can run Thank you, Mr.
I will give you
Mitchell.
permission to email it to Teresa and she can print it in the courtroom.
Oh my
Well,
God.
It's part of a 700-page PDF, so I can't just email one page.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
That's all right. You can do it the way that you need to.
They are being very nice, even after all the shit talking he just did to them.
All right.
They're going to allow this still? Wow.
Liscano, I'm just going to have you for a moment.
Good for them.
Take
Better
a
than me.
seat.
I would have said
You're
fuck
not going to
off.
testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to have you come up to the witness stand. Everyone can have a seat. I want to advise you that I'm aware you have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then.
I paid
Thank
a
you.
water bill earlier.
All right, then let's have the jury brought out, please.
Oh, okay. Well, yeah, you're very familiar. Yeah, I assume you probably know Wisconsin law pretty well. But I appreciated Rob chiming in. Also, Rob, I don't know if have you ever gotten in touch with Nick Ricada? Because you guys are both in Minnesota. Just a thought. Minnesota. Yes. Awkward turtle. Awkward turtle. My God, it's been so long since I've done that.
All rise.
Wrestler Town says they're being nice because they're enjoying it, beating him down. Yes, but it's also because they're professionals at the end of the day. They are consummate professionals. I give Sue Opper's office, I think it seems like they're pretty upright people, which you don't always get in a DA's office. I mean, I will give her credit. They seem like they shoot pretty straight. And that's not always common. So, yes, my hat's off to her. If you live in Waukesha County, I think you've got a pretty good DA there. Even if she does sound like this all the time. Oh, got to get the casserole in.
Everyone, please be seated.
Yeah.
The defense may call its next witness.
Here come the aneurysm EMT standby.
Is it Jason Hayes? Jason?
All right. We'll have the witness brought in.
I'll get him in touch with you if you want. I'll give him your information. Don't worry though. Like, I've had to email him before, and it's taken a while for him to get back to me too, because he gets like a million emails. I finally have his phone number, so it actually helps.
Is it Haynes or Hayes? Does anyone know?
No end for the best night ever.
Hayes?
No end, no.
All right. Good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir. Your witness.
Just 1 second. I accept for value and return for value this document for the record. Good afternoon, Mr. Hayes. Is that how you pronounce it, Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide,
Been doing that for a long time?
21 years.
Yes, it's a long time. The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
What were you doing that evening?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
Were you scheduled to do any marching in the parade itself,
No.
or just spectating?
Yes.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah, yeah.
I just wanted to make sure there was.
Yeah, he answered. He answered. Anything unusual catch your eye that day that you recall?
Yes.
And what did you see?
Besides the parade,
Yeah, I'm sorry. That was unusual that caught your eye that evening.
well, where we were, yes, a red truck came through where we were. It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that
We
time?
were all the way at the beginning of the parade.
Okay.
Like it was Main and the corner of Main and White Rock.
Okay. And you said you observed this vehicle honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it? I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
So well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main East to the same route the parade went.
Did you get a description of who was driving the vehicle you saw that
I
day?
did not.
Did you get a license plate?
Did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did. By a detective.
And do you recall if that was the same evening, or
It was not the same evening.
so
It was a
that-
couple
days
days
prior?
after.
Okay. Do you recall in that interview that you had with the detective stating that Your kids were playing in the roadway, and the operator of the vehicle honked the horn several times and veered to the left around the kids.
Yes,
So, in your opinion, it wasn't trying to strike the kids.
correct. Yes.
And after it continued, I think you said east.
Yep.
Would that be correct? East.
Yep.
Did you see the vehicle strike anyone? When
I did not. No.
Do you recall what side of the street the vehicle was traveling on at that
It
time?
was on the right side.
On the right side.
So we were on the north side of the road.
So the right side would be.
Yep.
Did you see the vehicle stay on the north side of the road for the duration of the time that you observed?
Yes.
So you never saw it go to the other side of the road, or
No.
Come on.
no further questions at this time?
Thank you. Any
Not yet, but close.
Yes, just briefly. Good afternoon, Mr. Hayes.
Good afternoon.
Thank
Yes,
you
what
for your
about the people I
attendance,
didn't
sir.
kill?
Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross.
It's cross. You get the lead all the time.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that?
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
That doesn't matter.
Overruled. The
Not relevant.
statement, continue asking the question.
I guess I was asking was that referring to
Doesn't matter.
interview officer?
Your objection is noted. It's
This
overruled.
guy spoke to an
Statement
officer.
asked
That's
the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection, speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirect, sir?
Briefly, very briefly.
very briefly.
You made a reference to the driver of the vehicle having a dark complexion.
Rob, thank you
what would
again
you
for
consider a
the
dark
membership
complexion?
gifts.
A dark complexion. I don't know.
It is kind of hard.
It's not that hard. He
Did
can
you
say a lot of
notice,
things.
Any clothing?
I did
on
not
the driver?
know.
Did you notice any hair?
No.
I offer for value return. Good job. Yes.
No further questions.
Oh, you got him.
You may sit down.
Daryl's like, God, that went great, guys.
You are excused.
I mean, it went good in the sense you didn't screw up. Did it go good in the sense you didn't mess up? Yes, but you also didn't hit a home run there, man. So
Are you going to call Mr. Lascano?
It would appear so. He's the one that's here.
All right, then he may. Defense is calling.
why are you
Darrell
such a dick?
Lascano.
Oh, I called him.
Correct?
Guess he's here. We don't know what you're doing half the time, asshole.
The defense is calling Abel Lascano.
All right, very well. We'll have him brought in. Thank you.
Amazon guy, I think, dropped something off. Give me 1 second, guys.
Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. And my clerk Teresa, who will be across from you or is across from you, will swear you in. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Lascano, ABEL LAZZANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Lascano. What do you do for a living currently?
I'm a hairdresser.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Do you recall the night of November 21st, 2021 pretty well? I know it's been a minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Okay. Is that part of Main Street close to like a side street? If you recall,
it's not too far from Maple.
Do you recall the side streets? Being barricaded during the parade?
Yeah, I don't remember.
Do you recall what time you arrived at
Jesus.
the parade that evening?
Yeah, it just started. So whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And
We'll get to
did you
this.
see the driver of this SUV you're referring to?
Yeah, you're standing right there.
What do you mean by you? And
And how many people did you see in the vehicle?
Just one, the driver.
You, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
I'm gonna attempt to see if anything brings back some recollection. First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Oh wow, this
Do
guy
you
really
recall
remembers
telling
that.
Officer Moss
Good.
that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
This is where you'd say, if you said that in a report, would you agree that's what you told them? If this was in a report, would you agree with that? There's ways he can work this guy. There are ways he can work this, but he's just not doing it.
To your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
Secondary issue.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Is that all you recall about your description?
That's all I remember.
Yes, this guy's about that.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
I believe it's the Lindholm or building on Maple Street.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop. No.
Yeah, that's great.
Did
see it stop. Brilliant, Darrell.
And speaking with, is it Detective Moss?
This is going to help you so much now.
Well, speaking with law enforcement that evening, do you recall advising law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this. I'm referring to page 4 exactly.
Objection. He didn't write this. He didn't author that report.
This witness personally wrote.
I believe it's what I don't think he wrote it himself.
That's not
written by another person.
By I don't know if it's Officer Moss or Detective Moss. I'm not sure what his rank is.
Continue with your questions. I'm going to deny the request that you show the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says 1 was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other 2 were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that 1 black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
A Barely, a little bit of that.
So
This is actually how you do it, Darrell. Good job. You finally
which
figured
of
this out a
these
little bit.
subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle.
Good job,
where I
slightly.
spotted it.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
Well, I was walking my family back to the car. Try to get them to safety. So I was keeping an eye out and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall
Nobody saw
why
that.
that would be reported?
No. When I found it, it was parked already.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to where the vehicle was ultimately found?
Yeah.
Do you recall yelling at subjects standing outside of the building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
This is fucking slow.
Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
Did you file a claim? Are you an injured party? Do you know the state of Wisconsin? Yeah, guys, the long and the short of it is apparently he claims there were 3 black guys in the car, and Darrell thinks it's going to get him some sort of reasonable doubt. But you can tell this guy's testimony, even if the state had brought him on, he's not going to have good testimony, period. You know, all he says is the car didn't stop. So it's not very good overall. And he didn't suffer any losses to his family or injuries to his family. So I think that's part of the prosecution streamlining of it. This was entirely just junk.
Do you recall stating that? Well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
Yes, I did.
Do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening.
Sure. Okay, great. Yes, SAS. They gave him a copy of this report.
Do you recall?
They're reading off along with him.
In your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
Yeah.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, and is in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
Any reason why the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Ooh, oh. Brilliant fucking thing, Darrell. Glad that got brought in. Yes, just keep having this guy keep talking about when the driver hit someone. Repeatedly.
Do you recall in your interview with Detective Coates that evening stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so clarification. The 3 individuals who were standing in a line, shoulder to shoulder, as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
I saw at least 2 of them. And looked like they were standing in front of it.
Come on, Darrell.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
I don't remember.
Yeah. This is it, guys. He thinks he's got it. He's right there. He thinks he's on the precipice. He's about to bring it home. About to bring home that not guilty. This is asinine. He's getting to the point where
Any reason why multiple, well, I'm not going to say multiple, two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
has no fucking idea why. Guys, this comes back to the whole, is the pen in his pocket
And
that blue ink or
during
black
the
ink?
parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
Yeah, guys, this comes back to
Yes, Your Honor,
every
thank you.
stupid little
Good afternoon,
inconsistency.
Mr. Lascano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes? Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overruled, Ms. Cross.
They're allowed to fucking
No,
lead on
negative.
cross.
Objection.
Overruled. The witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection, speculative.
Overruled.
That's not speculation at
About
all.
how many people did you see the SUV strike, sir?
Objection, speculative.
A ton.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way.
Yeah.
And then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in there.
Oof.
You remember that?
Yeah, it was
That's
right in front of
brilliant.
us.
Good job, Darrell. This is a helpful
Well, the
witness.
was giving the answer, not the last answer, but the one prior to that. He had his right hand in the air, directioning his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the
But did
air.
it honk?
All right, go ahead.
Thank you. So, Mr. Lascano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Oh, they're going to let him watch some
Go ahead.
stuff now. Oh, boy. Peter Jordan, do you like pina coladas?
Objection to the relevancy of Exhibit 65.
And getting caught in the
Noted,
rain.
overruled. It's been received. The state.
If you
may
own a
proceed.
Ford Escape,
This
You can
total
cause a
clip is
parade.
36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection,
Okay.
speculative.
Overruled. His answer may stand. He said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection, leading.
Overruled.
it's leading. It's cross, bro.
You may answer.
That's how this
Yeah.
works.
That looks right, correct, sir?
Objection, leading.
Overruled.
Oh, Rob,
All right,
no,
we're
no,
gonna,
no, no. Oh,
clear the
no, no,
screen.
no.
Please, and we're going to play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your
All right,
family
I'm already
members in
going
this
to.
clip.
Objection to the relevancy of this video to this particular witness.
Overruled.
They've already labeled. He could identify stuff, Darrell.
Overruled on what grounds, Your Honor?
Notice they just ignored you now, Darrell. Just flat out ignored you, brother.
Is that a tacit agreement?
Yes, it's tack it. It's tack it. Tack it on the wall. Just go tack it up. Jesus, Darrell.
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, it's not.
No, I did not.
Let me get see himself.
Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection, mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection, stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 more people. I don't know if they were, I'm sure they were white, but
okay.
I was trying to not make it obvious because at the time, I believe that they were with the vehicle. So I didn't want them to see that I saw them. So I just did what I thought was right at the time.
He knew better to be seen.
Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
No, I do not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection, there was never any crash mentioned.
I'll sustain. Calls for speculation.
Actually, not.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you
Objection
did?
speculative.
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection, mischaracterization of testimony.
Overruled.
That's not
Yes,
a
it was.
mischaracterization at all.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay. You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
Yes, he's sitting right over there.
Ooh,
Are you sure about
buddy.
that, sir?
Yes.
Objection
What are you,
speculative.
grounds?
Overruled.
No, come on, Joe. You gotta get them grounds out, son.
You
That
said that.
mischaracterizes the testimony because that was not testified to before on direct.
He said he
Your
saw
objections
you.
are overruled. I believe the
He said he
witness
saw
already
you.
Answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it,
you?
no.
Okay, just wondered. Mr. Liscano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case through your testimony?
Objection hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
He was dressed
Did
like a
you see
dumbass, like you.
if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast.
Well,
down
there's
the
state of
street.
Wisconsin again, sitting there in the other courtroom.
I wasn't paying attention to the color of clothes you were wearing. I knew
They
it was a
put him in
black
the courtroom.
male and had a scruffy beard. The first thing I told my wife is he was a black guy driving.
Oh, God. Yes. He looked like you. Oh, my God. Kill me now, Jesus. Take me now.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
Well, it had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard. You can tell if you were white or if you were black and if you had a beard or not. That's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
Ooh! Get it, son. Get it, buddy. Yes.
So that leads back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people
Just
around the
one look.
vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those
Critical
officers
lesson here, guys.
reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives,
both,
that you observed 3 or 4 people in the SUV.
Both.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this.
Oh, there we go.
To both detectives.
Both.
2 different detectives.
Both.
The evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was.
Yep, while you were
later
running
found.
people down.
Any
Beautiful.
reason why you stated to both detectives in relation to what you saw at the parade? Why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
Objection asked and answered. Objection.
What's your question?
The question is, why did you
I don't get
report that
Bruh.
to 2 different detectives on the same evening?
Deleted.
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
And during both interviews with detectives that evening, the evening of November 21st, 2021, you also stated to both detectives that you observed 3 or 4 Black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Thank you, sir. You may step down.
Because you're misstating what he told the cops, and they probably took a shitty report.
We have additional witnesses here.
Yes, Your Honor, they're ready.
It still doesn't.
All right, would that be how many people?
There's 2 left.
Okay. So the 2 left on your list. Your next witness, sir.
This is a fucking joke, Darrell. That did not help you at all because the guy said, "I watched you do it.
Guessing that's
You were the driver."
Oh,
you know.
I know who it is.
This guy kept saying, "You're the driver. You're the one who ran everybody over."
Second, Your Honor.
That's it.
One quick second.
That's it.
Go ahead.
I mean, the guy said, "I saw you driving. You're the one who did it." It doesn't matter if the fucking Harlem Globetrotters are in the car with you, brother. You're the one who did it, man. You ran those people down. You just he kept on saying it, and the jury kept hearing him say it. Good job. Jamie says, for $4.99, I'm confused. If these witnesses weren't called by the prosecution, why is calling them to catch them lying? I brought this up before and I keep bringing it up. He's trying to say, well, I had a pen in my pocket. What color was the ink? Oh, you don't know? You must not be credible. What color shoes was I wearing? Red or blue? What color hat was I wearing? Was my shirt inside out or not? Oh, you don't know? You must not be credible. You said I'd walk down the left side of the sidewalk and I walked down the right side of the street. You must not be credible.
Sorry about that, Your Honor.
That's
just making sure I have
he's
correct paperwork.
Bullshitting people like this, so that's a problem, and it's not helping. He's trying to poke holes where it doesn't matter. No Pants Baby says, "Hey Sean, dropping you like this judge is a weak C word." I still don't think she is. Should have defaulted his case yesterday. No, she's got to give him the chance to get through it. She can't just 90611 the whole thing right away. She's got to do it step by step by step. Bass for $1.99 says, "Objection, me have brain damage." I'm about there with you. William says, when they show us the other room, they're showing us where he's going to get sent soon. Oh, funny, funny, funny. Bass for $4.99 says, Darrell, if they are embedded in your grill, it doesn't count as the SUV. I don't think they're all white people, but funny.
So much paperwork.
Tweety Tweet says, what was the purpose of the issue with this witness's felony conviction? A felony conviction, if in a relevant time period, can be used to show that person lacks credibility in their testimony. Because there's the idea if they are a felon, traditionally people did not trust whatever they had to say. But in the the past 100 years, all kinds of crimes are now felonies, so it's not the same. But a jury is allowed to infer from somebody's criminal record that they are not credible. Let's see here. Yeah, somebody's saying these are all blank pieces of paper. Very good chance they are with him. Very good chance they are with him. 709 people here, guys. Thank you for sticking around. My name's Sean Martin. I run Potentially Criminal. I'm a defense attorney out of Cleveland, Ohio, and have the day off today. Well, I don't have any scheduled today, so I'm at home doing work, and we're following along with Darrell Brooks. He is trying to pack his own parachute, and it's not going very well. American Virtual, crimes of dishonesty are a separate factor. That's separate from the felony convictions. The crimes of dishonesty are a separate part of the criminal record for people. Pretty Mama Bear says the empty chair in the other room is putting on a better case. Well, that empty chair is not losing, so yes, it's doing better.
Okay, I'm ready, Your Honor.
Go ahead. Call your next witness.
Kathleen Urel?
Urel? That's how I think it is. We'll find out.
You ever blow your nose so hard and you get a little like spinny headed? Ooh. Wow.
All right, ma'am, if you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left, will swear you in. Go ahead and come all the way up. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Kathleen, Kathleen. Last name Urel, Yourell.
Thank you so much. Your witness, go ahead.
Good afternoon, Miss Urel. Is it Urel?
Urel.
Urel. What do you do for a living?
I'm in workforce management for a call center.
November 21st, 2021. Directing your attention there. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial meaning maybe a few minutes?
Until my group of children went by.
Okay. Do you recall where you were positioned during watching your?
Oh, come on.
Group participating in the
fucking
parade?
ridiculous.
Yes, on north and east, right on the corner there.
North and east.
If you're going parade route, it would be on the right-hand side.
Just so we have clarification, can we pull up the exhibit? I believe it's 15.
We can.
Thank you for watching, sir. I appreciate it.
Go ahead. And thank you.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet. Just I want to make sure the witness gets a chance to view it first. Can you see that?
Yeah, this woman
on
is
your
not
screen yet?
thrilled.
I do.
And using the touch screen
Bubba,
as a
we'll get
touch
to this.
screen, can you point out where
It's
you?
not published. So do you
Oh.
want it published?
I'm sorry. Yeah, publish.
Sorry, I didn't mean to interrupt, but I just wanted to point that
So
out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, can you, using the touchscreen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching it.
right on the corner. Sorry. Oh, well, if you want to
Can you clear,
erase it
can you
again,
clear
I'll do it
the
again.
arrow?
We'll clear it. You can do it again.
Yeah.
If you don't want, do you want the arrow?
Well, it was to the.
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was gonna
Can you
say
clear
that.
Well, I mean, it was right there, but.
I was gonna say a circle or a little dot if.
Well, I thought I was doing that, but.
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
There you go.
And you said that would be approximately East Main and Northeast.
Correct.
And do you recall if those will there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from here?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? Would that be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature.
Why? Why is this doing anything?
Well, all I can say is that I was walking past White Rock.
I don't know either.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across. When I was thinking it was going to leave the parade route, if you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade. And it went right to if you're looking at the parade, it was on the right-hand side. And it's continued on into the parade.
Hold on, just for the record, she was using her hands
Yeah.
during her testimony. I just need, that's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record about that. Go ahead. Next question.
I want to back up a little bit. When you first observed
Back it up.
the car, as you say, you recall that it was blowing its horn.
Yep, it was, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while.
Your mom doesn't do hentai. Oh crap! I didn't make that the right cut size. Your mom doesn't do hentai, sheeple.
Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No, I can't be sure. I'm sorry.
Eliza, the jury's sitting here now.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was, all I can state is it wasn't speeding.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Sarah, the jury's in the courtroom.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have clipped me or the two people that were in front of me.
Where you were, the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Good afternoon, Mr. Rowell. Thank you for being here. You testified on direct examination that you don't recall whether or not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed the driver
come
in the
on.
vehicle?
Don't fucking do this to me.
Yeah, I
Overruled, you may answer.
can't be too sure.
Overruled, she may answer.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I may have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Okay. Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
Thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street. Is that right?
Objection already answered that, asked and answered.
Overruled, you may answer.
You said correct.
Correct.
And after your children walked by in the parade, you walked in this direction towards the intersection of White Rock and Main. Is that correct?
Objection
Correct.
leading and speculative.
So overruled as to both, you may answer. If there is another objection, just
I'll
wait
pause.
until I rule on it.
Sorry.
Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street. Is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes.
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Urel?
Objection irrelevant.
Overruled. You may answer.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled.
Sorry.
Oh, Jesus.
Your oldest daughter, Charlotte, she was 14 at the time?
Yes.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
There was an objection, it's overruled.
Why would he call us witness? Because he's an
Well, I was
idiot.
Objecting, but okay. We still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry.
Overruled.
Okay, I'm sorry.
Objection hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection leading.
Overruled. You may answer.
Fucking idiot.
I was only able to see 2 of my children that night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care, the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled. You may answer.
Yes, the
You're
father-
proving injuries to other parties now,
Charlotte
Darrell.
suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection.
Dumb motherfucker. They're now establishing he injured more people.
You may answer.
Brilliant fucking work.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
That's serious injury in
Facial
most states.
scarring
Yes.
Serious
and
injury in
road
most states.
rash
Yes.
and a broken fibula and tibia
Broke. Serious injury.
Yes.
and broken metatarsal bones.
Yes.
Serious injury.
She was observed in a concussion protocol, is that correct?
She was.
Serious injury.
Your daughter Vivian, she was marching with the Extreme Dance Group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Overruled. You may answer.
Yes.
And road rash
Extreme road rash.
and a lung contusion
That sounds like serious injury to me.
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter, Vivian, suffered a broken tailbone, didn't she?
She did.
Your son, Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Jackson
correct.
Reed.
Overruled.
He was walking with the Extreme Dance Group, handing out candy. Is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
Ooh, that could have been
An
fatal.
open compound fracture.
Meaning the bone
Stuck through the skin.
came through the skin.
Yes.
Actually, here saying, I don't believe he's a doctor.
Overruled. The witness.
You don't need to. It's fucking obviously medical knowledge, you dumb fuck.
Was
That could have killed him.
Yes.
That's dangerous. Femoral artery, everything
A
right there.
police officer saved Grayson's life by placing a tourniquet on that
So he-
open leg wound. Is that
It
correct?
probably did
Yes.
sever his femoral
I don't have
artery.
any other questions.
Thank God.
Will you read the record?
Fucking brilliant job, you dumb motherfucker.
No regret.
You just got that shit brought up? Brilliant, Darrell. Brilliant. You must not have realized that was coming, did you? You didn't do your fucking homework. You called that lady up and she just fucked you ass in the raw. I mean, literally, just like
Can you call your next witness?
strap on you with a telephone pole. Your creosote laced balloon
You're gonna
knot.
take down these exhibitors. You're gonna stay up
Oh,
on there.
thank you. We'll take it down.
Yeah, you're covering up your mouth like, oh God, you're trying to hide. Ain't nowhere to hide for you now, you dumb shit. The jury just saw that. Bravo, Darrell. Bravo. Fucking raise your hands high, champ. Raise your hands held high, champ. Brilliant. Brilliant, brilliant, brilliant work. Yeah, I ain't flinched not one bit. Good
Can you call your
job.
next witness?
Just 1 second.
Good fucking job. Almost killed that kid if that cop hadn't been there with a medical tool. You dumb motherfucker. I mean,
Only one more person here,
Jesus
right?
criminy.
It's my understanding, sir.
Bringing light to this dark situation. I'm not trying to bring
Deputy,
light.
correct.
I'm just
Attorney Upper.
fucking stupefied.
Courtroom ready to go, Your Honor.
He needs a second to recover. Yeah, I don't think he realized that. And I don't know how he didn't, but once again, because he probably goes and sits there and masturbates on his tablet or something, or sits there and like watches his rap videos over and over and over again. Like, how did he not know this is somebody whose kids got run over? And not just like slightly injured,
Defense calls
like
Catrice.
critically
I don't
injured.
know how to say the last name.
Can you give me the spelling that you have?
Babiasz.
Timothy, that doesn't mean he lost a leg. It's just when you
What's
break
last
your
name? Fabias. All right.
when you break your
Thank you.
femur,
You are the witness.
there's all
Stand.
kinds of
Please raise your
arteries
right
and veins in
hand.
your leg.
My clerk, Teresa,
A lot of
will swear
leaky
you in.
boys.
Do you solemnly
No,
swear
that's
that the
just
testimony you're
it's
about to give shall
that
be
is a
the
major
truth,
risk
the
because
whole
you
truth,
got
and
sharp
nothing but
bone
the truth,
fragments
so
under
help
your
you
leg. So no, he
Thank you,
probably
ma'am.
kept
Please
his
have a
leg.
seat.
You break your femur though, it's dangerous.
First
Very,
thing I
very
will
dangerous.
ask you to do is to
Life-threatening.
state your first and last names for the record and then spell each.
Catrice Babias, KATRICEBABIASZ.
Yes. Mema saying, don't recall that witness.
Go ahead, your witness.
Good afternoon, Miss Babias.
Correct.
Yeah.
I'm surprised I got it right. What do you do for a living?
We'll talk about this in a
I
second,
am
Marie.
a law enforcement dispatch supervisor.
Yes. She's cute and woo.
And
Yeah.
how long have you been doing that now?
I've been in law enforcement for 16 years.
Guys, go look at it if you want to watch
The
it. You wanna
evening of
go fund me
November
for that.
21st, 2021. Were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas Parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn? Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What kind of gesture was
the
he
gesturing
doing? Show us, demonstrate.
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
Maybe.
For the record.
I'm hot. I'm hot. That's all he's trying to say, maybe.
Probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based
Objection.
on
She is not law enforcement.
what you were observing.
Objection.
The driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained is to the form of the question. Please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his
That's
way.
not law enforcement, though. She's not licensed. She's not sworn and carries a weapon. So that.
Back up.
He's churching it up.
Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Yeah, there you
seeing
go.
the driver?
You
I
fucking
looked
idiot.
the driver right in the eyes.
And how did the driver look?
The driver looked like through me.
What do you mean
like you had
through
1,000
you?
yards there.
Describe what you mean by through you.
Another great
I
witness.
feel that
Darrell.
it is very hard to explain that look, but it was very frightening.
Yes. Yes. Brilliant job, Darrell. Once again, bravo. Bravo.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the vehicle?
Hold on, I just need to make a record of she was also using her hands. That's okay. To indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Going back to the barricades, there was nowhere for him to go but driving over little fucking kids. The police made him do it. It's absolutely fucking ridiculous, Darrell. You Oh, God. This is a great example of what not to do, guys. What not to do.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
That almost got ran over by you acting like a lunatic. These people are not sympathetic to you, Darrell. I don't know what made you think this was going to turn out the way you thought it would.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes.
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
The Federales. All right. Nana, real quick, I don't mean to disparage, but for him to say you're in law enforcement, she's a dispatcher. She is part of the law enforcement team, but he's using that to try to church up her credentials and bolster her to make it sound like she's in law enforcement like a cop. He's intentionally trying to mislead people. That's all I meant. That's all I meant. We all do our jobs in life, and there's nothing to be ashamed of or to make fun of somebody about that. So,
at what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
So, my God in heaven. Why? Oh, no. There you go, Darrell. Use that.
Do you recall what date it was that you spoke with the FBI agents on?
Oh, God, this would be so funny if it wasn't serious.
A few days after.
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
What? I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
Jacob, this is a very fair thing. He just threw 13
red
names
sweatshirt?
Up.
It's possible.
He's also a different shirt.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
There you go. She just blew your gotcha up, Darrell. Marie, it does matter because if it was a couple of days, then they could claim she had seen pictures and that had ruined her idea of him. It's not really that's not a very effective in this situation because there's so much other evidence. But sometimes that can be important to say how long was it till you actually saw the police and had you seen the press in the meantime. So that's not the worst question he's asked by far. That said, though, geez, yes, he drove through that crowd with a 1,000-yard stare, and then she saw him disappear into another group of people. Woo! Yeah, this is beautiful work.
Do you recall?
Super lawyer right here.
Well, let me back up. Did you leave the parade at that point?
At what point?
After seeing the vehicle.
Yes.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
Oh, no. Good job, Darrell. Good job. Another brilliant
Doesn't make any
landmine.
sense. You talked to FBI agents a few days.
It doesn't make any sense because you're a fucking idiot.
To be fair, you said you didn't know. You said it was that week, is what you said. The same week. You spoke with FBI agents.
Dog
For no injury.
alert.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
I do not. I was not physically injured.
Oh, yeah, you're going to, show that. I dare you to try to do that to this community that's been absolutely traumatized, you asshole. This is not going to go the way you think it will. Don't do it. I'm pleading with you. You're
But you
not
didn't
going to
report this at any time whatsoever. Grounds.
Sustained.
grounds.
Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to the incident?
No, I did not.
Oh, don't act. Oh, yeah. That is not going to sell. You're like, well, that doesn't make no sense. Darrell, a lot of things in life don't make sense to you, honey. I bet a lot of things in life don't make sense to you. Like, why does 2 + 2 = 4? I don't get it. Why is ice cold, Darrell? You probably don't get that either. You know, a lot of shit I don't think you understand. You probably don't understand how they get the filling inside Pop-Tarts. You probably don't understand why people eat Pop-Tarts raw, uncooked, either. I mean, good God. Somebody was asking.
So today, your first time bringing up your alleged injury?
No, it is not.
Okay. Real quick, Richard Grubber, any chance it's the public defender's witness list? No, because the public defender would have gone out and interviewed these people ahead of time to know we don't want these people on our list. They would have had their own investigator, or they themselves would have interviewed
At some point,
these
you
people.
were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Yeah,
Do you
these are all
recall when you
prosecution
received
witnesses.
that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I contacted the victim witness advocate, Carrie Peterson.
Advocate? What does an advocate do? So you say, I've never heard of no advocate.
You contacted the Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
Okay.
Yeah, you used part of the prosecution's list. This was not the PD's list. Yeah, I think he thought there was something to gain here, but really,
You
this
ever
is beautiful.
spoke with anyone directly at the district attorney's office?
No, correction. Yes, when I walked in today, I met there and let them know I was here. And then they walked me into a room and I waited until I was called by you.
So before today, you had no interactions with anyone related to the district attorney's office besides I think you said victim advocate?
So the victim advocates who I've been in connection with and letting me know when to come and all of that.
That's because you can't communicate because you refuse to do the job and you act like you're helpless. So you've asked for their help.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
Would you
I believe, just
sustain
for the
that?
record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear, because since there's two tables.
What would be the reason for that?
Since there's two tables. of
She's
individuals, I
highlighting
think
that-
She wanted to make the witness aware.
She's only showing us
I
the
just wanted
three.
to point it out for the record since it happened.
I got him again.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
She's a dispatcher.
I have not been in a trial for law enforcement. No, I have not.
Dispatchers generally don't go to trial.
Never
You don't
witnessed
normally
a
call
trial,
them.
sat at a trial, been in a trial.
No, she's busy being a fucking
I have
dispatcher.
not.
You stupid fuck. You stupid fuck. They're
Have
like,
you ever
they're like, what is
testified
this?
in any way before today?
Objection asked and answered.
Overruled, you may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
What do you think you're gonna get out of this, man? They were trying to help clarify things for the record. What are you doing, Darrell? This isn't helping you. Nobody in the jury cares. You are not doing anything at all right now.
Back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes.
And why would you come to that conclusion?
Why would you ask this question? Why?
Because I saw an officer have to jump out of the way in order for
when it was approaching.
When it was
approaching.
Whoa. He's trying to testify
question
now.
was asked. This witness is going to be allowed to answer.
You have to accept that answer.
Without interruption. Go ahead and.
Got to accept the answer that you asked.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep. So I saw that an officer have to get out of the way, and he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
There, acceptable answer. Acceptable answer.
So what changed for the last question that you
Rose,
needed?
thank you for the memberships.
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
This doesn't help you, dude. You are fucking swinging and missing. Rob, I don't know, because he's a dumb fuck. Dumb motherfucker. Dumb fuck alert. Dumb fuck alert. Watch out, everybody. Here comes the dumb fuck. Here comes the dumb fuck. Jay Walker, no, the witness is at the mercy of the person asking the questions. She can't claim hostile interrogator. Yeah, that look. Oh yeah, so everybody's dumb but me. Wait, what do you mean? Like she killed the birds all over the house?
How did you
Others are all over the living room, but you don't know where the bird is.
come to the knowledge of
I'll
that
come
name?
look in a minute. Oh, I'm on.
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Yes, you received one from the
Those are both
state.
correct.
And
So you received two separate subpoenas?
yes,
Correct.
one from you, one from the prosecutor.
What
This
was
is
the difference between the two?
one was from
One
you.
was from the district attorney's office and one was from you.
Yes. Oh my God! You
So the one
Case
that you
dismissed.
received from the district attorney's office in July
they released you from it.
didn't have a case caption on it?
Okay, what's a case caption?
Oh my
Just
God.
1 second. One
Fucking
second.
Ricky Retardo. Ricky motherfucking Retardo.
The purpose of this trial.
There was no objection at first.
Doesn't matter. You can object now. You can object now. This is
The
insane.
objection under 906.11.
906.11, the XFM. Our good friend 906.11's back. Axing you.
I think
Ask a
you
question.
know where I was getting at with the question.
Then you need to ask your question directly, sir.
Because
Go
we
ahead.
know where you're going,
I'm
Darrell.
sustaining it as to the
Fucking
form
know.
of the question.
Where are you going? Fucking nowhere.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't
Yep, Rob, he's got him
contain
right where he wants him.
information to the case you were being subpoenaed for.
Objection relevance.
Grounds.
100% relevant.
Sustained. You don't have to answer that.
Yes, good.
I sustained the objection on that, those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection relevance.
Grounds.
Oh, sustained.
Yeah.
Grounds for the sustained. That
Not
was
relevant.
what? Mind-boggling.
Yes, to an absolute retard, it's mind-boggling. Yes. If you go wrong, go.
Sir, in
Yes,
July,
this is
when you
mind-boggling.
received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Yes, this case.
Grounds.
Sustained.
But it's irrelevant.
Not relevant.
She's testifying in the trial, and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
They released her from that subpoena. They released her from
called
that
her as a
subpoena,
witness.
you stupid
The subpoena
idiot.
the subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906.11.
No, she wasn't. She was
ask the
released from that
witness a
subpoena.
relevant
They told her you're not a
informative
witness
question.
anymore. They told her you're not a witness anymore. You don't have to be here. We're not going to use you.
Remind the jury that the statements of the
At
parties.
that point, the subpoena's
of the
undone.
attorneys Are not evidence.
Oh, fuck you, Darrell. Yeah, they done fucking me. They done fucking me. You're the one trying to shove
So
a
were you aware that it was a chance you would
bicycle up
be
your ass.
possibly testifying in this trial?
No, they released her.
Yes.
Then they released her.
And did you know who the trial was for?
Objection
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
think
Brooks,
that's- I think
I'm
that's very
sustaining the
relevant.
objection under 906.11, and I'm asking you to move on.
Yeah, keep axing, baby, and you get the axe. Mm. Oh, Jesus, Darrell. Dude, you're ruining my fucking Friday. It's a Friday afternoon. I should be, like, enjoying my life right now, not wanting to, like, go suck start a pistol.
Seems to me like a like a lot of your answers are coached. Is that fair to say?
Objection.
No.
Objection. Objection. Oh, I'd have objected to that shit. Argumentative.
So the subpoena that you got last week,
Oh, he's losing his voice or something.
is that how you learned the name that you used?
Objection
Grounds.
relevance for the same reason I argued before.
Grounds.
I hate this all.
Asked and
No.
answered.
Just you, Sheeple
She's
Hunter. Just you.
indicated the answer already. 906.11, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor
Straight up from
answered.
the nurse.
Under
Yeah,
906.11,
he's
please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and
That is
probative under
silly choking.
906.11, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the
That's not her job to
examination
tell you what's going to happen.
by you.
Ask a
to be
question
entered.
of this
It's not.
witness.
It's not an examination. It's direct.
It's a direct examination, sir.
Yes,
Under
it's
906.11,
cross-examination,
you're
direct
directed to ask a question,
examination.
Or I will
I
ask
heard,
the
I heard
state
you.
if they
I
have
heard
any
you, Your Honor.
questions.
I heard you. I heard you.
Get fucking
you.
to it.
Next question, please.
Today, Junior. Take that cock out of your mouth and get to work. Let's go. Let's go, baby. Come on. Pretend it's a rap video and you have to talk like a retard. Get that shit out like a machine gun. Come on.
No, the plaintiff is in this matter.
Yes,
Who's the plaintiff?
the state of Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Not relevant. Sustained.
ground.
Next question.
Have you ever had any interaction with the plaintiff?
Objection, vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the state of Wisconsin?
do not
I'm
answer
sorry,
that
that's
question. Next question, sir. Under 906.11.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
Under
Yeah, that
906.11, I
matters to
directed
you,
the
Darrell.
witness not to
That
answer
really
that
matters to
irrelevant
you, brother.
question. Ask your next question, sir.
Do it. Think y'all done doing a slick one on me. Oh, you're staring at them. Oh, yeah. Stare them down, Darrell. That's going to do it. They're going to give up now. Oh, no. He's staring at us. It's so scary.
Mr. Brooks.
Oh, whoa.
Ask your next question.
Bitch.
I'm going to get to it.
Thank you.
Oh, he getting mad. He getting mad, folks. We might get the taser today. Uh-oh. He's getting sad. He's going to start crying.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Guys, I would have already been sanctioned by the court if I was in there. So no, you don't want me to be
Grounds
prosecuted.
for
906.11. Sub 1, Sub A, Sub B, and Sub C.
is that lawful law?
All right.
Lawful.
You may sit down. Does the state have any questions for this witness?
Ah! Got him. Oh. Just bring up that she got released from the subpoena, guys. Make that clear. Because I don't think the jury's going to understand that. The subpoena was out, it was issued, and then we withdrew it because we didn't need to testify. Bring it up. At that point.
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overrule, the witness may answer.
Of course it's going to be overruled.
3 and 6.
And I don't know, Mr. Brooks hits it down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down.
No, you ain't going to tell him what to do. He's
Mr.
a
Brooks,
big
you're not
man.
asking the questions.
He don't
I'm
back
not saying
I
down.
would ask you to sit down, please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
Didn't do nothing. Didn't do nothing.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their question.
So how
Go
come when
ahead.
I did that,
Overrule,
it was
the witness may
Because you're an
answer.
idiot, Darrell. You weren't
I
doing
was
it right.
on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm gonna show
This
you
would be a
Mr.
very
Brooks,
safe bet,
this
sir.
Evidence is State's Exhibit 15.
Go ahead.
And I'd ask that the screen be cleared. And ma'am, does this show?
Wait until it's in the jury
I'm
box.
sorry.
I'm sorry. The jury would let me know when it's there. Thank you. It's there now. Go ahead.
Ma'am, do you see a purple line on that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you, I'm sorry, it's a touchscreen. I keep forgetting to say that. Touchscreens, just put a dot right where it is. Okay.
Maybe on the other side of that red line.
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were there were barricades that were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Okay.
Overruled.
Hearsay.
The witness may answer. It's not hearsay.
So when the red
Yeah,
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is correct.
Yes, hearsay. She's speaking as
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Ooh.
Mr. Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's because
Always
your objections suck.
Go ahead, you may answer me.
Sorry, there's a lot of talking. Your question was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes.
Okay, yes.
Thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
Overruled. The witness may answer. Go ahead.
Give me an answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
What a crybaby.
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
What?
Because she is a first-hand eyewitness.
Yeah.
I'm talking about you.
The objection is noted.
This
It's
is how leading
overruled.
works.
The question is proper, and the witness may answer.
Yes, my daughter was further in the roadway. We were all on the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was, no.
So she's going out to get some candy that had been thrown, I assume. correct?
Oh, no.
And,
Overruled. The witness's answer may stand.
and you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection. Speculative.
Overruled.
It's very possible.
Jesus, Darrell. Brilliant job calling this witness. Brilliant job. Brilliant job.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one was Ben, where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Overruled, the witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
This is
So
great.
going, and why don't you
Dri-
describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. Can you read the rest?
You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one at, I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
Yeah. What?
The report that the interview that was conducted with the FBI.
Yeah.
That was who did your interview, correct?
Yes.
Mhm. Where are we going with this, brother?
Why is it not in the report about the multiple officers that you say you saw attempting to stop the vehicle?
I don't know why
They
it
didn't
wasn't put
ask
in the
her about
report.
it?
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year,
It's only been 11 months.
I'm
Okay.
assuming that means that there's some details you don't quite recall all the way. That be fair to say?
Yes.
Still remembers her kid almost getting killed, though.
So it'd be fair to say that if there's details you don't recall, how can you recall the path of travel of the SUV that you claim you saw?
Can you rephrase the question?
She's not
I'm
going to
not
forget
understanding.
you killing a ton of people in front of her eyes.
I think it was clear, but I'll ask again.
What a fucking dick.
You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
She doesn't have to remember everything.
Justify what you just stated. Wouldn't it be fair to say that that's a possibility?
No.
She can remember parts of this and not
So
all of
you
it.
recall all the details of what you observed that evening, November 21st, 2021?
No.
The car killing people is a pretty obvious one to remember, Darrell. This is not. She's gonna drop that on you, so stop now while you're ahead. Don't or try to
So what
gotcha.
other details do you not recall?
Object. Yeah.
How does someone
Yeah.
recall the details that they don't recall?
You're proving a negative.
Sustained is to the form of the question.
Yeah.
Seems very funny.
Heading to sleep, American.
Seems
Well,
almost
good
as
night.
if you're recalling what you want to recall and purposely not
Objection. Badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness.
I was going to say that was just argumentative.
Next question.
You're not badgering.
Badger or argue. What do you mean?
She's not a badger. Just
Next
she's a human being. He doesn't know what badgering means. You're not allowed to bully a witness like
the
that.
witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
She doesn't look like a badger. She's a human being.
Under
How can I-
90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious, right?
Oh, she's 100% serious. man.
Intimidating the witness. What have I done to intimidate the witness?
The last question was badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling under 90611.
specifically
Please
said
ask a
intimidate.
question or
Yes.
I'm trying
I will
to merely-
stop the
How
questioning.
did I intimidate?
Keep
Under
moving along, you dumb
90611,
son of a bitch.
Sub 1, Sub A,
Gonna get axed, baby.
Sub B, and
She
Sub
gonna axe
C.
your
Ask
ass.
the next question or the questioning of this
Axe
witness will
that
end.
ass.
All right, you may
Just-
step down now.
Whoa! Chop,
Oh, man.
chop, chop. Oh, he's
This
getting.
must
Oh,
be all about the 62 trust, right?
oh, he's finally said it.
I'm
Full
going
sovereign
to.
citizen. Full sovereign
Um,
citizen.
You're done with
Full
testimony for
sovereign
today.
citizen.
Please do not begin your deliberations and discussion of the case until all the evidence is presented.
He
And
did
I
it.
have instructed
He
you
did
on the
it.
law.
He
Do
brought
not
up the
discuss
trust.
this case among yourselves or with anyone else.
You
until your
crazy
final
madman.
deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social
You're now
networking
listening to
sites
90611 The
to
Axe
send or
FM.
receive
Turn up
any
the radio.
information about this
Only
case
on
or your
Axe.
experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either
Oh,
in
he's
person
twitching.
or by any
He's getting mad. He's
electronic
gonna get big
means.
mad,
Do not
guys.
read any newspaper
Don't leave.
reports or
Don't
listen to
leave.
any
It's gonna
news
get
reports
good.
on radio, television,
His face is
over the
twitching.
internet, or
He's
any
gonna
other
he's gonna
electronic
bitch out real
application
hard.
tool about this trial.
He's gonna lose
Do not
it. Look at
consult
him. He's
dictionaries,
twitching.
computers, electronic applications,
He's
social
so
media,
mad.
the internet, or other
Oh,
reference
nobody
materials
talks to
for
big
additional
bad Darrell
information.
Brooks like
Do not
that.
seek information
No,
regarding the
he's a
public
blood,
records of any
yo.
party or witness
He
in
blood.
this case. Any
Blood.
information you obtain outside the courtroom could be misleading, inaccurate, or incomplete.
Fucking
Relying on this
lunatic. His
information
world's
is
collapsing.
unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
You're so mad. Well, here we go. Here we go. Here we go.
Call yourself a judge as much as
Put that mask on, you little crybaby.
tell the jury the truth.
Crybaby bitch.
Got no integrity whatsoever. None.
Hide under your security blanket, Darrell. You little bitch.
None.
Thank you, everyone. Please be seated.
Let's get ready, boys. Let's get ready, boys.
I would like an update on whether Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just know that.
Just know that.
She
Okay.
could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come.
I'm gonna laugh. She doesn't fucking show up.
That's simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm
I don't
directing you
know.
to have her
We
here
said
at
all
9
that. We said all that at the beginning, man. Like I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I need to make a record too.
You don't.
When
need
am
to-
I gonna get the chance to do that?
All right. I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make.
I'm
He
finna
hasn't
leave
sat
anyway,
down
so
for
you
the
can
better
hold
part
me
of
in
2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding
you
you
gotta
in
do is tell me
contempt.
if it's criminal or
Cry,
civil,
baby.
so I can hit
All
you
right.
with you.
I need to
what
clear
you
the
know is
courtroom because
coming.
I do need
I'm
to
gonna give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr.
Uh-oh.
Brooks, you're being
It ain't
taken
no
to the
Mr.
next
It ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to
Tacit
steal
agreements.
somebody's
Them tacit agreements. Oh, come on. Why'd you shut it off, TMJ? Oh, that's weak sauce. Okay. Well, everybody, that was fun, wasn't it? 800 people watching, guys. Thanks for stopping here. Anybody who's new in the meantime, my name's Sean Martin. I run Potentially Criminal. I am a defense attorney out of Cleveland, Ohio. And yeah, today I stayed home and we're doing this. It's been fun. I don't know. It's been a little rough. So go through some of the super chats and things people have asked so far. Sarah M for $9.99. Thank you for the super chat. Watching from Brazil, you are great. Well, thank you very much. I appreciate it. John Bubba says, gotta ask again because my phone messed up. Yesterday I asked if the death penalty was an option for the DA. No, Wisconsin has not had a death penalty for 1850s, 1853. So nope, he can only get life without parole. John Doerr, yeah, but here's the thing, Rob. Even if they did pass a new law, they couldn't make it retroactive because he was never sentenced properly. They'd have to go back and do like a sentencing phase for him. So no, you can't retroactively apply the death penalty. You can only apply going forwards, really. And if they tried, I think that would be very unconstitutional. Just a map nailed to the wall says, "Did you drop the clause as a sponsor? What kind of business is this?" I've had a couple of claws today. I need to kind of slow down a little bit. Marie Seiden says the kid could have lost his leg just by the tourniquet. A tourniquet's not fatal if you get to a hospital within a couple hours, and they're inside the continental United States in a major metropolitan area. They're well within the golden hour of medical care. So a tourniquet is actually a very critical part of wound care now and trauma care. We've learned that from 20 years of having warfare go on has spurned medical knowledge a lot. Tourniquets are critical, and they are very helpful life-saving devices. So that kid's 100% fine now. And by the way, before we get too far, I want to show this. That woman's family, they have a GoFundMe for the woman who her 4 kids were injured. Nick Ricada brought this up on his screen. They raised $15,000. I know we don't exactly have that many people here, but if you go to this GoFundMe for the Waukesha Parade tragedy, the Y family, and I'm gonna put the link up, and Parallax, if you're here, if you can pin it, that's fine. But I'm gonna put this link in the chat. You can donate if you want to donate. If you want to, great. If you don't, you don't. But this is a legitimate one to donate through. And yeah, go for it. So, okay. Oh, hold on. Did I miss something? I think someone super chatted. Yeah, hold on, guys. I'm trying to make sure I don't miss any. All right, we're back to Darrell being a little crybaby. Hold on.
We don't need a clerk per se.
We're back.
We just need to know that the audio visual is okay.
Oh, here we go. We're not done yet. They have to lay out the records, Eliza. So guys, stick around. It's going to be fun. Darrell's going to lose his mind tonight. We might get a Friday taser. We might get a taser shot for the week. Only I can pin links. Okay. All right. I got to figure this out then. All right. Hold on. Only I could pin a link. There could be only one. Actually, guys, I need to be right back. I will. 1 second.
Record to reflect that Mr. Brooks is in the adjacent courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once
Another
that
echo.
jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding
The GoFundMe's pinned,
objections.
guys.
I would just remind him that this was a witness he called. Therefore, it's proper and allowable under the law, under 906.11, sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called. Given his posture, given his staring,
This is in
given
the courtroom.
his
This is
pursing
not
of
me.
his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, That is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, irrelevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures that he did. That it was apparent to this court he did not like her testimony. And again, I'd remind everyone that it was his witness, and he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon the record specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write, English. Again, I may also refer back to the colloquy I had during the waiver of attorney.
Oh my God, come on.
Hearings.
Dude, don't do this to me. This is nonsense.
I will then ask him whether
I don't want to switch over right at the end, but I guess we're going to
I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects the defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004 Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146 Wisconsin 2nd 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 90611. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks. And I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
Yep.
We would not anticipate that as of right now, Your Honor, just so you know.
Oh,
the
no
timing.
rebuttal?
Thank you. I appreciate that. Because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. It's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes. With the hope of and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on
That Bible
Tuesday
can't save
morning.
you now, Darrell.
I anticipate that is going to be an incredibly lengthy process. We have been working, Madam Clerk has been working very hard.
We'll get to
on,
this bill.
Pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks. I do not anticipate getting done with sorry, I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Now.
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls.
Ooh.
And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
So just full of shit, Darrell.
Thank you. I appreciate it.
Lion ass Darrell Brooks.
I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of at this point on the topics that have been raised.
Yes, your turn, sweetheart. Let's go. Oh, they got him shackled up. Oh, no. They ain't fucking around with him no more. Ooh, he's in handcuffs. That's brilliant.
So is anything you wish to address before we break for the day?
He done fucked up.
Yeah, I wasn't really hearing everything that was just said good. But why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence.
You can't do that. It doesn't work, you dumbass.
That has yet to be done. I've put you on notice and I've stated it on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about?
You don't.
Whatever he was just talking about is in regards to
Erica. Whatever it was a lie.
Going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters.
Then go get the goddamn letters.
And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up.
Oh, it's all against everybody against Darrell.
You sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts evidence, ain't it?
Yeah, and your dumbass almost let it in.
That on record and not even be truthful about everything that you said.
Because it's not in front of the jury.
But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt.
Oh my God, bruh. Oh my God.
Why was the bond not addressed? Why was the statement of particulars not addressed?
Holy shit.
No filings that I seem to file need to be addressed.
Because they're all bullshit, Darrell.
After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, You accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel. And you accepted that. But you still turn around and continue to violate my Sixth Amendment right. Violate my First Amendment right by telling me what I can and can't say.
You don't have an unlimited right to speak in a courtroom.
Which I have the right to say whatever I want to say.
No,
and
you
to
don't.
Be heard.
No,
That's
you
the
don't.
First Amendment.
That's not how this works.
You sit up here talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option.
They are not. It's not a mutually exclusive list. It's not an exhaustive list. You can do outside
Then you try
of
to
that.
sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but it's awful funny that it never got mentioned before.
Because now it's talking about your issue of you testifying, which hasn't come up yet.
You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third.
Oh my God!
When you knew from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceedings. But yet still you choose to find a way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant, the name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction for the record. Have yet to show that you even have a license to practice law. Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence? The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair.
Keeping your face clean.
Being impartial. When the jury was selected, I struck the whole jury. That never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you.
No, you don't.
And the reason I'm muting him is
No, you
because
don't.
he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it
The
as a
hoe
rant.
jury.
He
All them
continues
hoes.
to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims
about
to
to be
be a
striked?
sovereign citizen, claims that have no base, that are baseless
How am I going to
in
get
law
striked?
and in fact. I'm not going to address them
Definitely
any
using
further.
this shit.
Again, they are simply baseless.
Oh, stricken.
And
Okay.
with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are on
9:30
recess.
a.m. on Monday morning for Eastern time. 9:30 Eastern. Guys, like I said, if Nick's doing it, I might be able to pop on a stream for a bit, but I'm not going to be able to do it myself. But let's finish up. We got some super chats and other questions to get through. Yeah, so the family that has the fundraiser going, guys, they're almost at $87,000. They were Nick's team, Nick and his crew raised like they put 15 G's in already. And the donations are going up and going up and going up. So guys, if you want to donate to this, I think it's a good, worthwhile cause. This is a good GoFundMe. I don't normally ever put these up because you never know who's doing what. But this is the family that one woman who talks about her one son almost lost his leg and almost bled to death. And then his other kids have chipped vertebrae, broken legs, and they're looking for some help to get through the hard times. So if you want to, give them some support, and I have the link pinned in the chat as well. Maria, we already talked about this with the FBI. Richard Gruber is saying, is this any chance the public defenders list? No, because like I said, they would have interviewed these witnesses and made sure that they didn't interview or bring them up. So they would have found all this stuff out. Eric Rollins for $5 says, yeah, I say he's going to prison. Yep. Dusty Storm for $4.99. Yep, thank you very much, Dusty. Eric Rollins says for $2, I bet this $2 he has no clue what 90611 is. Yeah. Eric Rollins for $5 says, the jury knows the truth. You drove a car in no parade. They know that thanks to your witnesses. Yes, they do. Becky Holea, I think is how you say it, for $19.99. Thank you. Thank you for the coverage of this case. As a defender of our Constitution and of the accused, I thank you for your honest opinions. It gives me hope. Well, thank you. Eric Rollins for $2 says, get Kim Potter to taser him. Ooh. Michael Leitner for $10. Thank you. Retainer for White Claw for you. Thank you. Miss Dinka Dinka says, is it in a case there's a tech issue with the video? Oh, why they have the court reporter? No. The record that goes to the Court of Appeals is the typed out thing. That's the official transcript. That is what is used when they review a case. Now, some states, they may allow the video stuff to get reviewed, but that typed transcript is what's considered the official record of what occurred. So, no, that other stuff is there just as a backups. But the primary one is what the reporter is going to be typing out. Now, let's say the reporter's machine dies, then yeah, they would probably make up the gap with what's there. But even then, it's somebody listening to it, listening to the recording and transcribing it. Bill saying, in Wisconsin, the jury determined the sentence was up to the judge. It's up to the judge. The judge determined sentencing. The murders, though, are life without parole automatically, so there's no issue there. Rob is saying, I have some of the filings that have been entered. Well, I know he has filings on the record, but he wants to try to admit his filings into evidence, and I don't think that's going to work too well, but we'll see. I mean, you guys are... Thanks, Arash. Yes, I'm doing fine. Okay. So yeah, that was a great time by Darrell. Yeah, I didn't expect all of that to happen. That was absolutely crazy. And it will be great for Darrell because now these witnesses are done. We're blowing through most of them. Got through almost everybody today. There's one left, his mom, which he makes it sound like might show up. And then it'll be him. And I'm sure there's going to be a big temper tantrum when he tries to take the stand himself. So that is really it. I thought there would be some fireworks today, but not as much as I anticipated. I mean, this is a pretty funny day. Very involved. Tina Priestler says he had Emily yelling today. It was crazy. Yeah, it was a rough day. He doesn't consent to me using that name. Well, he can fuck off. It's like he's going to do anything about it. Oh, I remember there was a comment, but I deleted it now. Somebody was saying that Cardinals wear. Well, I got to show this real quick. Somebody was saying, "Oh, Cardinals wear the Zucchetto." Yes, Cardinals wear this hat right here. That's a Zucchetto, yes. But Cardinals also wear the Biretta. That's what they also wear as well. So I'm trying to find one of these that's not obnoxiously expensive. So when Nick's wearing his mitre, I can wear one of these. But the Cardinals wear these as well. Just had to get that in before we end for the day. But that is it. Say that name again, Darrell Brooks. That is it for me tonight, guys. If you don't have any other questions, I think today was a great and interesting day. I'm sure tomorrow will be Monday will be even worse for Darrell. And yeah, it's just going to be great. It's going to get so much better. I'm sure if he takes a stand, he is going to lose his absolute mind. And then when he gets cross-examined, oh God, he is not going to like getting talked to like that. Thank you for the stream. I appreciate it. GoFundMe pulled it? What? No. Are you serious? No, GoFundMe still got it going, guys. I'm looking at it right now. Here. I'm watching it right now. They have $87,000. If anybody here donated, you guys are awesome. And I'll put the link up one more time. But yeah, it's still going. It is still there. So that should be it. Oh, I think Darrell for bail. Ah, I see. Yes. Denise saying, can you believe how today went? No, I can't believe. I've never seen anything like that ever happen where a judge has told someone, you're done. Your cross-examination is done. I'm cutting off your cases. I'm cutting off your direct examination. I've never seen that happen before. I don't think a lot of attorneys have ever seen this happen before. This is a unique event. Pretty crazy event too. Kenji Azia is saying he's not smart enough to vote the Fifth Amendment. Well, we'll find out. Miss Wee Lassie, I think I'm going to end with this. I think it's true. He is going to be raging when he gets back to his cell, knowing that was his last chance to get one over on his girlfriend and badger her and screw with her, and that'll never happen again, and that she never sends him letters, and she never takes his calls. And now he's impotent, and he can't do a damn thing to her. I'm sure he's going to lose his mind. Tina Priester says, can he invoke the Fifth on cross? No, you cannot do that. You cannot jump up there, give your spiel, and then say, I refuse to answer. You can't do that. It doesn't work that way. Does not work that way. You are not allowed to do that. If you give direct testimony, you have to be subjected to cross. You can't just do it one way. So, yeah, that's it, guys. I will see you guys Monday somewhere else. And in the meantime, have a very nice weekend. And remember, just because you did it doesn't mean you're guilty. And please, for the love of God, don't represent yourself, because this is the perfect example of what happens. Oh, crystal blue. That's a good idea. Go to a costume store.